Testing, testing, one, two, three. Testing, testing, one, two, three.
Palumo.
Like, what's on the website? As president.
No, he's with the commission.
Oh, okay.
He was part. He's who we had a
You think?
Yeah.
Buenos días. Aún no va a comenzar la audiencia. Vamos a tomar unas fotografías y luego comenzamos la audiencia.
We will be starting shortly. Please be seated. We are taking photographs and we'll be with you very soon. Thank you.
Cuando terminen las ponen.
para que de pronto los salude. ¿Listo, Du? Yeah, no worry. I'm gonna give some information and then we're gonna start. Ah, me parece una buena idea. ¿Listo? Muy buenos días nuevamente, señoras y señores. Vamos a dar inicio a este tercer.
Good morning, ladies and gentlemen. We are about to begin this third day of the hearing on the climate emergency and human rights, the request for an advisory opinion by the Republic of Chile and the Republic of Colombia. Please go back to your seats. Please do not place your personal items on the seat next to you so that more people can enter the room. We would remind those who will be speaking in the different panels today that you must come half an hour before the panel begins so you can be seated by the court officials. Also, the first rows of black chairs are reserved on my left for the delegations that will be speaking in the session, and on the right for the different delegations. And again, court officials will make sure the seating is done correctly. I would remind you that we are providing simultaneous interpretation services. You can request a receiver at the door to the room or use your own cell phone. In either case, do remember to keep the screen of the device open, because if the screen turns off, then the transmission will be interrupted. Finally, I would remind you that this hearing is being broadcast live over the court's social media. You can find the links in YouTube, English, Facebook, Spanish, on the website of the court. If you have any problem finding that, please talk to anyone from the Secretariat. We are here to help you. Ladies and gentlemen, please rise. The court is entering the chamber.
Muy buenos días
Good morning
a todas las personas que nos
to
acompañan
all those who are
presencialmente y a
with us
través de
here
nuestras redes sociales.
on site and over
Se
the
reabre esta audiencia
social
pública sobre la
media.
solicitud de
We are
opinión
reopening this
consultiva
public
presentada por la
hearing on
República
the
de
request for an
Chile y la
advisory
República de
opinion brought by the
Colombia
Republic of Chile and the
sobre los
Republic of
temas
Colombia
relacionados
to
con la
discuss
emergencia
issues
climática
involving the
que
climate
planteados
emergency
a esta Corte.
that they have
Esta audiencia,
submitted to the
como
court.
ustedes saben,
As you know, this hearing,
tercer día de sesiones de
this sitting is the
periodo
third day of our
de sesiones
166th regular
Escucharemos
session.
esta mañana
This morning
y tarde
and this afternoon,
un
we
total
will
de 10
hear a total of 10
intervenciones divididas en 4
interventions
bloques.
divided up
Cada
into
bloque
4 blocks.
seguido
Each block will be
de las
followed
preguntas de mis
by
colegas
a question and
jueces
answer
y
session
jueces.
by my colleagues, the judges.
Doy la más cordial bienvenida a todas
I
las
would like to
personas
welcome
comparecientes
all the people who will be
y
speaking
agradezco
before the
en nombre
court
del
today,
Comité
and on behalf of the
su
court, we
interés en
thank
este
you for
procedimiento.
taking an
Hoy
interest
nos
in this
distingue
process.
su presencia
Today, we
la
are
Secretaría
honored by the
del
presence
Principal of the West
of
Indies Cave
the principal of the West Indies Cave Hill Council, Carl Landis. It is a pleasure to have you here with us today. Also, the Provost, Chancellor, Dr. Antonios Hippolyte,
It's an honor to have you here. Y a las autoridades de la
and
universidad
the university authorities who were kind enough to join us in this session. Today is a special day. I will not be recognizing the registrar of the court, but the assistant registrar, Romina Sunienski, who today is wrapping up her final session with the court after 17 years of service. This is a token homage. We want her to lead this her final hearing. It's in recognition, Romina, for your extraordinary work and performance here in the court for so many years and for your many contributions to the Inter-American system. The judges are going to rise in honor of her, and we would ask the audience to do so as well and give her a round of applause.
Señora Secretaria Adjunta de la Corte,
Madam Assistant Registrar of the Court, I will now recognize you and ask you to give the instructions for this hearing. Please proceed, Romina. Thank you very much, Madam President. Good morning to everyone who is here. Thank you so much for this recognition. It's very moving for me. This morning, the following delegations will be appearing before the court: the Ruta del Clima Association, the Inter-American Association for the Defense of the Environment, the Central for International Environmental Law, the International Network for Economic, Social and Cultural Rights, and the Ruta del Clima Association. Number 3, the World Youth for Climate Justice. 4, Caribbean Environmental Law Unit of the Faculty of Law at Cave Hill. 1 Ocean Hub, Renew TT, GNHRE Caribbean Region, and ILA Caribbean Branch. Number 5, Elisa Fornale, Veronica Bilkova, Lawrence Bugord Larsen, Federica Cristani, Sara Devido, Curtis Dobler, and Anne Hertogen. Number 6, the Information Center on Private Companies and Human Rights, the Attorneys Collective Jose Rafael Recepo, CAJAR, Pax Christi International Program for Latin America and the Caribbean, the Environmental Committee in Defense of Life. Number 7, the Civil Association for Equality and Justice, ASIG, the Center for Legal and Social Studies, CELS, the Fundar Center for Analysis and Investigation and Research, the Center for Economic and Social Rights, and the Association Ruta del Clima. Number 8, Eulalia Petit de Gabriel and Iraida Jimenez. Number 9, the Association for the International Code of Conduct, the Arias Foundation for Peace and Human Progress, the Institute for Instruction on Sustainable Development, the Geneva Center for Governance of the Security Sector, the Legal Advisory Service of the El Bosque University, the Institute of Studies for Development and Peace, and other experts on the subject. And finally, number 10, we will hear from the Center for Gender and Refugee Studies, the International Refugee Assistance Project, the Global Center for Legal and Environmental Studies at the Elizabeth Hobbs School of Law of Pace University, Sir Arthur Lewis Institute of Social and Economic Studies of the University of the West Indies, the Americas Alliance, Refugees International, and Shana Tabak. I would ask those appearing before the court that in your oral submissions you express yourselves slowly and clearly in order to facilitate the work of the interpreters, and please respect the time limits that have been assigned. We would also ask you, when you begin your words, to tell the court the name of the person who will be taking the floor. That's all. Thank you, Madam President. Thank you, Madam Assistant Registrar. We will follow the order as established in advance. Therefore, we will now hear from the representatives of the Ruta del Clima, the Route of the Climate Association. Good morning. Ladies and gentlemen of the court, I'm speaking for the Central American Ruta del Clima. Loss and damage is the daily life of the community Toma del Agua of Chiquimula, Guatemala, who because of the drought are unable to grow their beans and rice to eat. They are the fishing women of the Colonia of Honduras who cannot fish because of the storms and have to go home without fish. Or the families of Cedeño Beach who are suffering from the tidal waves and are unable to fish. The Cahuita community and their national park, which is eroded by the rising sea levels, destroying biodiversity and jeopardizing their people and culture. It's the struggle of the communities of Puerto Rico that are experiencing the settlement and loss and damage, where exclusion and gentrification are taking advantage of their vulnerability. The community of Yuna Yala of Guajira, Colombia, who see their crops threatened by the adverse effects of climate change, the thousands of women who every day are facing hurricanes and drought, who live with hunger, with crop loss, and see that their ecosystems are degraded. They are victims of climate collapse, and they see the problem of child care in their communities and are victims of violence in this crisis. They are alone before the economic costs, so alone against the loss and damage. We've seen how, and we have visited communities in Guatemala, Honduras, El Salvador, Costa Rica, Panama, Puerto Rico, Colombia. We have heard and seen how their communities are fighting for their dignity given the loss and damage. Thank you for the privilege of being able to talk to these farmers, fisher folk, and leaders to talk about their daily lives. Loss and damage is the impact that people cannot bear or adapt to that cause irreparable damage or irreversible loss. Loss and damage may mean a loss of economic and non-economic factors of life, such as culture, traditions, languages, when they are forced to leave their homes in order to save their lives. Today, we are before the Inter-American Court of Human Rights to ask that you clearly delimit the legal obligations that the states hold, given the loss and damage caused by the adverse effects of climate change and in consideration of the human rights of the most vulnerable people of our region. Loss and damage have been caused by when the states violate their long-term obligations to prevent cross-border damage, respect and protect human rights. This international misconduct should force the states to provide reparations for mass violations of human rights for the loss and damage caused by state actions or omissions. Climate change is caused by the direct and indirect action of the effect of human activity. Economic actions that have released thousands of tons of greenhouse gases into the atmosphere, providing profits and benefits that are out of proportion for certain sectors, while having such an impact on vulnerable populations. Article 8 of the Paris Agreement reiterates the duty of the states to face damage and loss in harmony with the provisions of human rights and international law. The Human Rights Council recognizes that climate change is an existential threat and that the adverse effects of climate change have consequences for the effective enjoyment of human rights. The continuous production and increasing use of fossil fuels condemn all of us to suffer losses and damages that threaten our existence. The UNFCCC Article 1 recognizes that climate change causes changes to the physical environment and the biota, which has damaging effects to the composition and ability to recover, and on the function of socioeconomic systems. These devastating effects are what we reproach and report from our own territories. The adverse effects of climate change are the result of cross-border environmental damage. The International Court of Justice has recognized the general state obligation to guarantee that all activities under their jurisdiction and control would respect the environment of other states or other areas beyond their national control. This includes the obligation not to allow the use of their territory to cause damage to their residents or properties when there are serious consequences and the damage is verified convincingly. The principle of prevention, as the Inter-American Court has said, is the obligation of the states to take measures to prevent environmental damage before it occurs, including by adopting measures to reduce, limit, or control activities that could cause or create the risk of damage to the environment. The International Court of Justice has said that the principle of prevention is an international standard for environmental protection, especially considering the irreversible nature of environmental damage and the limitations of mechanisms for repairing damage. The states have the duty to protect the atmosphere in accordance with the Resolution 76-112 of the General Assembly of the United Nations. The interpreters are asking if you would slow down, please, and speak a bit slower. That warns against atmospheric degradation and its damaging effects to the environment and human systems. The states parties to the Framework Convention have the duty to take measures of precaution to anticipate, prevent, or reduce the causes of climate change and its adverse effects in accordance with Article 3.3 of the Convention, Human Rights and International Environmental Law. This duty explicitly calls for dealing with the serious or irreversible damage, taking comprehensive measures and policies that consider economic sectors and contexts. Article 2 of the Convention defines the responsibility for prevention, such as stabilizing concentration of greenhouse gases in the atmosphere that interferes with anthropogenic interference in the climate system. Stabilization must take place quickly enough for the ecosystems to adapt naturally to climate change and ensure that food production is not threatened so that economic can continue sustainably. But this has not been done. Atmospheric change has increased significantly over its levels of 1990. The IPCC, in its most recent report, expresses with high certainty that climate change caused by the human race has caused widespread adverse impacts and losses and damages associated with nature and people, even beyond the natural climate variability. And it is unquestionable that climate change has already altered human and natural systems. The Framework Convention, CCC, and the Paris Agreement establish the common but differential responsibility of the states to protect the climate system. The Convention says explicitly extends this responsibility to fight the adverse effects of climate change. Article 63.1 of the American Convention contains a common law provision on the responsibility of the states concerning the duty to redress and cease violation. The Inter-American Court of Human Rights has established that it is a principle of international law and also a general concept of law that every violation of an international obligation that has caused damage entails the duty to redress. We have the right to climate reparation. Repairing the damage caused by the violation of an international obligation consists of full restitution. This entails restoring the situation as it was before and repairing the consequences of the infraction. International environmental and climate law does not restrict or limit the responsibilities for repairing climate damage or deaths and loss. Instead, the principles and objectives of the Paris Agreement and the Framework Convention provide a basis for the pre-existing obligations of the states and include the fundamental obligation under human rights law to prevent and correct violations. To meet their obligations, the states must implement mechanisms to restore damage to restore the status to its earlier state, by including restoration, compensation, or payment of economic sanctions, and the financial instruments needed to support repair. This means transferring public financial resources from the largest emitters to pay for reparation for loss and damage. We note, however, against the commercialization of suffering caused by loss and damage and the transformation of victims into consumers of financial services. To close, the states, by means of paragraph 51 of Decision 1/COP21 that adopted by the Paris Agreement, have decided that loss and damage do not entail or make room for any form of legal or responsibility or indemnification, overlooking the principles of international law, making populations more vulnerable and exposing them to human rights violations. We would ask this court to outline the state responsibilities for loss and damage caused by violation of their obligations to prevent cross-border environmental damage and protect human rights, leading to the obligation to provide climate redress. All we ask for is justice. Thank you.
Thank you very much to the representatives of La Ruta del Clima for your participation in the hearing. And we now give the floor to the Inter-American Association for the Defense of the Environment, the Center for International Environmental Law, International Network for Economic, Social, and Cultural Rights, and the Association La Ruta del Clima. Please proceed. Good morning, Honorable Inter-American Court and distinguished members. I am Angelica Corredor. I am a young person from Colombia, and I am part of the Committee to Defend the Life and for the general community. I am here representing the International Network for Economic, Social, and Cultural Rights, integrated by over 280 organizations, social movements, and activists in the world. I appreciate the opportunity for addressing you on behalf of communities affected by the climate crisis in Latin America and especially Colombia, because this is a stage where we have to seek justice, safety, and ask for noxious actions to stop and integral or comprehensive reparations. We cannot accept the unacceptable consequences of damage to the environment. As a young person and in the midst of this environment, I am faced with confusing discourse by international leaders and politicians that do not take effective action to protect our communities that are suffering the impacts of climate change, while production and the use of fossil fuels continues, as well as agro-industrial deforestation. From our communities and villages, we say that the world cannot let you continue destroying rivers, trees, animals, just to get material richness and individual interests. The half of the world's population, that is the poorest, has not contributed to most of these emissions, and the rich part of the world is responsible for more than that. So what is the future, the quality of life of women, children, and those and the homeless that are facing the catastrophic events of the climate crisis based on a lack of capacity and strategies to resist to climate events that are the result of abuse of the agro-industrial actors and the fossil fuel industry, and mostly from the global north. As I've said, climate change has led to economic and non-economic damage and loss. In my own community, Saldaña, this small village does not have a sewage system, and so we have to use our water from wells. The depth of wells is growing. It's much more difficult for us to get our water, which is vital. This is caused by climate change and the intervention of mining companies that have made us more vulnerable in the past years. Extractive activities have changed the course of the river with less flow and impacting its biodiversity as well as our population. There's more erosion and particulate matter in the air we breathe, and we are now facing problems of food sovereignty with our crops contaminated. These are devastating effects for our community and the intrinsic value of nature. And it is not an isolated situation, not just in our territory. It is an X-ray of what is happening in all territories in Latin America. In January 2024, the Berlin highlands in Santander suffered damages after a wildfire that burnt down more than 200 hectares. We have several species that are important to regulate water production and availability. They need more than 50 to 100 years to grow and to just be 2 meters in height. In Colombia, climate has changed so much that we are now seeing events we had never had before. Hurricane Iota devastated San Andres Island. 80% of it suffered grave economic damages, and 100,000 and more inhabitants were damaged. There were losses in tourism, culture, heritage, mangroves, forests, and marine ecosystems. The country has also suffered from landslides after torrential rains, and this year the greatest disaster we've had was on January 12th. There was a landslide in Antioquia with at least 33 people dead and several vehicles swept away. Coastal erosion is also one of the clearest losses and damages after climate change. It is a consequence of rising sea levels, and it has led to changes in our cultural and social dynamics. With all this in mind, social movements, young people and women ask for justice and reparation for those who have caused these impacts, to take on their responsibilities and to stop their dangerous ways and to pay for the impacts we have suffered in our communities. We know that international negotiations on climate negate these types of reparations, and there's just voluntary funds that are seen more as a charity. And these types of funds do not allow us to get full reparation and the capacity to work at the necessary level. Although we do need resources, this is not enough. We have a right to comprehensive reparation, not just monetary payments, but restitution of lands to meet our basic needs and the guarantees of non-repetition. For 3 decades, climate negotiations have not provided reparations to the communities that have less influenced the current climate crisis and the ones that are suffering these damages the most. We call for justice and ask the court to make decisions to guarantee our full exercise of human rights, as well as urgent action to address loss and damages brought on by the crisis, and to ensure differentiated responsibilities are shown between the global north and global south, with a priority to individual and collective rights, and acknowledging those communities that have been affected as rights owners and having the right to full reparation. The law is clear, as the court itself has said, and as conventional international law states. When an international obligation is violated and there's damages, it should lead to comprehensive reparation. Thank you.
Thank you for your presentation. We will now hear from World Youth for Climate Justice. Please proceed. Honorable Court, Registrar of this Court, human rights cannot be respected or guaranteed within the context of a climate emergency if we do not first recognize that vulnerability to climate change goes up proportionally to the date of birth of each person. A child born in 2020, 4 years ago only, will suffer 7 heat waves more than someone who was born in 1960. Twice as many floods, droughts, and crop losses. What can we expect from the conditions in which people will find themselves who will born in future years, or the future that those born over the last 30 years can aspire to? My name is Mariana Campos, and together with my colleague Aditi Shiti, we represent World Youth for Climate Justice, an organization led by youth from around the world. It is a great honor to come before this court, and also it shows quite clearly the responsibility and the active role that we must take in the face of the climate emergency, because me being here as a student in this room, pleading for an habitable future for myself and future generations instead of being in a classroom, shows that we're walking down a path that is runs completely contrary to science. This reflects a burden that we are taking on to ensure a better future. And that is why I would like to help this court look at the obligations that are incumbent upon the states about children, youth, and future generations. First of all, I'll talk about the vulnerabilities and the the effects that these future generations and youth are liable to experience. And my colleague will talk about generational equity and the intertemporal dimension of these obligations. The science behind this climate emergency cannot be seen or understood if we do not put a face to the statistics. Scientific consensus shows us that GHG emissions will bring about irreversible changes that pose a threat to ecosystems, biodiversity, livelihoods, health, and the well-being of present and future generations. On the other hand, this court, in the judgment of the community of La Oroya versus Peru, paragraph 143, acknowledged that children are particularly hurt by climate change. First of all, for the way in which they experience its effects, and also because climate change will have an effect throughout their lives unless something is done about it. This was also seen in the case of Chiara Sacchi from Argentina and Catarina from Brazil, to name a few children that demanded major cuts in GHG emissions in their countries before the Committee on the Rights of the Child. We believe that a similar interpretation must be extended to the youth, and having youth between 18 and 30 years of age be seen as especially vulnerable to the climate emergency. And that is why this court has also recognized the need for reinforced protection for children. And youth are especially affected because they cannot realize their life plan in the same conditions as previous generations. And also, they are discriminated against as immature when they try to get involved in public affairs. What is shown through the growing criminalization of young defenders and activists. Although we cannot say that youth are just as vulnerable as children, but they must be considered more vulnerable than older generations. Finally, children and youth are those closer in time to future generations. So they have an important position in this transition towards an intergenerational type of thinking in the long term. States must acknowledge their right to be heard when they advocate for their own rights, and even when they advocate for the material interest of future generations to enjoy the same biological, natural, and cultural diversity, the same quality of environmental goods, and the same access to opportunities as previous generations. In view of the above, it is necessary for states to comply with their duties for respect and guarantee vis-a-vis current generations, especially children and youth, and also future generations whose material interest to live in dignity on this planet, it also involves our own interest to preserve our own species. I will now give the floor to my colleague, who will elaborate on intergenerational equity and the state's duty of prevention. Please speak slowly.
Honorable Judges, Madam President, Honorable Secretary of the Court, my name is Aditi Shetty from World Youth for Climate Justice, and I will speak in English. I will elaborate on 2 points. First, the intertemporal dimension of climate change and integration of intergenerational equity to achieve climate justice. Second, strengthening the preventive obligations of state to ensure a holistic and inclusive reading of the Inter-American jurisprudence in the context of climate change. The principle of intergenerational equity is at the heart of children, youth, and future generations centered approach to climate change, adaptation, and mitigation policies. This Honorable Court has given extensive recognition in La Oroya cases, and this not only marks the influence of the principle, but also the temporal dimension of climate change.
I'm sorry, please pause because we have a traduction problem. Can you wait, please? 2 of the judges are not listening to the translators.
Could you please just slow down? Could you please slow down? Just that's all that was requested of you, ma'am. Thank you.
Problema de comunicación.
Oh, okay. I can hear myself if I put it on. So.
Sí. Eso pasa en todas las películas. No los prueban los equipos, no nada. Y vienen a esto días antes, no prueban los equipos. Ya.
Thank you, Madam President. As I was saying, the principle of intergenerational equity not only marks its influence in La Oroya, but also the intertemporal dimension of climate change. To substantiate this, it is important to highlight that the Maastricht principles have also been considered in the case to protect future generations from climate change. In other recent cases, that is the Klimasystemen, the European Court tactically identified the positive duties of state to tackle proportional intergenerational burden sharing. The court recognized that it is necessary to avoid a disproportionate burden on future generations. Moreover, in the recent concurring opinion of La Oroya, it was noted that the principle of intergenerational equity is not isolated. The content of the right to environment cannot be reduced to reparation measures or policies adapted from that perspective. Under that logic, they will only have an impact on a short period, and therefore impacting a group of people in one generation. On the contrary, measures adopted from an environmental perspective must not lose sight of the fact that safeguarding the environmental goods will be inevitable and have an impact on generations in the short as well as the long term. Therefore, we respectfully submit that it is pertinent for the court to include the concept of intergenerational equity in its corpus juris, as it is essential to protecting not only children's rights but also protection of future generations in light of this climate emergency. Owing to the above, we also respectfully invite the court to consider the clear future-facing or intertemporal dimension of climate change, which is inherent in the protection of Article 19 of the Convention. And for this reason, states have a reinforced duty to protect children and future generations. Considering the serious challenges of the climate emergency, the burden will be inherited by the youngest amongst us, and therefore states must duly account for future harms that children, future generation, and youth will suffer. In this light, we respectfully submit to the court that the principle of intergenerational equity should also be systemically integrated and harmoniously interpreted with the relevant articles of the American Convention. In this advisory opinion, we again respectfully invite the court to identify the obligations that stem from an intergenerational reading of Article 26, 19, 4, and 5 of the American Convention in light of this intertemporal nature of the crisis. This Honorable Court has operationalized some of these aspects in the indigenous communities case, Suma vs. Nicaragua, and in terms of indigenous communities and their relation to land, and are not merely a matter of possession and production, but a material and spiritual element which they must fully enjoy, even to preserve their cultural legacy and transmit to future generations. Therefore, we contend that states have heightened and differentiated responsibilities within their positive obligations to protect these vulnerable groups from the adverse impacts of climate change and environmental degradation, and by that extension to have positive obligations towards future generations to effectively ensure that the world that they enter in is not in a catastrophe. Coming to my second point, which is also my last point, and moving on to the positive obligations of the states, the foreseeable harm due to climate change, which is irreversible, making this a climate change emergency, engenders a broad base of obligations which states must strive to mitigate, adapt, and hopefully even eliminate. This Honorable Court in AO 23 and the La Cajonette case has expressly pronounced itself on the right to a healthy environment in both its individual and collective dimensions. Importantly, owed to both present and future generations, which is connected to other rights and fundamental existence of humankind, thus expanding the interpretation of Article 4 and 5 of the American Convention in the context of environmental degradation. In AO 23, this court has observed the principle of prevention in the context of protection of human rights. It was noted that if it is not possible to restore the situation that existed before environmental damage occurred, prevention should be the main policy as regards to environmental protection. coming back and relying on the concurring opinion in Lahore again, the court has established that the human right to a healthy environment has been understood as a right with both individual and collective connotations. This collective dimension, in its collective dimension, the right to a healthy environment constitutes a universal interest owed to both present and future generations. And to conclude here, and in the interest of time, I recognize we submit.
Perdón, ya ha terminado su tiempo, tiene un minuto para.
You're out of time. All you have is 1 minute left.
To conclude here, we submit that states in their preventive obligations have a duty to ensure the protection of future generations from adverse impacts, and children and youth, being temporally closest to the adverse impacts, have a right to a healthy environment in the context of anthropogenic climate change. Strengthening this clarification of these positive obligations by taking preventing measures could help achieve climate justice. Thank you.
Muchas gracias al World Youth for Climate Justice.
Thank you, World Youth for Climate Justice. I will now recognize the Caribbean Environmental Law Unit of the Faculty of Law at Cave Hill, One Ocean Hub, Renew TT, GNHRE, Caribbean Region, and ILA Caribbean Branch. You have the floor.
Good morning, Madam President, judges of this honorable court. My name is Alana Lancaster, and it is my pleasure to make this intervention on behalf of the Amici representing the Caribbean Environmental Law Unit of the Faculty of Law at the University of the West Indies Cave Hill campus, the One Ocean Hub, Renew TT, and make to clarifying specific human rights standards for the conduct of states, both individually and collectively, which take into account the increased vulnerability of SIDS posed by the climate emergency. The Amici go to great pains to underscore that these states are experiencing the hardest, longest, and most disproportionate impacts of the climate emergency. Secondly, we will make some contributions with respect to human rights and the role the ocean plays in climate mitigation, a process known as the Ocean Climate Nexus. This is of particular importance as the vast majority of Caribbean SIDS are ocean-rich in nature. On average, the ocean under their control is 28 times their land mass. Caribbean SIDS are essentially large ocean states. To put this into perspective, the state of Barbados, where we are currently located, has an exclusive economic zone 388 times its land size, while Antigua and Barbuda's EEZ is 250 times its land size. The marine environment, including continental shelves and exclusive economic zones, therefore comprise the lion's share of the natural resource capital of SIDS. This latter point leads to the third and final focus of our intervention. That is the importance of the ocean to marginalized demographics and the principle of intergenerational equity for Latin America and the Caribbean in general. The region currently has the largest number of children and young people in the history of the region. Yet, the Amici note that there are increase in documented instances of human rights violations of frontline and coastal communities, defenders, women, indigenous and Afro-descendant peoples. Many of these impacts arise from climate responses which negatively impact marine ecosystems and biodiversity, as highlighted throughout our submission. Your Excellencies, there are 16 small island developing states in the Latin American region and Caribbean region, stretching from Bahamas in the north to Suriname in the southeast. SIDS will meet in just over a month to discuss and endorse the Antigua and Barbuda agenda for SIDS, which specifically emphasizes the ocean as critical to promoting sustainable ocean-based economies with the help of the international community. While the legal obligations that arise at the Ocean Climate Nexus are already under examination by the International Tribunal by the Law of the Sea, there is still scope for this court to clarify human rights standards with respect to connections between land and sea in the context of climate change. To this end, the court can further develop a harmonious interpretation of the law of the sea and international biodiversity law, together with international climate law and human rights law. Madam President, honorable justices, the human rights environment includes a healthy ocean, which, as illustrated by the Barbadian delegation, is essential for SIDS. This includes the role of the ocean in the protection of the human right to culture, children's human right to play, everyone's right to food, as outlined by Oxfam in their intervention, and the rights to life, health, and livelihoods. Importantly, this court's advisory opinion will allow for further clarification of the content and obligations arising from the human right to a healthy environment, already recognized as an autonomous right by this court in Advisory Opinion 2317, when addressing the threats to the marine environment of the wider Caribbean region. Excellencies, I also wish to underscore the necessity for alignment between both physical and biodiversity sciences, which illustrates the interdependence and interconnectivity between the climate system and the ocean, and the benefits of a healthy ocean to human well-being. This is another noteworthy feature of the Antigua and Barbuda agenda, and is critical for SIDS because their size and geographic characteristics make them integrated land-sea systems, which require collective management as a single unit under the concept of the rich-to-reef approach. This approach is important for comprehensive and effective management of the triple planetary crisis for all states in the wider Caribbean region. But, given their sizes and distinct characteristics, is of particular relevance for Latin America and the Caribbean 16 SIDS. This is because threats both on the landward and seaward sides of the coastal margins are concentrated. The amici have noted with satisfaction the court's endorsement of the rich-to-reef approach in Advisory Opinion 2317, and are pleased to highlight examples of state practice in consonance with the Paris Agreement's national determined contributions by Barbados in their Roof-to-Reefs program, as well as by other states in the Eastern Caribbean. Apart from their outstanding marine resources, Latin America and the Caribbean also possesses diverse coastal marine environments, known as blue and teal carbon ecosystems. Recognized since 2006 by the Intergovernmental Panel on Climate Change as important carbon sinks, these areas mediate interactions between land, sea, and estuarine systems. Blue and teal carbon are critical components of nature-based solutions and are increasingly important to both climate and biodiversity regimes. Additionally, they host ecological and ecosystemic functions linked to enhanced fisheries, other marine resources, coastal tourism, aquaculture and mariculture, which are all fundamental to Latin America and the Caribbean region. Notably, these ecosystems are also the basis of debt for nature regimes, which are currently underway in Barbados and Belize, and debt for climate regime as proposed by the Barbados, and support both the global biodiversity framework and Paris targets, while also providing a basis for more just and equitable approaches to ocean governance. As our slide summarizes, we have developed more detailed legal interpretations of state obligations in our written intervention on the basis of the arguments I have just outlined. Against this background, the amici wish to highlight these key points for the court's consideration. The need for systemic and evolutive interpretation of the applicable international law, which are supportive of human rights and the ocean climate nexus within the Inter-American region, as outlined in paragraph 25 of our submission. Secondly, the need to assess and prevent extraterritorial human rights impacts of climate measures on children and vulnerable people. This can be done by considering the lessons learned on human rights violations under the REDD+ process, and is critical to avoiding a repetition of past mistakes within ocean-based climate solutions. The inclusion of the precautionary approach and an ecosystem approach as encapsulated within the Rich to Reef approach, thereby supporting the indivisibility of human rights and nature, as argued during day 2 of these hearings. The incorporation of human rights in the design, implementation, financing, monitoring, and review of climate policies, plans, and actions, including the just transition. The latter is a critical aspect of both the ongoing negotiations on the international plastics instrument and the plastics regime, and is emphasized in the Antigua and Barbuda agenda for the blue economy. Finally, a further application of inter-American principles on the climate emergency and human rights, which are mutually supported by international biodiversity law, the law of the sea, and general international law on human rights, with particular attention on the latest clarification of the international law on the rights of the child in General Comment 26 on children's rights of the environment. We thank your excellencies and welcome any questions or comments on your submission. Gracias.
Muchas gracias por su participación y aportes a esta audiencia.
Thank you for your participation in this hearing, and I give the floor to the representation of Elisa Fornalé, Verónica Vilcova, Lawrence Burgog Larsens, Federica Cristani, Sara Devido, Curtis Döbler, and Anne Hertogen.
Distinguished members of the court, my name is Elisa Fornalé. I'm a professor at the University of Bern, and I'm really honored to appear before you for the oral pleading on behalf of our group of experts in this historic advisory proceeding. In an attempt to assist you in answering the momentous question before you, my aim is to focus on the role of international cooperation to address some of the protection challenges that concern in particular the impact of slow onset event. To this end, I will organize my oral pleading as follows. First, I will introduce a little bit how slow onset events affect access to human rights. And second, I will discuss how cooperative duty should be strengthened to ensure the protection of affected population in the short, medium, and long term. It is widely agreed that the cooperative duties are requested to comply with international human rights norms. Madam President, distinguished members of the court, I will now move on to the first part of my pleading, highlighting that slow onset events are long-term processes during which human rights are critically affected at different time points. As is illustrated by several UN special procedures, the reality is that slow onset events interfere with the ability of affected population to access and benefit for the human rights. And just to give you some example, in the last year, for instance, we have found that there are implications for economic, social rights, cultural rights, participatory rights, family and private life. And this creates unprecedented protection gaps. So exposure to slow onset event not only increase people vulnerability, but also increase the risk of exploitation. And we have seen also some cases at domestic level, for instance, that we have documented cases of trafficking and exploitation, new forms of modern slavery, in particular for people who are first to move. This means that affected populations are increasingly exposed to what some scholars refer as a slow violence, namely a violence that occurs gradually and postpones the structural power over space and time, and this in turn contributes to multiple intersecting inequalities. Here we face three challenges. Firstly, the use of a wide margin of appreciation by state to intervene to protect individuals under their jurisdiction. And this point has been in part addressed also by the most recent historic case, the Clima Signorini, by the European Court of Human Rights. And the court in this case confirmed the pressing need to ensure that the legal protection of human rights should be given priority when balancing between different, even competing interests. And second, and linking to this previous point, I would like also to refer to the issue that has been addressed yesterday, in particular yesterday afternoon, about the use of temporal notion, such as crisis or emergency, because this notion could also be used by state to justify limitation of human rights. However, human rights derogation, even if permitted, must be non-discriminatory, as well proportional, and in place for the shorter periods of time. As argued by Judge Charles Worth more than 20 years ago, the crisis model has a risk because these divert attention from providing long-term solutions focused on tackling the global and structural injustice that in our case are linked to environmental degradation. Third, this also could have an impact on the co-distribution of human rights duties among member states, because these reflect the discrepancies that we are seeing between what are perceived as the legal duties of the state that are not directly or less affected by climate change. So what is important to remind is that the ability of affected state to meet the human rights obligation needs to be maintained. To conclude my first point, this means that the distribution of obligation between states and the international community needs to be adjusted to the need of the most vulnerable population without compromising the stability on which international law depends. Now I will, Madam President and distinguished members of the court, I would like to move to the second point of my presentation, where I will stress the role of international cooperation in the context of law set event. Before that, allow me briefly to recall that the general obligation to cooperate is drawn generally from Article 1, Paragraph 3, 55 and 56 of the United Charter. And international cooperation really plays a central role in fostering interstate relations and stability. The centrality of international cooperation in the UN frameworks confirms that there is a general duties for states to engage with each other. International cooperation was also among the issues that received the widest support during the debate at the UN SIS committee in front of the General Assembly related to the topic of sea level rise and international law. So this principle we know is grounded in binding treaty obligation, but it has also been interpreted by international court and tribunal, and I remember very briefly, I recall also this court in its advisory opinion in 2017 concluded that the states have the obligation to cooperate in good faith to protect against environmental damage. This required to notify, consult, and negotiate in good faith. But I would like to stress in particular the last point, because cooperation between states could require to adopt new and legal and institutional framework through which cooperation could be achieved by contributing to the progress of human rights. International cooperation is commonly included in human rights treaties. Some instruments refer simply to a duty of international assistance and cooperation, but others also include in their definition the duty to seek to conclude agreement with other states for the fulfillment of their human rights obligation. So this is becoming increasingly critical, in particular, and I would like to focus a little bit more on the challenges that we are facing to translate human rights obligation in the context of climate migration, in the short and long term. Because as highlighted by the Sydney Declaration, the duty to cooperate requires states also to improve their effort to strengthen a coordinated measure that guarantee human mobility option at domestic, sub-regional, regional, and international level, which should be predictable and durable. In this context, to make cooperative duties effective over the longer term, states are required to develop human rights-based and gender-responsive bilateral regional agreement in the context of cross-border migration. Finally, to conclude my second point on the role of international cooperation, I will focus very briefly on the role of what we think is also emerging as critical, the role of interstitial norms and principles as defined by law for the protection of the environment and prevention of climate change. Because we believe that the interstitial norms also can play an active role when not only for interpreting international obligation, but also in trying to see how international obligation fit together. Because beyond setting out cooperative duties, it will be necessary to address the fact that the state will be faced with conflicting or competing obligation. For instance, we have seen in the context between economic development and the protection of the environment. So if we focus on climate migration, let me just briefly recall the emergence of the role of principle of good neighborliness, that these could also be used to support international cooperation by taking into consideration the geographical proximity between affected and less affected states. So this will allow protection to be met and also to facilitate human mobility between neighboring states. But at the same time, to prevent what is emerging as an issue of concern, and some scholars identify as the implementation of a so-called self-deportation strategy, which constitute a modern removal strategy of making migrant lives so unbearable that they will leave the country. So to conclude, I would like just to identify the following prominent issue that we suggested that the court could take under consideration in this advisory opinion for protecting the right of affected population. Recognize international cooperation as a legal obligation that applies to the obligation of the American Convention on Human Rights. Recognize the need for states to assume regulatory responsibility. And finally, to recognize also the role of interstitial norms to guide the state to overcome possible potential conflicts that could affect the primary responsibility to respect, protect, and fulfill the rights of affected population. Madam President, distinguished judges, this brings my submission to a close, and I would like to express my gratitude for your attention.
Muchísimas gracias por sus aportes a esta audiencia.
Thank you for your participation. Now we will go into the question and answer period for our colleagues. Judge Patricia Perez Goldberg, do you have any questions? Yes, Madam President. Thank you. Thank you for your presentations. They were very clear and very comprehensive. In the interest of time, I have only two questions. First of all, for Youth for Climate Justice. I'd like to ask you to elaborate on the pending advisory opinion on climate change that was requested to the International Court of Justice, and one of the points that was part of that request was that it elaborate on whether states have legal obligations based on the principle of intergenerational justice. What do you think this court has to add, or that is different, or that supplements that advisory opinion? That's my first question.
Judge, if I may in English, the current advisory opinion before the ICJ, as you rightly mentioned, it's intergenerational justice is one of the aspects of many obligations that are requested to be clarified. In terms of what can be added, as I mentioned previously in my submission, that it is well recognized, the principle is well recognized by this court, by international courts, or also by a lot of domestic courts around the world. However, there is some disconnect for it to be part of jus cogens, and then going into how to apply it within obligations. So that's the reason one of my submission was looking into the preventive obligations of states, because they can have positive as well as negative obligations. So the positive obligations in itself would say that because of the precautionary principle, because of sustainable development, because of preventive measures that states need to take, within that, I think there could be an addition through that clarification and an explicit analysis or an explicit analysis by this court would be like a stepping stone to that. Not only that advisory opinion, I think other regional domestic, or other regional courts and also domestic litigation cases if they come into the future.
Thank you very much. Una segunda pregunta a la
I have another question for Professor Lancaster. I'd like for you to elaborate on the following. You talked about the supplementary nature of a contribution, similarly to this question, as to what we could contribute to supplement the advisory opinion pending before the International Tribunal for the Law of the Sea. I'd like for you to elaborate on that specific consideration you made about the key issue of subsistence for SIDS, and how this court could add to that or do something different from that advisory opinion that is still pending before that tribunal.
Thank you. First of all, I think that the basis of the court's advisory opinion as coming from a human rights perspective will, by that very nature, add to an advisory opinion which will be primarily through the lens of Part 12 of the Law of the Sea Convention with respect to the climate change. And to some extent, that opinion will be, I don't want to say limited, but within that scope. One of the things that this court can offer, and they have already identified the principles, is linking the importance of the right to a healthy environment with many of the rights under the Protocol of San Salvador, for example, some of which have already been espoused by the Human Rights Committee, for example, in the Torres Straits Islanders. But within the Protocol of San Salvador, I think there's a more fundamental basis. It will also align with previous as well as more recent jurisprudence of the court. And one of the things that we note is that the relationship between human rights and the marine or coastal environment is not as strong in the marine environment as is in the coastal environment. And I think the courts, in both the advisory opinion 23 as well as recent Laurel, for instance, as well as the Mosquito Divers case, have developed a set of principles as well as a clear direction in that the marine environment is as important, if not more important, for states such as especially the small island development states, who really and truly this is their main annuity, if you want to say it, in the future. Thank you.
Thank you very much. No tengo más preguntas.
Thank you. I have no further questions.
Thank you. Judge Gomez. Yes. I will begin with the end.
So, Professor Fornalé, thank you very much for the intervention. On behalf of such a prestigious group of scholars, what caught my attention is you devoted a lot of time of your intervention on the issue of international cooperation and the policies of good neighboring. Do you think that's the approach for the sort of damage that we're talking about? International cooperation, good neighbor? You've been here, you've been listening for the last 2 days. Is that the right approach? I was surprised because you devoted a lot of time of your intervention on that. So.
Thank you a lot. Honored Judge, I would like to elaborate a little bit on the reason why I included this attention on cooperation, because I'm also involved in the work of the International Law Association on Sea Level Rise and international law, and we identify this as an emerging principle that needs to be developed more, because this was also the request from the member state. As I mentioned before, the member states submitted several statements where they ask, for instance, the International Law Commission on Sea Level Rise and international law to clarify the content of the duty to cooperate in relation to the protection of affected population. And why I included the good neighborhood is because we have these new bilateral treaties adopted between Tuvalu and Australia, and they decided to adopt this bilateral agreement under the principle of good neighboring. So I found that maybe this is a principle that was not under the radar in this specific context, but they decide to develop more what they call climate cooperation, to ensure that there are regular pathways for migrants that decide to move from Tuvalu to Australia. So I think that maybe could be a possibility to explore more, because it's true that we tend to focus on the good neighborhood as a principle that requires states to abstain, but maybe we can also see this as a proactive principle to increase cooperation. I think my focus was mainly really related to human mobility in this context.
But you mentioned it also when you were talking about climate migration.
Yeah.
You were talking about good neighboring. Aren't we lowering the standards?
I'm not sure.
Okay. No, it was a question because, you were talking about climate migration and to what degree, we're confronting forced displacements and people that have to cross borders. No, but I think you've answered on your perspectives. Just call my attention because also the term has been used through history, different contexts. It doesn't have such great press. That's why. All right. But let's move from cooperation and good neighboring, and let's go to responsibility. If there were responsibility, moving from your, paradigm of cooperation and good neighboring, how would you identify victims and establish reparations in cases, for instance, let's talk about sea level rise. We have distinguished delegation from the Caribbean here that are interested in that. So how would you do it?
You mean in case that cooperation is not implemented? In
case in which if you were talking about responsibility, not just cooperation.
I think it's depend. I identify in the moment where, for instance, there is a violation of human rights of affected population, and again, my focus was mainly in the case when people are forced to move. So it depends if this kind of violation occur, for instance, in relation to different kind of duties. It can be the duties to prevent or the duties to protect or to fulfill their human rights. So it depends when we talk about the people affected by sea level rise. There are different situations in place. So it depends if it will be the state under which they are, under which jurisdiction they are, or if it will be a state in transit that we can identify as a transit state of the country of origin. I think there are different spectrum of options there. For this, I talk also about the issues of distribution of duties and responsibilities, because there are more states that need to be considered in this process. So I think it's the complexity of the issue when we talk about sea level rise is this, from my perspective.
Thank you very much. I have another question for Professor Lancaster Salmon. Thank you very much for appearing and for the Caribbean group. You were very eloquent when you were talking about the need to have harmonious interpretation of different legal, I don't want to call them systems, but groups of rules. And you mentioned law of the sea, international biodiversity laws, environmental law, and human rights law. It's been a theme. We've been talking about this the last 2 days. But if you could talk a little bit more about this. How do we achieve the objective of harmonious interpretation? We're putting all of these elements together. Especially because nobody has, straight, absolute, clear jurisdiction to apply all of them at the same time. So, yes,
Thank you. I think one of the starting places with respect to states in the wider Caribbean region is to perhaps tease out these elements in existing obligations which states have, specifically with respect to the marine environment. I'm thinking of the Cartagena Convention for the wider Caribbean region, which incorporates many of the elements, and because of the nature of the instrument, the scope and objective of the instrument also clearly aligns with, for example, this Convention on Biological Diversity, which has developed impressive framework, which is in respect to the role of international biodiversity law, the ocean, and human rights, including with indigenous peoples and also Afro-descendant communities. However, and further, I don't think many of what is perhaps the new lens is the human rights lens, because in many respects, states have committed on the various paradigms. So, for example, the Sustainable Development Goals. Most states in the region have endorsed these. They've endorsed the Paris Agreement. The Sustainable Development Goals require the alignment of Sustainable Development Goals 14, 15, and 13, which are climate action, life on land and life on water. And most importantly, there have been linkages with Sustainable Development Goal 16, which is where I see for states to give homage to this, they need to strengthen human rights in various areas across their legal regimes, for example, business and human rights. Of that.
Okay, because yesterday some very prestigious jurists had lots of doubts. If you had an object of protection that was marine life or, species other than our species, and they were looking at human rights on the one side and environmental law on the other side, and separate because they have a different object of protection, let's say. But at the same time, to have the entire view, it looks like you're asking for a harmonious interpretation, where we have objects of protection that, in theory, when these rules were approved, were different. But it looks like now we have to consider them together.
Yes, I would say so. I think we are in an era where there's been a substantial paradigm shift, our understanding of the science, both climate science as well as biodiversity science. In addition to, I think when many of the early international law instruments, for example, were developed, they were developed in isolation of the social and basically the economic, social, and cultural aspects. In many respects, in the earlier days of conservation, we were concerned with ecosystems. We were concerned about balancing many ecosystems and economics. I think somewhere within that framework, the human element got lost. And it is critical. A lot of what we're here, the climate emergency, oceans. The human element is both the bridge, which we're trying to safeguard, but also the person, the entity that is.
Let me see if I understand you. It's very difficult to talk about biodiversity without understanding that our species is also affected by the lack of biodiversity,
Yes,
and therefore should be part of the legal framework.
Yes.
Thank you. Thank you very much for that. La última, señora Presidenta, prometo.
Last question, Madam President, for the association Ruta del Clima, the Climate Route Association. You spoke about reparations. How can how can the pecuniary, non-pecuniary damage be calculated in climate change cases with the types of progressive impact we see, and also the tipping points? We've talked about that. Thank you, Your Honor. With respect to the economic impacts, I think it's much simpler to do. There are methodologies on risk management that are in general use. What we do not have are systems for national monitoring to quantify the figures. For example, in cases of slow movement, slow evolution, there is a serious lack of data. There is also a serious lack of parameters, standardized parameters for monitoring these things. Science exists, it's out there, but the states, and this is part of the historic development of the Framework Convention, this issue simply has not been developed, and so far the states, for example in Panama, they are developing a system for monitoring loss and damage with 16 indicators. So there are countries doing it. With non-economic damage and losses, the states are starting to develop mechanisms to figure it out, but this is something being developed only now. What's missing is demand. The states have not established mechanisms for reparations requiring data of this kind. Good. Since you have these associations have similar names, so maybe you could also answer about in your submission, oral submission, you made reference to the types of funds, the voluntary funds that already exist for reparations. What can be done, even beyond the currently existing funds? You were very emphatic about this. The UNFCCC framework. Is it enough? What paths could be followed? What avenues could be taken to create reparation funds? Initially, I think it would be necessary to ask the states that are most rigorous with these funds. The communities are suffering the impact of the climate crisis, and the way to redress is not through a voluntary fund. The state or the international corporations decide whether or not they want to help with the redress, to repair the damage they caused, or simply not to, or not to help the community. We need to be more demanding. And we need to regulate so that these funds become mandatory and not optional, voluntary. Human rights cannot be violated by the states.
May it please the Court, Nikki Reich with the Center for International Environmental Law. Just to add to a few points with regard to the Loss and Damage Fund that's been established just at COP28 under the UNFCCC. A few initial remarks about the inadequacy of the fund, and then in fact it hasn't actually been set up to provide reparations at all, and would not result in the required support and redress needed, which goes far beyond monetary considerations, even if it were adequately funded, which it hasn't been yet. There is no reference to human rights at all in the substantive provisions of the fund, only a reference in the preamble. And there's also extremely limited participation on the part of Indigenous peoples, communities affected. They are not part of the board of this fund, and they have very limited access to and participation, as we've recently witnessed in a first meeting. There's also no mention of common but differentiated responsibilities, and there has been a consistent and concerted attempt in the language regarding that fund to de-link it from the basis for legal responsibility, echoing what we've seen before in the negotiations and attempts in the adoption of the Paris Agreement to include language that suggests it provides no basis for compensation or reparation. But that underscores really the importance and opportunity that this honorable court has to reinforce the very clear and strong basis in law for the right to remedy and reparation in the face of evident, manifest and mounting damages and violations of long-standing and pre-existing legal obligations to prevent transboundary harm and to protect human rights. And that the law is indeed clear, as my colleague said, that both under conventional and customary law, under the American Convention, as this honorable court has said, when there is a breach of an international obligation that has caused damage, that entails a duty to make full reparation.
We understand that.
Yes.
If the fund doesn't consider common and differentiated responsibilities, if human rights is not a parameter, and if there is no participation of afflicted communities, what does it do? What does it do? What does it cover?
Respectfully, Your Honor, I think in many ways the jury is out on whether it will and what it will cover. And I will turn to my colleague to complete and come back, if possible, with the court's permission.
Señora jueza, el fondo
Your Honor, the fund mainly handles the financing gaps for loss and damages. It provides financing for loans and grants. But most of the issue of loss and damage is not covered by the fund. Instead, financing mechanisms cover it. And these are international banking entities that need to provide funding by means of loans and other mechanisms. This is why we have warned that when victims become consumers of financial services, because that's the main structure of this fund for loss and damage, and the financial mechanism, which is the substantive part of what was created in COP27 and COP28.
If I may, just to add as well that, as my colleague has alluded, and as this honorable court's jurisprudence recognizes, that reparation takes many different forms and encompasses critically beyond just compensation, guarantees of non-recurrence, and there's as well as other forms of restitution. And the fund that's been created does not address those full dimensions of what reparation requires and entails. But in fact, as we've heard throughout the hearings to date, the conduct that is within the control and jurisdiction of states can and should be regulated and affected to prevent recurrence, including one of the best ways to ensure non-recurrence is to phase out fossil fuels and other conduct that is driving a loss and damage.
Understood. We're just talking about the fund. Thank you. Thank you very much.
Gracias, jueza Gómez.
Thank you.
Thank you, Judge Gomez. Judge Perez Manrique, do you have questions? Yes. Along the same lines, about the fund. The second group of speakers, where you also have La Ruta del Clima. In their written submissions, you refer to the fact that the way the fund is constructed or constituted might contribute to structural violence in our countries. If you could please elaborate, what are the risks? You have somehow already alluded to this, but if you could please give more detail, how this fund as it is constituted might become a factor for an increase in structural violence in the region. Thank you. Thank you very much, Judge. One of the main objectives or mechanisms the fund has it can provide non-reimbursable funds, but the real approach is as loans, insurances, and other financial mechanisms. Separately, when you have the fund and you have the financing mechanisms. The mandate under Article 8 is relegated to the financing mechanism. So when we see there's a vulnerable community such as Puerto Rico, Costa Rica, where you already have risk indices created related to people's credit ratings or records, the exposure you have to climate risk makes you more vulnerable. Depending on where you live, it affects your credit rating. So in terms of access to financing and to be able to move around, it's important to consider. And then Latin America is one of the regions that is most indebted, and those suffering most are, again, vulnerable communities. And in this case, it's just a transfer. The common but differentiated responsibilities are not assumed by the large emitters. It's actually taken on by the countries and the main affected. So they have to bear the cost of getting insurance, taking out a loan to be able to face the loss and damages, whether through local governments or an emergency committee, or directly themselves. And that is the game that will lead to more violence and more inequality, because we're adding pressure to the economic game we already have to play in our communities. So then you hold that the fund has one single way of contribution, which is financing, and financing comes at a cost. Indeed, financing, first of all, is provided by donors, and generally these are developed countries. Although these can be non-reimbursable funds, it is designed for it to be used by financial institutions such as the World Bank, the Inter-American Bank, who have the purpose of loaning money or creating mechanisms, bonds, or financial services in the end. And that's not the logic of a person that has suffered a violation of human rights because of cross-boundary damage. It's not the duty of that person to get insured or take out a loan. It should be by the state. And that's the logic we are seeing in this fund. And obviously there's no obligation to even provide any type of funding to the fund, or even the financial institutions that also depend on financing that, again, is decided by developed countries such as the World Bank. Could you be more specific within this regime and how the fund would work, how that would lead to more structural violence? It would be because of the activity of the fund and how it's deployed?
And thank you for the question. One of the fundamental ways that the fund, as it is currently constructed, risks reinforcing structural violence is that in its failure and explicit attempt to delink funding from legal obligation, it risks blocking access to justice. And it cannot and should not be used as an excuse to prevent communities and individuals affected from accessing justice at the national level or the regional level, or otherwise seeking to hold states accountable to their legal responsibilities. Indeed, it cannot and should not be used as an excuse for states in this region not to demand what is legally owed under international law. And it's also critical that the lack of participation on the part of affected peoples and communities in the fund restricts its ability to respond to the various types of material and non-material harm that is being caused by climate change. This goes to the question around calculation. I think it is critical that people victims of climate harm are self-identifying and are able to describe what needs to be repaired. And there is a lack of access and ability to do that in the fund as it is currently constructed. But that is also why it is such an opportunity for this court to reinforce that nothing about this mechanism displaces the existing obligation under human rights law and longstanding law of state responsibility and international environmental law, and the clear duties to provide reparation when states have, through their acts and omissions over time, contributed to evident climate harm. It also, just on the financing issue, that there is, whether or not this fund exists, the right to reparation and remedy exists under law and persists alongside this and needs to take many forms. And currently, the levels of financing that have been committed are nowhere near at the scale of the mounting loss and damage being witnessed around the world. I believe my colleague wanted to add something.
10 segundos. La razón de por qué existe.
The reason why the fund exists is because there's a textual statement saying that talking about the non-responsibility of loss and damages. This is this decision of COP21, and so that alternative created is where you have structural violence. It was a decision of states in interpreting the Paris Agreement with a non-binding decision because it expressly does not want to create a reparation mechanism. It is stated explicitly so in the Paris Agreement. And so this is the alternative solution that has been created because of that political decision. Thank you very much. You've given good examples of how to relate the situation of the fund and structural violence. Thank you. I would now like to ask World Youth. You've given a clear presentation as to what future generations are concerned about. And when we talk about future generations, it's children, young people, up to a certain age. So the question is, there's another dimension of future generations, the people yet to be born, people that are not here today in the planet. And even before being born, they are already affected by this phenomenon. So I'd like to hear your thoughts on that. Thank you for the question, Your Honor. We would like to make a distinction between the concepts developed by the court in terms of the people yet to be born and future generations. We believe that future generations as a concept are objects to rights. They are right bearers. So present generations, particularly states, have the duty to protect the future rights they will have once they are here. Very specifically, I'd like to highlight this court's opinion or criterion on the connection of the rights of the child, as we also mentioned during our submission, youth, with future generations. Because by protecting the rights of children and youth, we are protecting the rights of future generations, trying to preserve the same quality of planet and natural resources and cultural resources that we have today. Thank you. So let's talk about the future generations as you have conceptualized. What are the main issues and what could the court contribute to in terms of standards? Thinking about participation of future generations. We know there's the issue of representation, of determining harm or damage, to be able to demand protection, etc. But I'd like to know your thoughts, please.
Thank you for the question. As for, if just to repeat it so that I know I've understood it correctly, is that what you asked, what standards need to be observed, right?
Respecto de la participación.
Regarding the participation of future generations, the right to participate.
As my colleague mentioned earlier, children and youth are the nearest to understanding how climate change will affect them. And that's the reason why youth and children have a better or sort of a foreseeable understanding of how this would affect. She said that, she also mentioned that the date of their birth will then determine how much they're going to be affected. So just in that sense, I think allowing youth and children to have that standing for them would be one of the standards. And just to mention, and just to go a little bit further into that, I think in the case of Opusa versus Factoran, the Filipino Supreme Court actually lowered that and allowed minors to talk in the interest of future generations. So that perhaps could be one of the standards. However, within the obligation of preventing and within the positive obligations, states could also enable certain measures that have a forward-looking climate policy, climate environmental policy, in a way of ensuring that the interests of future generations are protected. And I hope that answers your question, and I'll pass it on to my colleague.
Just to add to that, and thank you for the question, Article 19, I think, also contemplates participation of children in matters that affect them. I think there is nothing that affects them most than the climate emergency. So in this sense, there's no need for material damages to exist already for children to request or participate on behalf of future generations for states to take action to guarantee and respect the future rights of future generations. Thank you very much. To Caribbean environment. First, in your observations, you have, in paragraph 87, referred to the fact that it is necessary for states, or that states could design effective programs to integrate environmental democracy in the pursuit of stronger children or strengthening children's rights. So could you please elaborate?
Sorry, just give me a moment to confer.
Lo tengo marcado como párrafo 87.
I have it under paragraph 87.
I will ask my colleague to expound on this.
Good morning, honorable judges. My name is Elisa Morgera. I'm the director of the One Ocean Hub, and I've worked with colleagues at the University of West Indies for 5 years on these questions. I think our arguments on intergenerational equity very much build on what our colleagues have mentioned around the importance of existing legally binding obligation on children's rights, and also building on specific regional instruments such as the Cartagena Convention and the Escazú Agreement. And I think there are 2 points here to keep in mind. I mean, one is even clearer indications around the interpretation of children's participation in any processes that may affect their rights, which have been illustrated in the general comment, number 26. But additionally, I think that point that's mentioned in paragraph 87 around distributive effects can lead to another consideration in terms of participation and representation of children's rights and, in fact, future generations. And that has to do with the temporal element and the science we can rely upon to understand what those distributive effects might be. The Convention on the Rights of the Child is very clear that states have obligation to consider impacts on the life course of children, and that really means multiple decades, 50 and more. And we have science showing us now what are the vulnerabilities of children, and particularly how those vulnerabilities clarify state obligations in terms of protecting children's rights to life, survival, and development. And I think children's right to development and its interaction with children's health and children's cultures can provide a crucial element in identifying both relevant either medical or other scientific evidence that can clarify today what those distributive effects might be, and then shed light on the obligations of states, but also institutions where those decisions are being taken to consider that science and engage children in understanding what that science means to them and to their own perspectives of life and their agency in co-shaping the future solutions and immediate solutions to climate change.
I understand your explanation perfectly. The question is what standards would help us truly bring into effect this democracy and strengthen, as you've said in your amicus, the participation of children.
Two substantive rights. One is children's rights to be heard, which has both procedural and substantive obligations for states. And the second is children's rights to development, which really provides the understanding of temporal vulnerability and extends, I think what we suggested in our written intervention, it can really shape the understanding of prevention and precaution in terms of vulnerabilities, time spans, and legal standards of protection.
Bien.
Thank you.
Finally, I listened with great interest to all submissions. And in the case of the presentation by Elisa Fornalé, I have taken a few notes, and according to my notes, in your presentation, you employed a principle that I would like you to elaborate upon. You referred to the principle of indubio pro futures generationibus, meaning pro in favor. When in doubt, the law should be interpreted according to the rights of future generations. That's how I see it. But I would like for you to elaborate on that, because it will be important for the court. It's an important concept that you are bringing forth and developing yourselves.
Yeah, this is a little bit a suggestion that we try to elaborate, because we realize the increasing role that the principle pro natura is playing, in particular in the context of Latin America, and we wanted to try to see if we can expand a little bit the impact of this principle, bringing into the context also the role of intergenerational equity. So we wanted to understand if the protection protection of nature could also mean that these, together with the precautionary principle, could include also the ensures that we can protect the present and future generation. So we suggested to go a little bit further, not only to focus on the Pro Natura that has mainly this role also as an interpretative tool to favor the protection of the environment, including human and non-human. But in our elaboration, we would like to take a step further to include also this intertemporal dimension. So for this, we suggested to shift the Procardo from Pro Natura to Pro Futuribus Generationibus. So this is really a suggestion that we wanted to bring to your attention.
Well, I have taken note of it, at least. And could you please explain how it would work? How do you envision it working? Because you came with a proposal, so we would like to see
that there is, even if we don't have any scientific certainty that there will be the risk of an irreparable effect, damages. In any case, we need to protect the environment with the interest that the protection of the environment now will include the present and future generations. So this is also in this view to include also generations that are both human and non-human. So this is condensate a little bit the development that we have been with together the Pro Natura and the intergenerational equity principle. So I read also in the concurring opinion that this was a little bit the approach that was suggested also in the Peru case. So our suggestion goes in line, but we rephrase that as a Pro Futuribus Generationibus. Again, with the idea to solve possible issues of interpretation, again, in the absence of certainty, for instance, from the scientific perspective. So taking a precautionary approach in this context.
Thank you so much. Thank you for all your answers. You have been very kind. I have no further questions, Madam President. Thank you. Judge Ferrer MacGregor, do you have any questions? Thank you, Madam President. First of all, thank you so much for your very valuable submissions, both in writing and oral, that will lead to a great deal of reflection on our part. There's something that is a matter of concern to me. This is day 3, so I was wondering how many days it's been. It feels like a week, but it's been only 3 days. Very intense days, by the way. But there's something that I'm concerned about. That has to do with something important, which has to do with a general principle. The general principle of shared but differentiated responsibilities, CBDR. So how can we make this materialize in practice? How can we get there? That's the question. Voluntary funds are insufficient. You have spoken of several things. Each of you has raised several issues, and we've heard several points of views. But what I would like to hear is from each delegation, for a maximum of 2 minutes, if I may, and speak slowly, please, for the interpreters to be able to follow you. For a maximum of 2 minutes, please tell us, from your point of view, how we can help this principle materialize. How do we bring it down to earth, this principle of shared but differentiated responsibilities, common but differentiated responsibilities? How is this principle lived in practice? You know, there's the issue of intergenerational equity, common but differentiated responsibilities, and international cooperation, of course, which was raised here as well. and then national capabilities, and the need to protect and guarantee human rights. So all countries have said that they're under the obligation to protect rights. They must all contribute to climate action, but not all of them have contributed in the same way to the climate emergency or have the same needs and the same resources to respond. So how can we actually make this materialize and become a reality? I would like to hear from all delegations about that. Of course, we have a limited amount of time, but in 2 minutes, tops, in the same order that you spoke. Thank you, Your Honor. I think that evidently there is a report by Oxfam about cumulative historical emissions, where it says that developed countries, according to the Framework Convention or the Global North, is responsible for 90 to 92% cumulative emissions along history. So that's there's the reality. There are different responsibilities. When we talk about the reduction targets, which also entails reducing damage, not all countries necessarily, and this is seen in the Universidad Politécnica de Catalunya study, where they speak of equity and carbon budget. We are under the obligation to reduce emissions, but that obligation does not is not incumbent upon us in the same way. So, and that has to do with the actions. I mean, these are economic actions, actions by persons, by countries as defined by the Framework Convention. So the first step to have a good allocation of responsibilities is, first of all, to recognize what the legal responsibilities are for each case. And that's eliminated by paragraph 51. And all of those states, even those under the American Convention, all those signatory countries have decided to accept, first of all, accept and take responsibility, and also, secondly, based on your actions. Panama, Costa Rica have less than 0.005% of global emissions. I mean, so that's how it is for Central American and Caribbean countries. So that can be ascertained in figures. And there are university papers about that can help us allocate responsibility so that we can find a way to repair climate change.
Thank you very much, Judge, for the question. I think this is a critical, the question really critically underscores the opportunity that this court has to clarify that longstanding human rights law, including the principles of equity and maximum available resources or progressive realization, those concepts can be brought to bear to complement and complete and reinforce the concept of common but differentiated responsibilities and respective capabilities under international environmental law and the climate agreements. And that the differential responsibility of developed states that have generated the lion's share of cumulative emissions and have greater capabilities to respond and redress harms is reflected in and flows from those legal obligations. Just as under human rights law, states' obligations are differentiated according to their resources and capacity alongside their proportional contributions to a given harm or human rights violation, so too can and should it be with regard to climate harm. And that those differential contributions to the harm through cumulative acts and omissions over time and differential capacities to respond can help distinguish the obligations incumbent chiefly upon the developed states to provide not only reparation for loss and damage, but the various forms of reparation needed, including not just compensation and finance, but also technology transfer and guarantees of non-recurrence, and that those responsibilities encompass and not only all three pillars of climate action: mitigation, adaptation, and loss and damage. But I think that there is a clear role here for the long-standing jurisprudence on equity and maximum available resources to help concretize what that CBDR means in practice here. And the last thing I would just say is that with regard to many of the questions about implementation of the principle of intergenerational equity the Maastricht Principles on the human rights of future generations contain a number of very helpful elaborations of what it would mean in practice, for example, to apply the precautionary principle with a mind towards the rights of future generations, such that, as it says, and I quote from Principle 9, the burden of proof in all circumstances must lie with those who would undertake or persist in the conduct involved, not with those who might be harmed. And I think this court, in drawing on its own jurisprudence and that in other international environmental law cases, could operationalize that burden shifting in cases where harm and responsibility is at issue, and that would go a long way towards addressing the rights of future generations facing irreparable threats. To complete me very briefly, yeah, go ahead, please, sorry.
Procurar que sea...
Okay. Please be brief. In fact, everything she talked about pretty much summarizes how we would see the responsibility of the countries. I would simply add then that if we look at it in terms of climate justice, in order to have justice, there needs to be social justice, environmental justice, and justice overall. We cannot think that the countries would take responsibility without starting with a concept of justice that covers everything. In our submission, we, as countries of the Global South, our emissions, we don't have large industries so much. We do not have so many transnational companies, and therefore our impact in terms of greenhouse gases is minimum. But we are suffering more from these damages and these losses than by those who generate more. So you need to start with the idea of social justice in order to achieve environmental justice or climate justice.
Thank you for the question. As my colleagues already mentioned, this principle, as well as the principle in intergenerational equity, stem from equity itself. And again, to achieve climate justice, again, I'm echoing my colleagues' words here because I think we stand on similar lines, is that if climate justice needs to be achieved, and if there is a recognition of differentiated responsibilities because climate change is affecting different people, different groups differently, that bringing that into the social aspect and the human rights aspect, this principle forms the basis of how certain, not just countries, but certain states and certain states should develop or not develop, or allow certain other states to develop. So having that standard, I think in the core with its equity would be crucial to understanding the applications of CBDRRC in the context of the climate emergency. And again, just to echo my colleagues' words here, like the Maastricht Principles, again, embed certain obligations in respect to future generations and their right to be protected. And when they come into the world, again, as mentioned by my colleague earlier, have the right to harmonious development. That can only happen if certain states take certain kind of responsibilities. I think I'll stop there.
Thank you for the question. I think I will first start by saying that we can identify existing examples of best practice. I cite the example of the Convention on Biological Diversity, which can be harmoniously interpreted both with the Inter-American system, both with the instruments in the Inter-American system, as well as with the Cartagena Convention, which guides not only the wider marine environment of the Caribbean region, which touches and concerns most Latin American and Caribbean countries, but also has a component on land-based sources, which outlines very specific standards and that can be interrelated. And I would say the court in its decisions, include both contentious as well as advisory opinions, have teased out linkages between the system and the Convention on Biological Diversity, for example, in the Kalina case, and with the Cartagena Convention in advisory opinion 2310. We, in our submission in paragraph 140I, also highlight some guidelines with respect to small island developing states within the Latin American region. And I wouldn't go through all of them. One of the ones I think is critical to highlight is one of the key components of common and but differentiated responsibility is transfer of technology and cooperation. And one of the things we underscore is that it is clearly critical and necessary for small island developments as well as Latin American states. But what is needed is technology transfer that is not a mere transfer from the global south to the global north to the global south, but one which incorporates traditional knowledge as well as leads to capacity building. I will end by saying that this is currently under consideration within the context, the same issue of how to best articulate meaningful common but differentiated responsibility is currently under discussion as we speak, I think, yes, with the internationally legal binding instrument on plastic pollution, including in the marine environment, which is of obvious relevance within the context in which we speak. Thank you.
Okay, thank you again for your question, Honor. I would like to conclude by linking the role of the principle of common but differentiated responsibility to the cooperative duties that was the focus of my presentation, because I think, and this is my understanding of when we talk about cooperative duty, specifically in the context of human rights, these I identify as a legal obligation. And once, as I said before, what is crucial, in particular for vulnerable states affected by climate change, and let's take the case of small island states, that they have the possibility to continue to protect the rights of their population. And once they are not more able to meet, for instance, international human rights obligation, and I think in particular socio-economic rights, I think in their context the principle of common but differentiated responsibility could play a role, because external state, less affected state, but also states that have more capacity, will play a role by providing finance, technology transfer, capacity building, also to ensure that the population, for instance, has the possibility to remain in their island. So there is all this component that I see as a legal obligation, and in this context the principle could play a significant role in giving content to the cooperative duties in the context of human rights.
Y bueno, aprovechando que
you're talking about a duty for international cooperation, and you associate it with, you link it to what in the text you gave us with Article 26 of the American Convention. Is that correct? That is, from the perspective of the convention, you're saying that there are a number of instruments, right? But you linked it to the American Convention. Could you explain that a little bit?
I wanted to stress a little bit with our intervention. So to see the role of cooperation, international cooperation, as really a legal obligation to ensure the protection of human rights included in the American Convention of Human Rights, that can be derived by the general obligation also included in United Nations Charter. This is, I see that there is some doubt, but I believe that we can also rely on the impact of other instruments. Cooperative duties in the context of human rights means also to provide support to affected population, and this in line with supporting the affected state to realize and implement and ensure that they can protect the human rights of affected or their population.
In this sense, we are particularly interested when we hear you talk about obligations rather than responsibilities.
I presented the role of to stress the role of legal cooperation as a legal obligation.
Okay.
Yeah, sure.
Muy bien, muy bien. Muchas gracias.
Good, thank you. For world youth, for climate justice, you completed your first presentation, your first intervention, with a phrase. You said, you're talking about children, youth, and future generations, right? And you said, with respect to intergenerational equity, you talked about incorporating this concept. You're asking us to incorporate this concept. And you say it's in Article 19. It can be drawn from Article 19 of the American Convention. You also said that it makes reference to you said Article 4, Article 5, Article 26. Could you please explain in a bit more depth? Bring it specifically when you talk about the American Convention, and something you said at the end, future rights of future generations. Are we talking about future rights or rights of future generations? It's not the same thing. It's two different generations. Because you said literally future rights of future generations. Can we protect? We can protect them as rights, but the question is who represents them? Or instead, are you saying that through protection of children and youth, if we achieve that, we can then protect? These are two different things. Thank you, Your Honor, for this question. I know that time is short, so I will not take long. Mainly, I think that the relationship of these articles is that in the cases of climate litigation that have taken place before domestic courts and regional courts, it has been done, these cases have been brought under the idea, with the idea that there was violation of the right to life and to personal integrity for children and youth who are bringing their grievances. And this is because the states have failed in their obligations to prevent foreseeable damage. Based on what we read in science, science speaks of irreversible damage to health of present and future generations. And this leads me to the second point of your question, which is that this differentiation between being a subject of law and an object of law, we believe that this should be addressed, especially when we talk about future generations from the perspective of objects of law, where the states would be under obligation concerning future generations, and you don't necessarily need to recognize the rights of future generations, because we know that they do not yet have legal personality to call them that. Nevertheless, this does not mean that they do not have an interest, a material interest. They live on this earth, and they should be able to enjoy the same rights that we are all enjoying. And if we may, we can even see it in light of Article 26, more progressive rights, and also in light of the pro persona principle. We need to look forward from the perspective of policy with the intergenerational perspective. So this, I think, is, in general terms, this is the perspective that we hold. Of course, all of this, as my colleague said, Aditi said, derives from the right to a healthy environment, which, and the court has established this in two dimensions, individual and collective. Future generations, we believe, would come under this collective dimension, with this perspective that future generations are an object of protection, and therefore we can link that to the other objects of protection, such as nature, biodiversity, and it all needs to be interpreted holistically, because in that way the states would not otherwise the states would not have the tools to face this climate emergency. Thank you. Thank you for your answers.
Thank you, Jeff McGregor. I ask the Vice President if he has questions. Yes. The first question is to Professor Elisa Fornale. That goes along the lines of questions already asked by Judge Perez Manrique. And also, for the benefit of usefulness, I will try to be very straightforward. I did not fully understand the usefulness of the concept in dubio, well, the Latin name, when in doubt, for future generations, or to the benefit of future generations. And you are suggesting it is a combination of the precautionary principle and in dubio pro natura. But quite frankly and respectfully, I believe it's more one of these names that have come up also in the hearing that seem to be more sophisticated theory than real tools to be used. And here we are trying to provide tools to solve concrete problems. So my question is, how does that assist us, the use of this principle? Thank you.
Thank you a lot for your question. Yeah, our idea when we try to suggest these two principles is really to provide tools that allow states to mainly to resolve conflict in case of uncertainty, and also when I said before, the adoption and the inclusion of this principle, let's say principle, but as I say, interstitial norms, because they have no autonomy or normative autonomy now, is really to create a normative change when they are applied, and to allow state to change also, or to solve a conflict that they can have in case of conflict interest. And I think Pro Natura has worked quite well, and there are several cases at domestic law, but we don't have a formal recognition at the international level, so this I think could be an important opportunity. Also because the only mention we have at the international, as we say in our amicus, at the international level has been done in a dissenting opinion during all the cases in front of the International Court of Justice. So I think due to the development that we have seen, we see in the region, I think it could be a good opportunity. As I said, we suggested to move a little bit further, but the idea beyond these two principles is to work as a really interpretative tool that we can provide to the state when there are uncertainty or there is not possible to solve issues where there are conflicting interests at stake. So this was the main aim that we had when we tried to suggest them.
Thank you very much. And as my colleague has already said, with Pro Natura we are clear on it, but the question really is in favor of future generations. I have to confess I still have my doubts, but thank you, we'll reflect upon it. Thank you so much. And I have another question to the Ruta del Clima. I would also like to come back to something else I did not understand. And if you could please be very specific in your answer. How, going back to the funds, how would these funds drive structural violence? I still did not understand it. How does the current design, such as they are and they stand today, how could they further this violence? Thank you, Your Honor. It's related to the conditions of extreme vulnerability the communities are in. They are currently already suffering damages and losses, and how countries and communities that are already extremely indebted and have precarious conditions economically speaking. They have pre-existing conditions of vulnerability, and then the consequent damages of extreme events and slow onset events, such as in the dry corridor of Central America, droughts or hurricanes. These events have devastated the areas for decades. And the fund, although it could lead to non-reimbursable funds that could be delivered to countries, is actually dominated by financial mechanisms, so insurance or credit or loans. So it opens the possibility for these countries and communities, instead of receiving the reparations they are owed due to these damages that they legally have a right to receive, and for damages they have no duty to support, they themselves, and they're already doing this, they have to pay out of pocket, out of their national budgets for these damages, and they must seek new forms of financing, whether be it through credit and financial mechanisms, so that they can subsidize damages that were caused by third parties. And this will lead to social conflict. In communities currently, what we see is that many of these are women's communities because men have left. In Central America, it's very common to see in fishing or agricultural communities where there is a loss of the social fabric. And besides that, on top of it, you have indebtedness, which is basically what the fund is suggesting to do. The main pillar, again, are financial institutions, international financial institutions, who have an aim, as any type of this institution of the like, have to provide loans to states. So that's the socioeconomic dynamics we are talking about. And we are talking about communities that if I don't fish today, I don't eat today. If it doesn't rain today, I won't have crops. And if I go out to fish, I have no way to pay for the gasoline, the diesel I use for my boat. So to that extreme, societies in Costa Rica, Honduras, El Salvador, Guatemala, we are seeing this logic imposed. Financial services as a solution to what extremely vulnerable communities are suffering. Thank you very much. No more questions.
Vicepresidente, también a Ruta del Clima.
Thank you also for Ruta del Clima, and briefly, in the interest of time, you said that Panama has a system to identify economic pecuniary reparations with 16 indicators. Could you briefly explain how that program works? And you said other similar experiences that may serve as an example for this court. Yes, certainly. Panama does indeed have a system with 16 indicators. It's on the website of the Ministry of the Environment of Panama. Unfortunately, I haven't had access to the description of each indicator, but I am certain of this because I have spoken to people at the Ministry of Environment, those who were in charge of developing it and are about to implement it. So I would owe you an answer on that. And we also do field work with community monitoring, and we have developed indicators to work hand in hand with communities to recover first-hand data, so to collect those, and we can provide you with that methodology as well. And there are other studies in Bangladesh and in Nepal where loss and damage has been analyzed at length, and they're looking for ways to go about it. But one Central American government has, and that's Panama. That's an important milestone to be borne in mind. Also, it's important to say that under Article 14 of the Rio Declaration, and the Convention on Biological Diversity, efforts are made to explain what losses and damage are in terms of biological diversity, and that could also be transposed to this case to see what considerations are to be taken into account. Thank you. I would like to see those data, so if you could please provide them to us. I'd like to thank all of you on behalf of the court for your submissions. Those were very useful for us, and as part of this very difficult task of issuing an advisory opinion of these proportions. We are going to break until 12 p.m. when we're going to resume with the second part of this morning's session. All right.
Buenos días.
Good morning. We reconvene this public hearing following the order established this morning and in preliminary meetings. I give the floor to the Center on Information on Business and Human Rights, the Association of Lawyers Jose Alvear Restrepo, Pax Christi International Program for Latin America and the Caribbean, and the Environmental Committee in Defense of Life. I remind those appearing before the court to please express yourselves slowly and clearly, both in your submission and then when answering questions to help interpretation run smoothly. Thank you. Warm greetings to the judges of the court. Before I begin, I wish to thank the solidarity and hospitality of our host state and, of course, the significant participation of civil society from all Latin America that, as always, has provided great energy in the Inter-American system of human rights. I am Fabiana Andrés León Peñuela, representing Colombia in the Center of Information on Business and Human Rights and the organizations mentioned by the President. The main objective of our submission is to focus on strengthening the inter-American system of human rights regarding the responsibility of economic actors and as to the respect and guarantee of human rights, particularly under the current climate emergency. I will bring 3 ideas that you might integrate into future jurisprudence and the advisory opinion, which would help us build solid inter-American environmental laws for the good of all communities, individuals, and nature. The first thing I'd like to highlight is an approach on the right to development as a determining factor to integrate in human rights under the climate emergency. We must consider that precisely the climate emergency is showing that states are really not materializing the right to development. To the contrary, all their initiatives are geared at promoting development that has gradually destroyed nature. And consequently, the right to a healthy environment is closely linked to that. Secondly, we invite you to include standards regarding the need to consider the role of businesses and the role of having more monitoring and supervision over their activities, as well as prioritizing accountability. Reinforced due diligence is necessary and should include participatory mechanisms, access to justice, and dynamic reparations as we have under the climate emergency. We would also like to suggest within the standards of the system. To be used, the Sendai framework for disaster risk reduction linked to the climate emergency. The disaster approach would contribute essential elements for decision-making in a dynamic, ever-changing context such as climate. A static view on climate would not really reflect the reality. As for the right to development, I suggest the following elements. Development was a central aspect of the creation of the Inter-American system. It is part of the constitutional elements of its charter and one of the main objectives of the system, particularly the joint promotion of the development of economic, social, and cultural development. However, the approach does not really follow the inalienable exercise of peoples to full sovereignty of their wealth and natural resources. It has been used as carte blanche to impact and exploit communities, many times in an unsustainable manner. This has led to the evolution of international human rights law as a relevant role for the inter-American system, and it is included in it to try and limit the exploitation of natural resources. It is clear that there's also a direction of public policy in the region where the backdrop is indebtedness, and certain clauses within bilateral agreements of investment impose burdens on states that limit their capacity to regulate the impacts of the climate emergency. This is an opportunity for the court to help guide states and to help them activate the necessary safeguards to correct the path the development matrix is following and protect their populations. It has been calculated that demands for investment in oil and gas may be ascending several $1 million, and considering these figures, it is necessary to have constructive dialogue with arbitration mechanisms and with the states that sign bilateral investment agreements to ensure they include international human rights considerations and identifying measures to protect safety, the life of people, labor rights, public health, and the environment, including response to climate emergencies. And considering the business framework, the guiding principles on business and human rights have provided substantial elements as to due diligence. However, we believe that it is not enough. We need to advance a mandatory due diligence approach based on the criteria identified by the Inter-American Commission on Human Rights in the report of 2019, considering elements such as adjusting behavior of businesses and companies to the guiding principles with an inter-American perspective, adopting plans to reduce emissions within the context in which companies operate, and minimizing their carbon footprint, not presenting obstacles to implementing environmental policies or actions, and mitigating and remediating negative impacts of their operations that might have been unavoidable, as well as those that could have been foreseen. To provide greater clarity on potential standards and obligations, we invite the court to consider the proposal by the Working Group on Human Rights and Transnational Businesses. They suggested 3 levels of obligations: the obligation to protect by the states, obligations to respect by businesses, and the obligation to remediate for both. In the first case, adopting an ambitious approach to reduce emissions, guaranteeing a fair transition based on rights, and to support defenders, to discourage greenwashing and undue influence of businesses in public policy. As for businesses, they have to adopt corrective measures urgently in their operations and promote responsibility and engage with stakeholders such as indigenous peoples and reducing the impact on human rights regarding the climate emergency, as well as promoting responsibility and refrain from greenwashing. And for the obligation to remediate, we have to have appropriate and effective measures considering intersectional and vulnerability approaches, building a solid accountability culture, and provide legal, judicial and extrajudicial recourses related to the environmental impacts and human rights derived from the climate emergency. The court should focus its efforts on characterizing extractive operations as a high risk, considering the emergency. And regarding the Sendai framework in the Inter-American system, we believe it is essential for the Inter-American system to include this risk perspective, as it is consistent with the dynamic development of the climate emergency. And it means that we would have a response articulated by international instruments, but also a very concrete, specific response according to the cases and particularities of each territory and context. This would allow the Inter-American system to include elements such as size, frequency, concurrence, whether we're talking about rapid or slow onset, the origin, whether natural or human-made, and even a description of technological or biological threats and risks. Additionally, in order to improve the way the Sendai framework is applied, we suggest certain recommendations as to priorities included in emergency action plans or plans to respond to the climate emergency in the region. Urgency in understanding risks, strengthening governance to manage risks with clear and well-defined criteria, support through regulatory regimes that refer to the roles of state and non-state agents, and the inclusion of stakeholders from the scientific, academic, private sector, and civil society. And lastly, it's important to, from the Inter-American system, ensure companies assume business models that allow for shared prosperity, to truly commit to the public sector, and to have a relationship that helps us provide a clear due diligence approach, mandatory due diligence approach, so that states can adopt these measures within their regulatory frameworks. And lastly, including effective participation and fair negotiation with communities and workers with projects that are occurring or will occur in their territories, and also considering the damages and violations of human rights that are presented or may present themselves. Reducing GHG. Sorry. That, of course, means there should be a precautionary approach that is coordinated and open to risk analysis regarding human rights and the climate emergency, linked to the development of business activities and how these should take specific rapid measures to respond to this without becoming actors that go against measures by the states. Thank you.
Thank you for your participation. Now I give the floor to the Civil Association for Equality and Justice, the Center for Legal and Social Studies, Fundar, Center for Analysis and Research, and the Center for Economic and Social Rights, and the association La Ruta del Clima. You have the floor. Thank you, Madam President, Honorable Court. Good morning. To all, my name is Julieta Levin. I belong to the CELS, and I am going to speak based on the amicus curiae that we submitted together, the organizations that you just mentioned. And it will focus on the role of fiscal policy in the face of the climate emergency and its impact on human rights. When we talk about fiscal policy, we're talking about resources available. And without resources available, nothing can be done about climate change. So for the steps to combat this emergency to be possible, it is essential for this honorable court to include standards about fiscal policy in its advisory opinion. This is fundamentally important and is an issue that is being broached at the regional and international level in several venues. And it's especially important for Latin America and the Caribbean, where fiscal systems are regressive because the tax burden is not proportionate to people's ability to pay, which affects the most vulnerable the most. And it is one of the most indebted regions with the highest level of exposure to climate change. Oftentimes, for states, debt obligations prevail over climate obligations, and countries allocate more resources to paying debts than to dealing with climate change. So this has to change. This is an opportunity for this regional court to be at the forefront of this issue. A key tool for the development of standards in this area is the initiative on fiscal policy that was made up of some of these organizations that I represent. They include human rights instruments in the area and have been signed off on the Inter-American Commission, and also include the Protocol of San Salvador. We would like to have you include that in your AO. I will first of all speak about human rights and fiscal policy and the need to mobilize as many resources as possible. And then I will develop the link between debt and climate change. And finally, I will submit our pleadings, our petition. The right to a healthy environment and other human rights is contingent on resources being available. Reparation for losses and damage caused by climate change also is contingent on funding. We need resources to fund the energy transition, and also have policies against climate change and for the transition. However, the structure that we have in place goes against the taking of these measures. We don't have a fiscal situation that is comparable to developed countries, where there are excise taxes that do not bear in mind people's ability to pay and are therefore regressive. Fiscal policy can contribute to guarantee rights by allocating resources, or else have inefficient or regressive regimes. The obligation to mobilize as many resources as possible means adopting a policy framework to ensure resource mobilization, and further taking measures to enlarge that pool of resources when necessary. That means increasing fiscal space through progressive tax measures, through resources that are being mobilized and that are lost due to evasion and corruption. And also they should be obtained through international cooperation. Based on the principle of non-regression, states must ensure that their fiscal policies do not lead to backtracking in terms of human rights. And this means exploring all possibilities of enlarging fiscal space before going into austerity. And now talking about CBDR, which has been mentioned once and again during this hearing, developed countries must provide financial resources to developing countries to meet their climate commitments. And this court could specify what the scope is of these CBDR in terms of finance. And going back to an issue that is a double whammy for the region, debt and climate change. The Latin America and the Caribbean is the second most indebted region over the last decade. There is a vicious cycle involving debt and climate change, because the emergency caused by climate change has led countries to take on debt to face this issue. Here, once again, CBDR. Our region that has made a negligible contribution to climate change is now suffering its consequences by receiving loans from international financial institutions or countries that were the ones that caused climate change. And thus that increases the burden of debt. Going back to Judge Ferrer Magrego's question, the court could indicate the need to explore different alternatives to loans to fund climate action, such as grants. So there's a need to fight climate change. In 2021, the lowest income countries devoted over 5 times more of their resources to climate change than those that are developed. And there are also situations that are incompatible with the fight against climate change. The economies that are based on the export of raw materials, as is the case of many countries in Latin America, foster overexploitation of the natural resources and extractivism and agri-industry. In Latin America, there are tax benefits and also subsidies to these industries, and they favor high income individuals and companies and end up being regressive and hurting those most vulnerable. The case of Argentina is a case in point. Currently, there is an adjustment being made to public spending affecting human rights and environmental rights. In the first Q of 2024, 96% less was executed on the environment and climate budget. But the tax benefits of extractive industries is never brought into question. There is a promotion of mining, for example. In 2023, over 58 billion pesos were not collected, which is the same as the initial budget of the former Ministry of the Environment. And the government seems to be happy with this model and overlook these things. This court can have a fundamentally important role in saying that the principle of debt sustainability must include an environmental dimension and human rights obligations, and should not be circumscribed, as is the case now, to short-term analysis as to whether debt can be paid or not in merely financial terms. And this has been said during special procedures before the UN. Debt cannot be considered sustainable. If to pay, you have to breach your human rights obligations and your environmental obligations. It cannot be a viable option to relax the standards of environmental protection to foster hard currency investment to pay the debt. And this is not just for debtor countries, also creditor countries, states, IFIs, and private financial institutions are also under the obligation for cooperation, due diligence, and precautionary obligations that make it necessary for them to carry out impact assessments before making recommendations and issuing loans, and making sure that the ability of the state to respect human rights is not undermined. This AO is fundamentally important in delineating, outlining the main obligations of the states to face the climate emergency. Climate change has especially great impact in our region and is a threat to humankind as a whole. And that is why financial issues must be included also as part of fighting climate change. In view of the above, we would like to request that when issuing the advisory opinion, it develops standards on fiscal policy to guarantee the availability of resources to face the impacts of the climate emergency, resources that must be collected in a progressive and forward-looking and sustainable way, so as to make sure that sufficient resources are available to guarantee human rights, and taking into account the CBDR and the need for international cooperation. These standards would once again position the court at the forefront of the international of the world, setting the course for the states and for other international organizations and tribunals that are dealing with this issue, which is an issue that will not disappear soon. It is here and will be for years to come. Thank you.
Thank you for your participation. We will now hear from the representatives from Eulalia, Petit Gabriel, and Iraida Jimenez. May it please the court, I am Iraida Jimenez. I'm from the International Affairs Office of the University of Barcelona. Madam President of the Inter-American Court, ladies and gentlemen of the court, Assistant Registrar, representatives of the states and international organizations, ladies and gentlemen, the climate crisis we are facing poses an existential crisis not only for enjoying human rights today, but also for the very survival of the human race into the future. This is why the critical question we should ask is, are the interests of future generations being protected by the obligations established in the American Convention? Are they adjudicable before the court? The answer is yes. This is why we want to emphasize some of the principles that will help us develop this position. First of all, the delimitation of the concept of future generations in the sphere of international law, which has evolved and has finally become an essential component for sustainable development, and also a critical factor, an indissoluble factor in human rights treaties. The idea that that intergenerational rights are being developed progressively as an intertemporal right, and there is has a means of access first to temporal justice and also to climate justice. This has been a bridge for including the principle of humanity and equity through the interpretive jurisdiction of for the Biodiversity Convention. This includes the interests of future generations and has been used in a number of different litigations, both domestically, such as Future Generations, Neubauer, the Institute of Amazonian Studies, and more recently, internationally, before the European Tribunal of Human Rights in Climus Seniorium, where there was the issue of uneven distribution of the burden for future generations, associating it with effective measures for making substantial progressive reductions of greenhouse gases. The guarantee of life, survival, and development of future generations is based on two main pillars. First of all, data-centric, and number two, multicentric or anthropocentric. The first has to do with meeting the ultimate objective of state sovereignty, which is nothing more than protection of the human community, which needs to include compliance with international standards associated with human rights, and this leads to protection of populations that are currently under the jurisdiction of the state and can be projected to future generations. The second pillar, multicentric. We should recall that the American Convention protects the rights of current people, but also is vital for it because of its intrinsic value. Faced with the failure to comply with convention-based obligations on the states, this is where intergenerational justice would take shape, first of all, from the substantive standpoint through the concept of life plans, which has been established by this court in its findings on reparations, but also in substantive law to life and personal integrity for children and youth. These are particularly vulnerable populations who are affected because of intersectional vulnerability. The right to life, which is enshrined in Article 4 of the Convention, is not limited just to mere physical existence. We find that there are current categories facing a significant, real, and imminent reduction of life expectancy as a result of climate change. Therefore, we must ask, what is a life plan if not an expectation to lead a decent life into the future, even faced by a grave material and imminent threat to human rights? We should remember that the incorporation of the life plan is an autonomous right, because the violation of the rights guaranteed in the Convention has an impact on life expectancy and therefore on future life plans. Therefore, it entails violation of Article 4, 5.1, 17, 19, and even 26. In the context of the climate crisis, in sum, the right to life and life plans are intergenerational guarantees in the framework of the American Convention. This, in no case, means calling on actio populares, because we see that legitimate and direct interests of current vulnerable groups are being undermined. The key of state obligations is based on the sustainability of conditions for decent life, where the state has the role as a trustee of this essential resource for the effective exercise of human rights with no specific temporal restrictions. Thank you for your attention. I will now ask Professor Petty to continue. May it please the court. My name is Eulalia Vladimir Petty de Gabriel, and I am appearing before the court as a professor of public international law of the University of Seville, Spain. As my colleague has established, substantive rights recognized in the American Convention for people currently living and existing guarantee or can guarantee the interests of future generations. From the procedural standpoint, however, the problems that the inter-American system may face are different from those in the European system and those that have been described in the past few days. We're not talking about rights holders, whether or not people hold rights, because living people do have rights, or a question of standing or locus standi, because in the inter-American system, any person or group can bring a petition. Rather, it's a question of identifying victims as a standard for admissibility, which is different from the standard for jus standi. The requirement for identifying the victim, nonetheless, is not contained in the convention. It is a requirement that is established as actionable under the rules of procedure under which a petition can be brought without identifying the victim when it's not possible. But the rules of procedure of the court establish as a necessary requirement the identification of the victim in order to process an application received from the Commission. Exceptions are recognized in the case of collective violations, and the court has developed in its case law this as a number of criteria for determining special circumstances under which this exception can be invoked. Bearing in mind the difficulty of identifying specific victims, in the sense that damage to life plans and the impact on future generations is uncertain, although it's likely and foreseeable. So we would propose to the court a number of different avenues by which it could move ahead in this area. First of all, to analyze in terms of massive or collective violations or that can be litigated because of the climate emergency. And this could be done without making any change to current practice. In the second place, explicitly amend your rules of procedure in order to allow a new exception as the elements the court must define for bringing applications before the court based on climate emergency. A third idea would be that the court accept the view already taken by the European Tribunal in the Swagens case as the potential victim. That is to say, when a whole chain of events occur that are likely, that are probable, and that culminate in a certain violation of the rights of the applicant. This situation, we think, is certainly present in this current climate, especially if we consider what factors should come into effect for this purpose. Why, in our submission, did we submit a discussion of the contentious jurisdiction when we're supposed to be talking about an advisory opinion? Mainly because of effectiveness. It has been shown in the past that advisory opinions from the court can lead to jurisprudential development by the court, but not only by this court, also by domestic courts, and also changes to domestic rules and regulations. The states are the primary are custodians of guaranteeing rights, and therefore the advisory impacts for judicial review based on the convention would lead to a number of steps that we think could be included in the process of protection. In the second place, our second reason is based on context. In this dialogue among courts, why do we feel that these systems where we have diversity of views and of assessment is important, also in the case of territorial damage? And finally, there's an argument based on timeliness. The advisory opinion makes it possible to engage in a debate, a discussion, and a biased discussion without viewing the real situation of victims, re-victimization, or circumstances that converge in the states. If I may, I would like to close with a personal comment. 24 years ago, on this same date, I was married, and I decided that every day of my life would be an April 25th. My husband, my daughters, who made it possible for me to be here and to develop my career, are my own life plan. We would ask this court to guarantee that children and young people can develop their own life plans, just as I have done. If they can't, there will be no new generations, my daughters, my grandchildren. Human status is necessary for the human community is necessary for the state to exist, for the new leaders to exist. The human community will give rise to future courts, future judges for this court. Thank you for your attention.
Thank you to Eulalia Petit.
Thank you very much for your participation. I now give the floor for the International Code of Conduct, the Arias Foundation for Peace and Human Progress, the Institute for Sustainable Development Education, the Geneva Center for Governance and Security, the legal consultancy of El Bosque University, and the Institute for Studies in Development and Peace, and other experts. Go ahead. Thank you very much, Your Honor and judges of the court. On behalf of our association and the legal consultancy of El Bosque University and the other organizations I'm representing that wrote this amicus, the opportunity for bringing our contribution under point E on the obligations of states in terms of protecting human rights defenders, environmental defenders. We wish to highlight the role that private security companies have performed in creating risk situations in two scenarios. First, by providing services to companies of the extraction industry, and secondly, when they protect human rights defenders. These types of private entities provide military and security services covering a wide range of services such as surveillance, protection of people and objects with or without weapons. The use of mercenaries to violate human rights and hinder the exercise of rights to their self-determination, calling it the working group going forward, has stated its concerns on several occasions because these types of companies have been replacing services that were previously provided by the state. Even for the region, Latin America and the Caribbean, it is estimated that 2.5 million people work in these companies in some places, and sometimes even exceeding the number of police officers. However, the problem is that this is not a fully regulated sector. Towards 2009, the Inter-American Commission lamented the lack of regulation and the implications on human rights violations. We are currently still pending on the thematic report on the matter. And also recently, the Commission for the Truth in Colombia issued specific recommendations to do the institutional and legal reforms necessary to ensure effective control for these types of companies. These companies in the extractive sector, as we have submitted in our document, are silent actors, but determining the creation of environments of violence against human rights defenders and environmental defenders. The working group has highlighted the fact that in the extraction industries, companies invest billions of dollars to build and maintain as well as administer their extraction projects, employing a large number of people. And it is to their great interest to guarantee the security of their facilities and operations. So therefore, they must use different types of security providers for their own security or third-party security officers or security offered by the state. All types of security provision entails surveillance, sometimes intelligence, and even use of force. With a lack of clear standards and effective supervision, it is unavoidable for violations and abuses to happen. The Inter-American Commission, in several of its reports, has mapped and received information regarding multiple incidents throughout our region. They've even said that people live in fear in certain communities because of how these companies act, that private security guards participate in police operations and detain citizens or even evict them. There's been very serious cases in Honduras, Guatemala, Brazil, Ecuador, Peru, and even one of the cases in Colombia involves women that in a focus group said that the security personnel related to clean energy projects, including clean energy projects constituted a threat for environmental defenders, and they had even threatened sexual violence against women. So even companies providing solutions to climate change are also immersed through their security providers in these kinds of threats. The companies that provide protection services for human rights defenders can also be immersed in these types of violent spheres against defenders. It is more and more common for countries in the region to use mechanisms to protect defenders, which are material measures to protect them. By creating these mechanisms, such as in Colombia, Mexico, Brazil, Guatemala, or Honduras, they are part of the supply chain of private security companies. Vehicles, vests, drivers, armored vehicles, etc. So we have a case in Venezuela where the Public Prosecutor's Ministry is authorized to ensure that companies protect their citizens. Or in Colombia, the Commission in its report on the matter stated that civil society has denounced security companies that historically have been linked to self-defense groups are linked to the Defender Protection Program. The Commission, in its practical guide and recommendations for protection plans, has recommended these companies not to be linked to risk assessment, and that they have to be fully coordinated with protection mechanisms whenever protection measures are implemented for defenders. So given all the situation, we find that a determining factor is a lack of adequate regulatory framework. We must have regulations that are specific to these types of companies, and we need standards. And this is a great opportunity for the Inter-American Court to promote throughout the region these types of regulatory frameworks. We have a very important basis for this, and we suggest you may include this in your advisory opinion. The Montreux document on international legal obligations and good practices for states regarding the operations of military and private security companies during armed conflict. For two reasons. First, because countries in our region do have armed conflicts, for long-standing ones such as Colombia or new ones such as Ecuador. And secondly, because the instrument does not limit itself to armed conflict. It does have a very interesting and valid paragraph on good practices in times of peace, covering aspects from hiring and procurement to accountability. And because countries in the region have also endorsed the document, Chile, Costa Rica, Ecuador, and Uruguay. And we also have the International Code of Conduct for private security providers, which is complementary to the Montreux document. It is also in harmony with the principles on business and human rights, and it also provides a source of important regulation on the matter. This will allow to improve the ways to incorporate staff, ensure correct forms of procurement, hiring processes, background checks, supervision of training, quality indicators, liability insurance, etc., licenses, etc. I have a minute left, and I would like to add that indeed defenders, environmental defenders, are actually working on mitigation of climate change. The communities are there stopping machinery from entering their territory. Communities are the ones taking measures and taking steps that states are not taking by making or establishing more flexible environmental protection. It's the farmers, the indigenous peoples that are limiting the devastating environmental degradation. They're doing it on their own. So when they take these measures, after years, courts most of the time even give them the merit that they had a just cause for these demands and rejecting these projects. In the end, those who end up repelling and exercise and repressing defenders many times are the companies that are at the service of extractive industries. So it is very important to have regulatory frameworks for these types of companies and the way the conflicts with communities are managed. That's why we wanted to bring forward this topic to the table. Thank you.
Gracias. Seguidamente corresponde.
Thank you. Now we'll hear from the Center for Gender and Refugee Studies, International Refugee Assistance Project, Global Center for Legal Environmental Studies at the Elizabeth Hobb School of Law at Pace University, Sir Arthur Lewis Institute for Social and Economic Studies of the University of the West Indies, and Alianza Americas, Refugees International, and Shana Tabak. You have the floor. Thank you, Madam President, distinguished members of the court. My name is Felipe Navarro, and I'm honored to appear today representing the Center for Gender and Refugee Studies. I am joined by Professor Camila Bustos and Dr. Natalie Dietrich Jones, who will also be speaking, as well as by Mr. Jose Miranda from the International Refugee Assistance Project. Our presentation today focuses on climate-related displacement. I will discuss state obligations to address this issue when it occurs across borders. My colleagues will provide additional considerations relevant to small island developing states and will cover internal displacement. While prevention and mitigation should remain a central goal, the reality of climate-related displacement confronts us. Although most people forced to flee remain within their own country, this phenomenon is increasingly transnational. Our submission emphatically calls for protecting individuals displaced across borders in the context of the climate emergency. This is echoed in over 50 other submissions, collectively underscoring the need to address this challenge through robust legal frameworks. International refugee and human rights instruments do offer a fundamental basis for protection. The UN Human Rights Committee has recognized that the obligation of non-refoulement under the International Covenant on Civil and Political Rights forbids states from returning individuals to places where their lives or well-being are threatened by the effects of climate change. Now the court has the great opportunity to reinforce the relevance of the right of non-refoulement as enshrined in the American Convention and the American Declaration in this context. We urge the court to ensure that this advisory opinion addresses state obligations in these four aspects. First, affirm the applicability of the right of non-refoulement in protecting individuals forced to cross borders due to threats to their life or personal integrity, humane treatment caused or exacerbated by the effects of the climate emergency. This is a matter of both treaty and custom, and as the court has recognized, is a jus cogens norm of human rights law. States must interpret their obligations accordingly and establish procedures to process the claims of climate-displaced individuals. 2. Emphasize that a primary way for states to fulfill this is through the right to seek and receive asylum as enshrined in the American Convention and through complementary protection. According to UNHCR guidelines and as demonstrated by the work of my own center, many individuals displaced in the context of climate change and disasters qualify for protection under the Refugee Convention, the Cartagena Declaration, and human rights law. States must interpret their obligations to extend these protections effectively. Third, underscore that notwithstanding their obligation to protect, states should individually employ measures that can give them the flexibility to respond to enabling climate-displaced individuals to reach safety and receive adequate support. These measures can include offering humanitarian visas, temporary protection programs, and family reunification pathways. 4, advise states that they are obligated to cooperate in fulfilling their human rights obligations and have committed to do so through different instruments. Therefore, cooperation agreements between states should be leveraged proactively to address the needs of climate-displaced individuals through measures such as improving migration and international protection frameworks and enhancing free movement agreements. The guidance from this court will be invaluable in shaping a principled and pragmatic international response to this pressing human rights need. Thank you. And if it please the court, I will now give the floor to Dr. Dietrich Jones.
Good afternoon, Madam President, esteemed judges and fellow attendees at this historical court sitting. I am Natalie Dietrich Jones, a research fellow based at the University of the West Indies in Jamaica. Today, I stand with all citizens of small island developing states, which are most vulnerable to the effects of climate change. I am pleased that through this forum, we have been able to cross geographical divides to hear the experiences of other states, such as Vanuatu. As we offer our final remarks on questions E and F, I would like to focus on question F3, which deals with forced displacement and migration. That is, what obligations and principles should guide the individual and coordinated measures that the states of the region should adopt to deal with involuntary human mobility exacerbated by the climate emergency. In our brief, we have argued that existing international and regional refugee and human rights standards delineate obligations and principles for states to protect persons displaced across borders, including those displaced in the context of the climate emergency. We also noted that successful mechanisms have been implemented across SIDS in the region, including mechanisms which have welcomed persons displaced across borders. The success of these initiatives points to what is possible through regional cooperation. It is notable that some of these mechanisms have emerged within a geographical space that is characterized by a weak human rights protection framework. Thus, within the Americas, there is greater capacity among some states to implement the court's findings. As the court formulates its response to our submissions, we ask that its deliberations on differentiated responsibilities also consider the distinctive human rights settings which shape the jurisdictions which will receive the opinion, in particular SIDS. The capacity to protect and enforce human rights is constrained by fiscal, technical, and human resource limitations in this special category of states. Therefore, should consideration be given to enhancing human rights frameworks with a view to strengthening SIDS' capacity to be...
I'm sorry to interrupt you. We have a problem here. The translation, can you please pause your presentation?
Sure.
¿Tú escuchas, Eduardo? Es un problema aquí.
Necesito por favor que venga el técnico.
We will just wait for the technician to come over, if you'll bear with us.
Please go ahead.
Okay. So, therefore, should consideration be given to enhancing human rights frameworks with a view to strengthening SIDS' capacity to be duty bearers to displaced migrants, both internal and cross-border? Could this be one element of reparatory justice? Such an approach would redound well to the wider landscape of human rights in Latin America and the Caribbean. In addition, we also ask that the court consider how it will engage with the different regional integration mechanisms, which will in essence be conduits for implementation of its ruling, where its jurisdiction applies. We urge the court to remind SIDS that notwithstanding the disproportionate impact of climate change, they remain duty bearers. Finally, we note that while the judgment will have wider application, that it may well require differentiated approaches in SIDS, not in the Americas. And I yield the floor to Camila Bustos.
Thank you.
Thank you, and good afternoon, Madam President and distinguished members of the Court. My name is Camila Bustos, and I'm an Assistant Professor of Law and faculty member of the Global Center for Environmental Legal Studies at the Elizabeth Hobbs School of Law at Pace University, New York. As my colleague said, we should not forget that most people forced to flee their homes due to climate-related impacts remain within their own country as internally displaced persons. Disaster displacements are usually mentioned as natural disasters, but it is human failure that is behind these disasters in many cases, and this obscures the way in which local and national governments are not meeting their human rights obligations under the law to protect residents. Economic inequality, poorly designed infrastructure and housing insecurity, coupled with inadequate disaster risk management, render people vulnerable and end up being forced to be displaced. As disaster scholars and affected communities painfully remind us, disasters are not natural, but rather the result of policy failures that fail to uphold the human rights of individuals before and during and after disasters. A few days ago, the Colombian Constitutional Court issued the judgment T-123 of 2024, which for the first time ever recognizes internal forced displacement due to environmental factors, including climate change. This decision establishes the obligation of the state to provide comprehensive protection to those affected, marking an important precedent for the protection of the rights of people affected by environmental events. Similarly, we respectfully urge the Court to ensure that this advisory opinion address state obligations in the context of internal displacement related to climate change in three main ways. Number one, states must uphold the rights of communities to remain in their homes and guarantee their safe return and resettlement where possible. States must fulfill their duty to protect the right not to be displaced as a result of climate factors. Managed retreat as or planned relocation should be a last resort option. This court has already articulated states' obligations with respect to IDPs under the American Convention. We respectfully request the application of these standards to climate-related displacement. And finally, displaced individuals should not be subject to bifurcated regimes of protection that recognize and address displacement due to conflict or war, but ignore displacement rooted in climate or environmental factors. States must protect all internally displaced persons through human rights frameworks and not just through using the handout approach. Thank you.
Thank you for your participation. We will now begin with questions and answers by the judges. Judge Patricia Perez Goldberg, do you have any questions? Yes, Madam President, I do. Thank you. I would like to thank all of you for your participation. I have only a couple of questions because time is short, but first I would like to express appreciation for the thoughts shared by Professor Petit. It was very enlightening and inspiring. The representative of the SACE, you shared thoughts about fiscal policy and climate change. So I would like to ask you, based on the review that you did, whether you have any thoughts about the measures proposed, for example, by the OECD concerning carbon, but also they have proposed other measures. Do you have any particular view? Because the OECD has systematized a proposal in the line that you have described. Thank you for that question. Specifically on the OECD, I do not have information, but I do have about the information about the idea that tax systems also need to have a purpose. They need to be regulated. They need to be supervised. So when you talk about benefits for extractive industries. The Inter-American Commission has also said that these benefits are out of order, and also the IMF itself has talked about the benefits for contaminating industries as benefits that should be removed. Also, and at the same time, benefit industries that are useful for the transition. So this is our argument. Also bearing in mind that here in Latin America, unlike the case of the OECD, most of the tax systems are regressive. They do not consider people's ability to pay when taxes are assessed. There is a comparison that was done by ECLAC with the OECD, which found that the tax structure in Latin America, they found that 50% of income, of revenue, consists of taxes on goods and services, unlike the case of the VAT, which applies equally to everyone, regardless of their socioeconomic status. But for the OECD, these taxes make up only 1/3 of total tax revenue. So when we talk about progressive systems, we can look at the OECD countries, which are much more progressive than those we find in Latin America, which provides a useful parameter. Thank you. That's fine. The thing is, OECD has a whole body of recommendations, a very broad one, and it would be interesting to know whether you have an idea about that range. But I want to talk specifically about the Americas. Yesterday we heard from Professor Desierto. I don't know if you heard her, and she was proposing a subject which was very interesting, that is the possibility of complementing national domestic cases with the international legal system or justice system. Have you looked at how fiscal policy, tax policy in the countries of the region takes into account in its planning processes these contributions, these international contributions? I'm, of course, most familiar with the Chilean system. We have a direct mechanism through the law on the climate change framework, which considers financing, but there are also indirect mechanisms, such as the law on the environment, differentiated electricity fee rates, and so forth. Do you have a view about the Americas? That is, how the countries are financing the contributions based on planning, budget planning. That is to say, a specific breakdown in national budgets. And if they do, what good practices have you identified? I cannot speak in general terms about the region. It's information that I do not have. What I can suggest as a good practice is the climate action tagged and environmental action tagged budgets. In Argentina, we have certain budget items that have been tagged because based on how much is allocated to these items. But I do not have information on how this is measured. I don't have specific information, but I do know there's a research project underway, at least in my own country, that analyzed how budget expenditures are allocated to climate actions. In general terms, what we can say is that most financing that in any case needs to be received by Latin America through Article 9 of the Paris Agreement, that is where the developed countries undertook to provide financing for mitigation and adaptation, but most of it is loans. So the fiscal concerns, it comes from the same attitude, which is that in any case, the financing being given through the Framework Convention of the Paris Agreement merely builds debt. Thank you. No more questions.
Thank you, Judge Perez Goldberg. Judge Veronica Gomez, do you want to ask questions? Yes. To Mr. Fabián León Peñuela. You refer to the importance of dialogue with arbitrage and financial institutions and bodies, and we know that This is something that in the international community is like facing someone with several personalities. On a certain level, they talk in a certain way, and in another level, they talk differently. It's the type of thing that happens throughout. So, more specifically, how should the dialogue happen? In arbitration venues and in economic or commercial areas where these are being discussed. You're talking about business and human rights. So what we propose is a two-level dialogue. Of course, exchange of information among courts is part of how you build international law. But we also understand that in arbitration courts and venues, you have lex mercatoria as the primary force. And so it should be a two-way dialogue and an exchange with these courts. But such as in this advisory opinion, this court has, in developing its jurisprudence, it has the opportunity of guiding states in the development of law. So it could be the thread that unites the discussion. And when discussing bilateral investment agreements, free trade agreements, and general negotiations in these types of areas, to include specific human rights causes to safeguard and protect, and very particularly introducing the risk perspective. Because what we see in the general context is that there is an assumption that a company operating in a territory is neutral, and we need to include in that perspective and within that vision of states to negotiate the fact that any extraction projects, any project related to natural resource extraction entails risks, and for that you should preventively identify measures and build governance considering the impacts you may have. And with climate change or climate impact even more so, considering all the perspectives we've heard from many speakers, differentiated impacts, specific impacts in vulnerable communities. I understand, but as we understood it, there may be environmental assessment studies that are paid for by these same companies. So now you're telling me they're neutral, so you wouldn't even need to have this? Well, the dominant discourse states that the fact that the company goes to a territory has no impact on it. If you look at it from that perspective, when there's an environmental assessment performed, reality is divided into groups, and they are seen as isolated or separated. If you look at the socioeconomic impact assessments, there never are biotic or abiotic components of these, such as if people were not related to the environment. So when we say that there's a dominating discourse that seeks to be neutral, is the fact that business activity in itself already creates impacts, whether positive or negative, depending on the context. But it influences how communities live. It creates certain expectation, previous economic movements, and the operation in itself has environmental impact. So just to remove that veil of neutrality or impartiality would change the way these bilateral investment agreements are negotiated. So there's a whole area, you're saying, as to how to evaluate or assess the impact and how to assess risk dynamics. Yes. And there's a paradox, if I may. Many states, given their weak institutions, when analyzing the impacts, use those studies as a basis, and they let themselves be influenced by them. And the problem is that the risk analysis and impact analysis of human rights by companies, you see that there is an absolute lack of transparency as to how they assess impacts. And what we can see clearly is that any reading on impacts from the business sector is always from the profit and loss perspective and not on human rights. Lastly, for you, what's the role of the state in regulating companies and businesses, particularly in terms of emissions targets? The role of the state is absolutely essential, and here again the court has an interesting opportunity to, considering the climate emergency, it could open the space, as we heard from our colleague Diana, to have new regulatory frameworks. Today there's like a prior initial consensus that these scenarios of multi-stakeholder governance are lacking something, and states need more robust regulatory measures with very clear, concrete indicators of the emissions that are allowed or disallowed, what is understood as emission, because even if you look at it in the current context and with new developments for the energy transition, hydrogen in the region, for example, is talked about as being a good way to reduce GHG emissions, but in reality, we see that the science today proves there's no evidence to that. And what's happening is that in these supposedly new initiatives to reduce GHG emissions, old extractive activities are being promoted, coal, gas, and hydrogen in this sense. And within these regulatory frameworks that are still weak in our region, in spite of this, are there any good practices that you could highlight? I would highlight three. One, within the system, the initiative by the Inter-American Commission in 2019 of providing Inter-American guiding principles. It's very interesting in how it presents this and the array of topics it includes. And then secondly, the region is also bidding on due diligence laws that are, of course, limited because it's just one procedure, but building public human rights policies and business and human rights policies, of course, with a more global perspective. And thirdly, framework legislation. There's initiatives in Brazil, for example, and Colombia. There's some discussion already, even in the civil society, to promote framework legislation on business and human rights. And the cross-border element, which is essential for the climate emergency. Is it included in these? Yes. One of the barriers to justice in business and human rights is extraterritoriality, and it's almost the question that asks us to reflect. And this is relevant because many of the impacts that we see in mining activities and even renewable energies are cross-border and transboundary. So I would highlight the discussion, for example, regarding mining rivers and the discharge of chemicals in rivers, and this type of mining does happen in transboundary scenarios. And also considering that we also should look to migrant labor and forced labor, which has to be linked. And also contamination. Thank you. Very quickly to Julieta Levin. You've mentioned common but differentiated responsibilities and said that climate change, the climate emergency, should order certain variables. You referred to fiscal matters. I know that given the nature of the discussion, when you talk about debt and external debt, we have cross-border elements. How, after all the perspective you provided from the fiscal side and taxes was more of a national level, how can we include the global or transboundary effect of the climate crisis? Thank you for your question. If I understood correctly, what we should consider is first the obligations of borrower states, but also the obligations linked to the creditor states and to states when they act within international financial institutions. Obviously, the court does not have jurisdiction over international institutional financial institutions, but whatever the court says is very much valid, considering negotiations that will lead to that. So debtor states might be weaker with facing creditor states, and so if the court were to develop standards regarding sustainability of debt, in the sense that the sustainability of debt should be linked to environmental sustainability, and that debt is unsustainable if paying off that debt means you will not be taking measures to adapt and mitigate, or if it implies not being able to face climate change, then that's the essential or the core issue, sustainability of debt linked to environmental sustainability and human rights. Many times we've talked about or heard about environmental credits and how these could be compensated with debts. I remember some conversations a few years ago on this. Do states later use environmental credit to face the challenges of the climate emergency? It's a good point. There's much talk about the debt for climate action swap, that this debt be used for climate action. These types of swaps are not negative in themselves, but we should consider several aspects for them to be properly used. In most cases we've seen recently, they did not lead to a reduction of debt in states, and they did not really work as a swap for a significant portion of the debt states already had. So again, that is a problem. It's also, there's issues with accountability, transparency, the participation of different stakeholders to ensure that these swaps also help alleviate the debt. So it might be better to talk about debt reduction or debt relief for climate action. So it seems that we are still lacking international regulatory and national regulatory frameworks. Yes.
For Eulalia Petite Gabriel, thank you for being here on your wedding anniversary. Thank you. You talked about standing and identification and also being bearers of rights, and you talked about this before the court. This might not be the most serious concept that has been referred to over the last few days. But what has been referred to is the fact that people don't have much of a recourse other than to resort to strategic litigation about the climate emergency. So aside from your advice to the court and also about convention-based review, and this has been used already by the court, I mean, in past AOs, but the main thing is access to domestic courts, isn't it? Do you have any thoughts about this? Yes, absolutely. And I'd like to add, thank you for your question and for the opportunity. First of all, I'd like to say that I'm here thanks to my family. And secondly, this is not advice for the court. These are proposals or suggestions based on our own examination of the analysis of the possibilities in front of us and of the court. Of course, the court knows a lot more than we do when time comes to come up with alternatives. As to access to domestic courts, which has been talked about, there are several problems. One of them is difficulty of access, especially for children, as has been said. And another matter of great concern to me, specifically, which is part of the European case law, is access to courts with regard to the principle of extraterritoriality when that is applied. Because if we want to apply rights with this context, and let's say a Barbadian national wants to file a complaint against Brazil, I mean, the possibility, the fact that the person can't litigate in Brazil means that they'll have no access to the system. And these are issues that must be considered by the court quite carefully, because the issue of extraterritoriality may seem very attractive as a means of guaranteeing the set of rights, and there are certain diffuse rights here. However, it may lead to greater problems. The difficulty faced by the territorial state where you can litigate, which is your own, if you add to that the requirement of having to litigate in the defendant state, that means that you are multiplying the difficulty, exacerbating that difficulty that you just referred to, Your Honor. So I don't have the solutions. I am not a legislator either. But these are problems that are intertwined and that cannot be taken in isolation easily. Victim identification, exhaustion of domestic remedies, and extraterritoriality. We've touched upon only one of those points, but I think that there's a need for a systematic analysis from the strictly legal standpoint as to what the difficulties are that for something that might seem as an advantage initially. Thank you, Judge Gomez. Judge Perez Manrique, you have the floor. Thank you, Madam President. We've heard with great attention, listened to with great interest to everything that's been said. And first of all, I'm interested in the issue brought up by the Center for Gender and Refugee Studies about environmentally displaced persons for environmental reasons. And I'm going to ask you to focus on the following. We have international legislation or law that about migrants and displaced persons, and we know about that. You brought that up in your own submissions. My first question is, aside from the legal framework, the challenge in defining this category of displaced persons for climate reasons, or climate-induced displacements. Why am I saying this? Because people migrate for several reasons. And we might have actually 2 or 3 categories that come to mind. They migrate because their life is at risk, a matter of safety and security. They may migrate for political reasons, or for, and this is third category, accounts for most of the migrants, is for financial reasons. So what allows us to identify environmentally displaced people as a category, which is something that you talked about in your presentation. Thank you for that question, Your Honor. I fully agree with you. People are forced to migrate or are displaced for several reasons. It won't always be for a single reason, but there might be a combination of such reasons. As we see it, the climate crisis is a displacing agent in several ways. It could be directly through a hurricane, for example, that destroys a person's community, home, or where there may be direct effects on the person per se. And also, when it becomes a multiplier of such risks that force people out and to flee. And what we'd like to underscore is that the climate emergency must be borne in mind, and so must its effects as part of this comprehensive analysis that is going to be done case by case for in protection requests. What we've seen in the analysis undertaken by our center is that people who are forced to migrate can qualify for protection under the Refugee Convention. For example, imagine after a disaster, if there is no efforts are made by the state for assistance that is equitable and relief that is equitable across the state, and that some people are more affected than others, as was said by others in this session, as we see that certain rights are breached that are part of the right to a dignified life. And we see that this effect is the consequence of discrimination on the part of the state, then that becomes something that is liable for a refuge request. If we think about the Cartagena Declaration and events that seriously disrupt public order, UNHCR has said that the state must protect law and order, freedoms, and the population in general. And so that's whenever, in the context of a climate emergency, when an event takes place, be it a rapid onset, fast onset such as a hurricane, or a slow onset event such as a drought, then that can have an effect on law and order in the country, and or at least for some communities and some persons, and that should be considered as part of the universe of analysis to see whether the person should be protected from refoulement. So along those lines, I'm still interested in asking you about the obligations of the state in the framework of their obligation to respect and guarantee human rights. So clearly, the general legal framework of protection in cross-border cases such as these would be applicable. But do you believe that there might be problems involving the international legal framework for the specific protection of these displaced persons? And I'm talking about the principle of non-refoulement, and other principles having to do with migration policy in a part of the world where migration is a very important phenomenon and very widespread. So in the specific case of displacement due to climate change and across borders, that is, that the court should suggest as a standard a legal changes, I mean, at the national level?
I would say, to begin with, that we would ask the court that the states should interpret existing treaties such as human rights or refugees in the light of the climate emergency. For us, this would be a basis, and it upholds what we said in our comment, which is that it's true that the system, the internet, there is no specific international system for climate displaced persons, but it doesn't mean that people are not protected. Human rights standards and refugee laws already provide protection, as we have said. The states can take additional measures as well to reinforce the system of protection and to expand protection more clearly, more specifically, for people who are climate displaced. This is something that we understand that the governments of the region are discussing, among other things, in the discussion of Cartagena Plus 40, which is under discussion soon in Chile. In this case, how would you apply this case of environmental displacement and the principle of responsibility, of shared and common and differentiated responsibilities? What's the interconnection? Thank you, sir. That's a very good question. As you have probably noticed, this is something that we did not address directly in our comment, in our submission, but we understand how important this question is. I would think that, again, let's start with the idea that all of the countries are have the obligation to protect, and and Dr. Dietrich Jones said this as well. We understand, however, that not all the countries have contributed to the climate emergency to the same degree. So we reaffirm the principle of the law of refugee law on shared responsibility, where the states, the developed states and the states that have contributed more to the climate crisis can support developing countries, first of all, through efforts of mitigation, as we have been discussed, as other speakers have said, but also supporting these developing countries that are receiving climate displaced persons in order to strengthen their protection systems and strengthen their social systems in order to receive these populations. The climate crisis and the climate system, the common and differentiated responsibilities entail something else. I think there could be an opportunity for the shared responsibility under the refugee law could intertwine with the common and differentiated responsibilities that we see in the climate legal system, and we could see this as a way for the states to commit to receive more people who have been displaced because of the climate impact, be it allowing access to their territories or receiving them as refugees, temporary evacuees. There are a number of resources that could be used. There are proposals such as the Conference on Immigration, which the NANZ agreement, which can provide a basic guideline, and the same thing is true in Central America. Thank you for your answers. I closely followed the proposals by Professor Petit, Professor Gabriel, and Professor Jimenez. I would be interested in hearing you. You talked a lot about intergenerational justice. I would be interested in hearing you discuss your own concept of future. What are we talking about here when we discuss future generations? Along the same lines, you offered a proposal about determining possible victims, because this, you said it very clearly, this is associated with the idea of active standing for bringing grievances. So here we talk about the potential of victims. It is not a matter just for the court. It's a matter for juridical construction that is standing. I would like to hear you talk more about that. May it please the court, thank you very much for these questions, Your Honor. Judge Perez Manrique. With respect to the concept of intergenerational justice associated with future generations, in our paper, we started with the idea that future generations are the ones that have not yet been born. So our interest is to link their interests because they do not currently hold rights, because they don't have any existing legal personality, but associate that with the rights of people who do exist. And clearly, with the life decisions made by our young people, our children and young people, will these generations exist or not when we see the decisions they're making? And will the state decisions make it possible or not for their life plans to lead to future generations? So that's the position we've started with, and that's the concept of future generation. Regardless of the idea of intergenerational justice or equity, that has other dimensions and other applications. That is true. For example, the analysis about terminology that we saw about in dubio pro future generations, we can use the fact that future generations could be overburdened or could be experiencing the effects even greater than those we are experiencing now. So when you need to weigh a situation limiting current rights, as in the case of Ubonnet, we would then choose for the good of future generations by constraining current rights, but that's a whole different assumption. If we talk about intergenerational justice, we're talking about weighing the limitations on the rights of people now living. What we're studying is something else. It's an analysis of how we can protect the interests of future generations through currently existing rights. All of this fits into the system. They are simply different legal situations or problems. As for the concept of potential victim, this concept, for example, in your 1989 case in the framework of the European Tribunal of Human Rights, in this case, it was applied to a German citizen who had committed a homicide in the United States. The judges are familiar with this. This construction was used subsequently, for example, in the framework of the principle of non-refoulement, to develop the idea that a person currently in a state not subject to the convention who could be expelled, whether that expulsion constitutes an act of torture or jeopardizes the person's life, is whether it's a violation of the convention. There's a whole chain of action here, so it's theoretical. The relationship but you can see the relationship to the climate situation. Every step in the cause and effect. It helps determine who is responsible, and there's no clear certainty that chain will actually be finalized, reach its logical conclusion. But even then, the court felt that there was, in fact, a potential victim, and therefore it decided to protect this potential victim by declaring that there was a violation by the state. In this case, the Human Rights Committee. In this case, it would be the American Convention. So, thank you. Thank you. You've been very kind. Clearly, there are no homogeneous concepts about future generations, right? That is very clear. And finally, I would like to ask a question about the access to information on companies and human rights. Unquestionably, there are many different derivations of this case. There are the whole issue about responsibility of companies concerning human rights could lead in many directions. They could be read in many ways. But I would be interested in asking you about one of the suggestions you made, that is, the possibility of declaring certain activities as high-risk activities. How would that work? How would that principle work? If we have an issue here that's associated with, I would assume, first of all, these companies have always required prior authorization from the state, a permit under certain conditions. But what would be the consequences, please? Perhaps you could talk about that. Yes, let us say I could give you an example and talk about how the measures could work. An activity that is not always associated with the climate emergency, that is always associated with the climate problem, is mining. But mining has become a determining factor that makes a negative impact on the climate emergency, especially mining in the Amazon. So there's a contradiction here in every sense of protection, which is that in the first place they say we need to preserve the Amazon because it makes it possible to capture carbon, and therefore it's a strategic ecosystem. But the state at the same time issues permits for mining in that territory. So with this example, we have an activity that apparently is not associated with climate. Maybe it doesn't even emit any greenhouse gases. It's not associated with climate, but its operation, and in this case, does have a significant impact in a scenario where that could be mitigated. So what can the state do? How can the state take measures? First of all, we have the possibility of implementing moratoria in strategic territories that need protection. Another would be that the companies themselves should incorporate into their own business plans, in their whole value chain, the whole issue of the climate emergency is a central issue, and particularly everything associated with emission of greenhouse gases, but primarily a clear understanding in their supply chain that there could be partners or trade or business partners who in principle do not have an impact but would in fact generate an impact, such as the example I just gave. In the third place, invite the states to develop scenarios and mechanisms of information and transparency that are much more robust and would make it possible to find all the information that today objectively is being generated by the companies, but that is not publicly available, but should be. Because very often, as you have said in your own case law, are operating in the territories of countries that are weak institutionally speaking, and it's these countries that capture information and have information about territories and can make it public. And in this sense, as you yourselves have said in your advisory opinion on the right to a healthy environment, would make it possible procedurally and materially to lead to the effective exercise of this right. In this environment, in this same context, what about the right to development? How would that work? It needs to be a sustainable right in the context of the climate emergency. And how would you condition the players in the case of a company? Here, thank you for that question, Your Honor. It's important here because it makes it possible to do a number of things. First of all, the right to development, as we have said, goes hand in hand with the system itself. It's an integral part. It's a catalyst, because the right to development, as you said, is the sine qua non principle on which democracy is built. So if you put it into practical terms, how do you make that work? First of all, the need to guarantee effective participation by the communities that will be affected by projects, especially extractive projects. This is a critical component, because it makes it possible to develop their rights as part of development, which is the right to science and the ability to coordinate scientific knowledge and the knowledge is available in the territory, so that do this in making decisions about policies. This could be much more effective if the communities themselves are the ones who understand the specific impact on their territory. But of course, I would also invite you yourselves to develop measures and proposals in the fiscal area. This is very important. It needs to be done, and remind you that the Inter-American Court has been a bastion and a lighthouse in international law on a number of occasions, and this is one of them. You have been very creative in the past, and you can be again. And I would remind you that it was the case law development of this court that launched the possibility for participation of victims in the environmental impact studies. And you can do that. You can be urged, and I would invite you to be to make the Inter-American system the one that can push for robust regulatory frameworks involving companies and human rights. That's inspiring to me, because you've talked about our ability to be creative. So I would ask then, how do we apply our creativity to the principle that the polluter pays, internationally and domestically? Polluter pays.
The polluter pays principle has the potential to work, but it has adverse elements as well, as it only considers short-term impacts and quantifiable impacts. But if we're talking about the climate emergency, these are progressive, cumulative, sometimes permanent damage that objectively you couldn't really say if you emit a certain number of gases, it's fine. And this is also to do with the implementation of the REDD Plus instruments and other tools, such as carbon credit, that are imposing certain types of procurement that is unfair, certain forms of production and illegal appropriation of territories. So beyond that principle, I think you have the opportunity of developing the correlation between the precautionary principle the development and the right to science and building plural knowledge. And finally, very fundamentally, part of the proposal we've sent, introducing a risk-based approach and disaster-based approaches to face the impacts that are not going to be focused on a certain moment in time, but they vary based on different conditions and situations. So creativity is more towards that, to find a much more dynamic system and not the traditional doctrine of principle equals rule, but how principles interact in multiplicity of rules. Thank you very much. No further questions. Thank you, Judge Perez Manrique. Judge Ferrer. Thank you, Madam President. Since you have called on us, help us with our creativity. During your submission, you've mentioned risks and also investment treaties. Risks to human rights in the context of the climate emergency. What do you think this Inter-American Court could help in that sense, in our advisory opinion? What could we call for? I would call for three things. First of all, relating the principle of cooperation among countries. I think it's part of the backbone of the inter-American system. And it's really an invitation for states within the framework of investment treaties that they negotiate with third parties to consider their negotiations may have impacts on neighboring countries. That's not happening today. These types of treaties and agreements are not signed with that in mind. So this is something the court could call states to remember. Secondly, I think it's important for the court to call states to review the way they are building the principle of legal security. There has been much a very contractual approach in that sense. So very important figures such as a declaration of public usefulness or utility have been perverted and become tools such as in my country, Colombia. Mining has been declared publicly useful, even though they are not taking into consideration communities that have spoken against these types of mining or imposing mining activities without any type of consultation. Again, here you have a wonderful opportunity, and you can help drive this. There should be a real objective, a way to bring mandatory due diligence to the inter-American system. It should be binding, and it should have at least two instruments you could stimulate in the context of bilateral investment agreements. One, for there to be a possibility to include clauses to void contracts when these do not consider real objective impacts on climate and human rights. And secondly, to include the possibility of negotiating clauses that open venues to renegotiate agreements, including the risk-based approach as a way to force the renegotiation of contracts. So incidents related to climate change should be a criterion to include in contracts that could accelerate renegotiation to lead to substantial change. Thank you. Thank you. To the representative of CELS, Julieta Levin. You've brought an innovative topic here today. It had not come up before. The debt and the climate emergency, and the fact that international financial institutions play an essential role to have the money that helps us fight this emergency. It has somehow already been covered by the questions by Judge Gomez, but could you please elaborate? What obligations do you believe these international financial institutions have, and what is the source of such obligations? Thank you very much for the question. International financial institutions, for example, the International Monetary Fund being one of the main institutions of the sort, have the Charter of the United Nations as their foundation. So protecting human rights is an essential principle or within that. So if you look at their incorporating treaties, they include human rights. Beyond that, within the UN framework and looking at independent experts on foreign debt and human rights, have developed several valuable documents and guiding principles on the matter. And they highlight one of the main obligations of these institutions and even other types of creditors, which is the obligation to perform impact assessments, how the debt will impact the countries, the borrower countries. And here I go back to what I mentioned before on debt sustainability. If you analyze the sustainability of debt, today these analyses are just based on financial or economic aspects, such as whether or not I can pay it off, without considering that the payoff might be if I cut back on all types of funding for human rights or the environment. In 2021, for example, in Argentina particularly, the surcharges for the loan, not the loan itself, of the IMF in 2021 were the equivalent of the whole budget for the Ministry of Environment and the Ministry of Justice and Human Rights. So it is an enormous problem. The resources allocated are insurmountable, and that's the issue with sustainability. How can we enforce this? It's very hard. Ideally, there could be some sort of dialogue between the standards of the Inter-American Court and other human rights protection standards with international financial institutions. Ideally, they would speak to each other, but that's where we're headed. To add to this, we should also remember, in the case of the World Bank, for example, that the mandate of, or the board of the World Bank has as board members the states themselves. So the way this institution operates is how states operate. So it's not removed from that. The same interests operate, and different from other institutions where there might be a separation between management and shareholders. We don't have that in the World Bank. What avenues are there for public or private financing that could help vulnerable states avoid accumulating more debt? Today, 80% of climate funding is through loans, so more debt. And that's why most of the civil society organizations that work in these topics are saying that financing should work on the principle of common but differentiated responsibility. No more loans, but subsidies, grants, which are in a way a form of reparation, considering the pollution, the contamination that debtor states were not responsible for. Thank you very much.
I'd like to echo the words of congratulations to Professor Petit and her family. They're probably watching us. It's 8 p.m. over there in Seville. So you were talking about 3 avenues, right? And I thank you so much for that and for going into our rules of procedure, because in adjudicatory cases, we'll have to face this. And it could be done, you're saying, through Article 35.2 of your Rules of Procedure about litigation and collective victims, or through a reform to Article 35.2, an amendment to it, or else do what the European Court did through the potential victim jurisprudence. So you've talked about potential victims, you're familiar with our rules of procedure. So if we had to reform our regulations, how would you do that? Our rules of procedure, how would you do that? Well, that calls for a PhD thesis, but if it please the court, and thank you for your question, Your Honor, if there were a need to amend the rules of procedure of the court to prevent, to contemplate an exception, I mean, the climate emergency, you know, in spite of the criticism that has been leveled at it, I don't think. You know, one thing is having the criteria, the different thing is seeing how the European Court established those criteria in Clima Signorin. And this affects jus standi, and we're not talking about standing here, but still, at the end of the day, the idea is to define whether what a victim is, the status of victim, and when it's required. So an amendment, a reform where you could combine potential victims, that notion of potential victim. And if you'll bear with me for a second to avoid making a mistake, in paragraph 487, the European Court said that the requester should be exposed to a high intensity of effects of climate change, so that it's not a ratio popularis. It has to be a group of the population that is especially affected and at a high intensity. So there's the issue of the threshold set by each court, and also how to determine the burden of proof of that exposure. And burden of proof is something that has come up over the last 3 days. I'm not going to go into that, but all of that could be part of that discussion about that reform. And this paragraph also says that there should be a pressing need to ensure individual protection of the petitioner in relation to the absence or non or of steps or measures to reduce the damage. I don't think that's exaggerated, actually. And so I'd like to see how to determine the burden of proof and the level of the burden of proof, but still, so that it doesn't become a ratio popularis. But here, the damage has not yet occurred, so that's in combination with other options, and it could inspire a possible exception, maybe, to be included into the rules of procedure when you cannot prove the existence of damage itself, because it's something that would happen in the future, and who knows whether as part of a plan, life plan, people will have children or not, whether future generations will exist as unborn generations. I mean, but still we can determine that there is a potential victim. Or maybe the exception would be the identification of the victim, or at least there should be some specific elements having to do with the causal complexity involving these climate emergency damage. Thank you. And Professor Jimenez, going back to the life plan, you said an autonomous manifestation of a life plan. What does that mean? Thank you for your question. When we refer to a standalone manifestation of a life plan, what we mean is that any type of breach of the convention may lead to the impairment of development of future life, and it will no longer be a form of reparation. And when the violation of the convention occurs, then this effect on this impact would be generated on present and future generations. Thank you. And now going back to a question asked by my colleague Perez Manrique for the Center for Gender Refugee Studies. The issue of obligations, meaning CBDR, so community visas. So could you refer to that about cross-border migrations and this issue, humanitarian visas, and they're so complex. You mentioned this, but could you elaborate on humanitarian visas? Of course. Humanitarian visas can be used by states to facilitate access and entry of persons who are displaced by the climate emergency. And this would be used, this has been used at a low level in some countries in the region, if I'm not mistaken, Brazil, and maybe others that escape me at this moment. There are different programs that may be modified or expanded somehow so as to specifically include this population. And what I have in mind is specifically the United States, which is where my center is based. The US has a parole program, which is an entry program designed for certain nationalities such as Nicaraguans, Haitians, Venezuelans. So these programs could be expanded to include the specific needs of persons who are displaced due to the climate, and also temporary protection formats maybe. In the United States, there's the temporary protection status, which offers temporary protection to or provisional protection to certain populations when there is a disaster that affects law and order in their country of origin. These programs are used very sporadically and in a way that is not generous and doesn't guarantee rights. Part of our advocacy in the United States and in other countries is to try and include a climate displacement as part of this migration mechanisms that are already in place. I have another question about displaced persons due to the climate emergency. Are there legal differences vis-a-vis other types of displacements or disasters having to do with the climate directly, and others that result from disruptions to law and order as a result of climate change? So are there differences in determining how to determine those?
Perhaps not exactly differences, but in the determination of how it affects, whether or not it affects public order or whether there are human rights violations. What are the factors? The effects of the climate, so that the effects of the climate emergency could be included comprehensively in that analysis. It should be comprehensive then. Yes. Very good. No more questions. Thank you, Your Honor. Thank you very much to all of the people and organizations who have taken place in this block. Thank you for your valuable contributions to this court. We will now take a break until 3 o'clock this afternoon before we continue with the rest of the hearing for this first part of the hearings on this advisory opinion. Thank you. Please rise so the court can take its leave.
Hello? Oh. Okay.
I have like 2,000 tabs.
I think if my computer could speak, it would be like you. To learn.
The countdown clock will be there, no? In the.
Yeah.
Hello.
Oh.
Hacer el intento. Mira que ahí ya, ¿no?
Look at the distance of the mic.
Muy buenas tardes, señoras y señores. Vamos a reiniciar.
Good afternoon, ladies and gentlemen. We're going to resume. All rise. The court. Good afternoon to one and all. This hearing is called to order. On the matter of the request for an advisory opinion submitted by Chile and Colombia about the climate emergency and human rights. I will now give the floor to the Assistant Registrar to issue the necessary instructions about the rules for the participation in this afternoon session. Thank you, Madam President. This afternoon we will hear from the following delegations. One, Citizens Movement on Climate Change, Fossil Fuel Non-Proliferation Treaty Initiative, Oil Change International and Bank Climate Advocate, International Network on Climate Change, Energy and Human Rights, Grupo de Energía de Bogotá, Earth Justice, International Trade Union Confederation and Trade Union Confederation of the Americas, CSA, International Lawyers Assisting Workers Network, and 9, Pedro Calvay Torres, Claudia Lucia Castro Bernechea, Alicia Alessandra Huertas Meléndez, Daniela Alessandra Llanos Avilés, Roma Marcela Ortiz de Orue Riquelme, Marco Antonio Zelaya Castro, Claudia Rocío Crespo Chávez, Claudia Paulina Mamani Yauri, Vera Camila Delgado Díaz, Mercedes Alejandra Bueno Barra, and Franco Daniel Matías Urquiaga Chuan. And finally, Eduardo González Chávez. Please be reminded to speak slowly and clearly to facilitate the work of the interpreters, and please identify the person who is going to be taking the floor. Thank you, Madam President. Thank you, Madam Assistant Registrar. According to the order agreed upon, we will now hear from Movimiento Ciudadano Frente al Cambio Climático. Proceed. Good afternoon, Honorable Court. I'd like to thank you for inviting us and listening to us with such care. I'm here on behalf of the Citizens Movement on Climate Change from Peru, MOSIC, and as representative of the Board of Directors of CANLA. CANLA was created in Rio de Janeiro in 1992 during the Earth Summit, and since then we haven't stopped participating and advocating with our governments to make as fast progress in climate action. We have decided to speak about questions A1, A2, and B1.2. In the request for an advisory opinion, focusing on the outcomes of the results of COP28 in Dubai, specifically 2 points: the global balance of the Paris Agreement and the Just Transition action program, work program. We decided to talk about these climate-specific issues which are so important, and also to systematically recognize all actions and needs and mechanisms and alternatives for actions that are, albeit limited, are what we call the best available political consensus, if that does exist. The the global balance of the Paris Agreement indicates with alarm and serious concern three specific issues that human action, especially emission of gases, has caused 1.1 increase in degrees in increase in climate in warming since pre-industrial levels, that the impacts of climate change are being felt around the world by human beings, and that most of the adaptation responses are fragmented, incremental, specific to sector specific, and unequally distributed among regions. And in spite of the progress, there are still major gaps in adaptation in all sectors and regions, and they will continue to widen with the current levels of implementation. The global balance also acknowledges that climate change is a problem for humankind as a whole, and by adopting measures to face it, parties should respect, promote, and bear in mind their respective obligations in terms of human rights, the right to a healthy environment, the right to health, the rights of indigenous peoples, local communities, migrants, children, persons living with disabilities, persons in vulnerable situations, and the right to development, as well as gender equality, women's empowerment, and intergenerational equity. The global balance, or GSD, recognizes that in spite of the progress that has been made in terms of mitigation, adaptation, and means of application and support, all parties are not yet collectively on track to meet the Paris Agreement and its goals in the long term. And there is a need for deep, fast and sustained reductions in the emissions of GHG, by establishing specific elements in each document. Number one, to treble the renewable energy capacity worldwide and double the rate around the world by 2030. Step up efforts to progressively reduce the use of to phase out carbon-based energy and other fossil fuels, or actually coal-based, and also accelerate efforts around the world to reduce carbon emissions and bring them down to acceptable levels by the middle of the century, by mid-century, and accelerate the efforts to have energy that are zero net in emissions. There are many other measures in the document. However, it must be said that the instruments to make these to implement these measures at the national level and regional social and environmental safeguards and standards are not clearly established, and they're not time-bound. They don't have targets, indicators, instruments, strategies, or monitoring mechanisms, reporting or evaluation mechanisms to allow for active and democratic planning. Participation actually of civil society in the region. We need a common and coordinated regulatory framework for this to be effective. Based on the above, CANLA and MOSIC recommend that the following 3 sets of obligations be recognized. One, to remedial obligations, to take all necessary policy measures to remedy as soon as possible the current impacts of fossil fuels on territories, taking into account the right to participation of populations that are directly affected, identifying historical losses and damage sustained by indigenous nations and communities, creating processes for recognition, reparation, and restoration of their territory, culture, and collective property, improve healthcare and education and social protection mechanisms with an intergenerational and gender intercultural approach to establish participatory measures in decision making for all communities potentially affected in their territories and in their rights to a healthy environment. Prevention obligations. There should be a rapid, gradual, ambitious of exploitation, exploration, distribution, exporting and consumption of fossil fuels, especially those that are burned to create electricity, establishing goals, targets, mechanisms, standards, instruments, and measures that to be reported periodically, that to guarantee the ambition of speedy processes for the energy and ecological transition, bearing in mind the rights of those who are most fragile, to establish a moratorium on solutions based on geoengineering and mechanisms that may lead to risks. Establish a moratorium on logging and with full respect to ancestral territories of First Nations, to develop guidelines for strategic environmental assessments, and also cooperation, having mechanisms for monitoring, reporting, and verification for the application of rights and progress in the application of regional Latin American standards. Also introducing safeguards and standards for the reduction of emissions and protection of human rights in sub-regional blocks that for there to be due diligence in business, trade, and foreign investment. In the COP27, only 2 years ago in Egypt, that was the first high-level document interpreting the idea of fair transition recognized in the preamble to the Paris Agreement, recognizing the impacts of the labor force and also all stakeholders, in agreement with Principle 10 of the Rio Declaration, and at least in our region with the Escazú Agreement. In this way, the UAE transition work plan is one of the results of the recent COP28, which ended on December 13 of last year. Its preamble recognizes that the parties in addressing climate change must respect, promote, and take into consideration their respective obligations towards human rights. Based on the above, CANLA would like to posit to this court what it has been recommending to the states, which is 6 differentiated and or additional measures that should be taken, ensuring effective participation and prior and informed consultation when appropriate for all environmental, energy, and socioeconomic decisions having to do with the low carbon transition. Establish permanent governance and participatory multi-level, multi-actor design of agendas. Also guarantee access to information related to the energy transition. To design and implement additional regulatory instruments to improve the distribution of the burden and benefits having to do with the energy and ecological transition projects. Also to update or create instruments for land management in the country, especially those having to do with the energy and ecological transition. To design and implement with a full participation of local communities programs for ecological restoration in those territories that are considering the closing down of contaminating industries where fossil fuels are burned. We need to help the peoples of Latin America and the world to strengthen their social their social structures and help us protect all forms of life on Earth and their right to continue to exist. I'd like to once again thank the court for this opportunity to speak before it, and I will be happy to entertain questions.
Thank you for your minutes presentation. I will now recognize the Fossil Fuel Non-Proliferation Treaty Initiative. Please proceed. Good afternoon, Madam President and members of the court. My name is Andres Gomez Orozco. I'm here with my colleague Rohan Nantakumar, representing the Fossil Fuel Non-Proliferation Treaty Initiative. I'm the coordinator for Latin America and the Caribbean, and Mr. Nantakumar is our legal advisor, and we are grateful for the opportunity to speak to you here today. The initiative exists to demand a multilateral instrument that would regulate fossil fuel production and speed a fair, fast, and well-financed transition to set aside carbon, the use of carbon, oil, and gas. It's important to note that two of the states in this procedure have supported the process, Colombia and Vanuatu. In this region, we've also seen that Colombia, Chile, and Costa Rica are members of BOGA, the Beyond Oil and Gas Initiative, that also focuses on eliminating fossil fuel production. Our main position is that the production of fossil fuel is governed by human rights obligations of the states, and these obligations make it mandatory to move swiftly and equitably to eliminate the production of fossil fuels. We support our arguments by examining the role played by fossil fuel production as a cause or as a factor of climate change, undermining human rights, and Mr. Nanda Kumar will address the legal obligation to phase out these fuels. The role of fossil fuel production as a motor of climate change is unquestionable. In paragraph 1 of our written submission, we said that climate change is caused mainly by the growing accumulation of HGH gases in the atmosphere. The main drivers of this situation are fossil fuels. Once they have been extracted, processed, and refined, they generate emissions through combustion and industrial processes. We will talk here about the entire production chain. There is consensus that climate change has already caused widespread losses and damage. Many of the participants here have said clearly in their written and verbal submissions. 5 UN special rapporteurs and an independent expert in November 2023 said fossil fuels are at the center of the planetary ecological crisis, and their tremendous negative impact on human rights can be felt all along their entire life cycle, from exploration and extraction all the way to combustion and contamination. Fossil fuel extraction can also interfere with human rights. We explained this in paragraph 54 of our written submission, and this court recently held concerning human rights violations derived from extractive activities in the La Oroya case. Therefore, fossil fuel production must stop. The IPCC, on page 29 of its AR6WGI report of 2021, a summary for policy, people responsible for policies, said that the carbon budget should contain 67% of possibilities for not exceeding the 1.5 C threshold, and by January 1st of 2020, that was 400. Since then, issues per year have averaged 37, and especially the World Meteorological Organization said that 2023 was by far the hottest year on record, 1.45 degrees higher than the median for the pre-industrial age. Scientific sources, including the IPCC and the International Energy Agency, emphasize that remaining within the carbon budget of 1.5 degrees C, nearly 60% of the reserves of the proven oil and methane fossil gas reserves found as of 2018, and 89% of the carbon that same year should stop being extracted, and it's quite likely that infrastructure for fossil fuels must be removed. Despite this, the report production gap of the UNEP says that the government's plan to extract by 2030 more than double the fossil fuels that would be consistent with a path not to exceed 1.5 degrees. If fossil fuels continue to be produced, the more intensive hydrocarbon deposits will lead to more and more intense impact in the future. Therefore, it's essential to note in this advisory opinion that reference be made to the production of fossil fuels, and particularly removing them as part of the conduct that states must adopt in keeping with human rights provisions. I will now recognize my colleague, Mr. Nanda Kumar.
Madam President, Your Excellencies, it is an honor to address you. The loss and damage caused by climate change, referred to by Mr. Gomez and by so many other participants in these proceedings, are synonymous with violations of human rights. These violations are not merely coming, they are already here. Relying on findings by the IPCC, 5 UN Human Rights Treaty bodies stated in paragraph 5 in a joint statement of 2020 that adverse impacts on human rights are already occurring with 1 degree Celsius of global warming, and that every additional increase in temperature will further undermine the realisation of rights. For the reasons given by Mr. Gomez, these human rights violations can be traced back to fossil fuels. The essential point is this: fossil fuel production is the starting point in a chain of conduct that gives rise to and sustains dangerous climate change. The impacts of climate change have already caused significant harm to the climate system and impaired human rights. And in light of the best available science and the remaining carbon budget, we cannot avert the climate crisis and effectively prevent further human rights violations without rapidly phasing out fossil fuels. Accordingly, we submit that this court identify the obligation on all states to phase out fossil fuels, that is coal, oil and gas, in its advisory opinion. The need for states to phase out fossil fuels to comply with human rights obligations has been recognised by most UN Human Rights Treaty bodies already, including the UN Committee on the Rights of the Child in its General Comment number 26 at paragraphs 65D and 98D, the Committee on Economic, Social and Cultural Rights in its General Comment number 26 at paragraph 56, and jointly by 5 UN Human Rights Treaty bodies at paragraph 12 of the 2020 joint statement I previously mentioned. In our submission, the phase out of fossil fuels, or the obligation to phase out, arises in 2 ways. First, it arises for states whose acts and omissions over time, including with respect to fossil fuel production, have already caused significant harm to the climate and impaired human rights. These states, as a legal consequence of breach, must take legislative and other measures to swiftly phase out fossil fuels as a means of cessation of the wrongful conduct and also as guaranteeing non-repetition of the breach. Second, the obligation to phase out fossil fuels arises for all states as a means of discharging due diligence obligations arising under the Convention and other fundamental human rights instruments. This Honourable Court has made clear in its advisory opinion, OC 23 of 2017, at paragraph 142, and more recently in La Roja, in paragraph 126, that in exercising due diligence, states must, in a manner that is appropriate and proportionate to the level of risk, use all available means to avoid significant damage to the environment. Not some, not most, but all available means. In our submission, phasing out fossil fuels is an available and necessary means that all states must take to avoid significant harm to the climate. In carrying out that obligation, all states must act in a manner that is compatible with human rights law and is informed by the best available science. At least 4 observations can be made in this regard. First, given the intensity of human rights impacts and what the best available science is telling us, we submit that no new fossil fuel projects can be approved, carried out or supported, and that now there is a presumption that fossil fuel production generally is not compatible with states' human rights obligations. Second, any fossil fuel phase-out must be compatible with keeping warming below 1.5 degrees. Conduct which is not compatible with that will not meet the standard of due diligence required. Crucially, however, that does not mean that conduct that is compatible with 1.5 will automatically satisfy all relevantly applicable human rights obligations. It must be recalled that global warming of 1.5 degrees, as stated by the IPCC in its 2018 special report at pages 44 and 447, is not considered safe. Third, states must phase out fossil fuels swiftly in line with differentiated obligations by reference to states' fair shares for addressing the climate emergency. And fourth, states must not rely on false solutions and geoengineering technologies which are speculative and counterproductive of the obligation of cessation and which do not address the primary driver of climate change, which is fossil fuels. And finally, we note that the Republic of Vanuatu, in their written submission at paragraph 98, submit that another available measure for states to ensure a rapid and equitable phase-out of fossil fuels is to support efforts towards a fossil fuel non-proliferation treaty. We would humbly endorse and join in that submission. Madam President, distinguished members of the Court, thank you for your kind attention.
Muchas gracias por su participación, sus aportes a esta audiencia. Seguidamente,
Thank you for your contributions, and now I give the floor to representatives of Oil Change International and Bank Climate Advocate.
Thank you. Madam President, honorable members of the Court, respected Secretariat, distinguished representative of member states, members of civil society, academia, and youth, good afternoon. My name is Maria Alejandra Vesga. I am the legal officer at the Global Public Finance Team of Oil Change International. I'm speaking today on behalf of two organizations, Oil Change and Bank Climate Advocates, two organizations dedicated of transforming climate policies and practices of governments and financial institutions to end public finance for fossil fuels. We draw our expertise in the oil and gas industry, energy policy, and finance to rapidly respond to global policy and industry developments. Oil Change International has expertise in informing the public with reliable data analysis to expose the impacts of fossil fuels on people and the environment so that us, citizens, taxpayers, can be informed and exercise our rights to push our governments towards the much-needed transition to clean energy. Transition that is being delayed and is an essential element of a commitment rooted in the duty to phase out fossil fuels. My intervention intends to call the Court's attention to the public finance expenditures of states and underscore how ongoing financial support from governments facilitates the expansion of fossil fuel industry and contributes to carbon locked-in development, which exacerbates the climate emergency in violation of states' duties under the American Convention and other international human rights instruments. These obligations require states to respect and protect human rights. The duty to phase out fossil fuels is a human rights obligation. It is the gradual reduction of the use and production of fossil fuels to zero, and the strengthening of energy independence. It is part of the ongoing renewable energy transition that is hindered by the fossil fuel finance. And by fossil fuel finance, I mean those flows of money that go to and from governments and its institutions and the policies that impact this. As already mentioned by my colleagues, fossil fuels are the biggest source of greenhouse gas emissions, accounting for nearly 91% of CO2 emissions globally. However, we see governments, multilateral development banks, and development finance institutions financing fossils at closed doors, and their decisions are leading to climate chaos. Already at 1.5 and at 1.1 of global heating, we are already witnessing climate effects very intensely in this region. We argue in our amicus brief that states have the duty to phase out fossil fuel production and use in order to stay within the 1.5 limit and take all necessary measures to prevent further foreseeable harm to human rights caused by climate change, including those irreversible harms that will follow if we reach the 1.5 or farther. Our most recent report that assessed energy finance from multilateral development banks and G20 international finance institutions indicates that between 2020 and 2022, $142 billion was provided in international public finance for fossil fuels, almost 1.4 times their support for clean energy in the same period of time. In the region and in the world, Canada leads the list of the top fossil fuel financiers, allocating nearly $10.9 billion per year in international public finance. We need at least $47 billion a year in public finance that's allocated for fossil fuels to be shifted to support a just and clean energy transition instead. Public finance has an outside impact on energy systems and often acts as a subsidy, and international public finance is instrumental to meet or break international climate commitments. Protecting a livable climate and environment requires a fair phased out of fossil fuels production alongside a fast and fair ramp-up of energy efficiency and renewable energy solutions. as recalled in previous interventions on the relationship between the environment and human rights in regards with the recognition of obligation to avoid transboundary environmental damage. It is relevant to highlight the substantial contributions of states to enable the emissions of greenhouse gas emissions associated with existing and new fossil fuel-related projects and activities overseas and their compliance of the due diligence duty. I will hand over the floor to my colleague.
Thank you, Madam President, distinguished judges. I will address 3 issues that have been raised by previous speakers and to consolidate the thinking on the legal basis for fossil fuel phase-out, the role of public financing, and equity. The advisory opinion presents this honorable court with a tremendous opportunity to show the courage it has shown countless times in the past and make history by being the first international court to explicitly state that the undeniable evidence that fossil fuels have driven and are driving the climate crisis means there is a legal duty under international human rights and environmental law to urgently phase them out. As my colleagues have asserted, such a conclusion follows clearly from well-established international law that predates and applies concurrently with the climate agreements. But no international court has stated it plainly. It is critical to do so, and this advisory opinion, as the first to address human rights and climate change, is perfectly suited. The fact that fossil fuels are not explicitly named in the Paris Agreement does not mean there is no obligation to act on fossil fuels as the primary cause of the climate crisis. The phase-out of fossil fuels is not only a mitigation obligation, but essential to guarantees of non-recurrence and non-repetition of climate harm. We know that more fossil fuels equals more loss and damage. Public finance is a key aspect of state duties to phase out fossil fuels because finance is a form of state conduct that triggers state duties and can give rise to state responsibility when it breaches international obligations, including the duty to respect human rights, as we contend that financing for fossil fuel production and use in the midst of a raging climate emergency does. Compliance with the American Convention and international human rights law requires action to phase out fossil fuels, which means not just ceasing financial facilitation of fossil-fueled climate destruction, but shifting that finance to renewable energy and other required climate measures. Due diligence in the context of financing means that before any public financing is granted, states must assess all foreseeable consequences on the climate across the supply or value chain, including foreseeable upstream, downstream, and extraterritorial impacts, the emissions that flow necessarily and inevitably from fossil fuel production and use, regardless of where those emissions occur or where the foreseeable climate-related impacts take place. It's critical to understand these obligations with respect to fossil fuels in the context of common but differentiated responsibilities and equity. To make mitigation, adaptation, and reparation obligations equitable, there needs to be meaningful differentiation between countries. And there are available methodologies to distinguish based on cumulative historical contributions to the emissions driving climate change and economic capabilities in light of national circumstances to determine states' respective fair shares for all aspects of climate action, mitigation, adaptation, and climate reparation. Some of those methodologies incorporate responsibility for emissions under colonialism, which significantly increases the share that former colonial powers bear. Such differentiation is particularly important in this region, where the large majority of states are among those least responsible and with the fewest resources to address the crisis. In the context of financing, fair shares requires the biggest cumulative polluters to shift their financing away from fossil fuels the fastest, but also to provide financing to those least responsible for the crisis and bearing its greatest brunt. We respectfully urge the court to expressly name in its advisory opinion the primary cause of the climate crisis, fossil fuels, and the corresponding legal obligations to halt that destructive conduct and hold the industry actors behind it accountable, ensuring full reparation for the damages they have caused and are causing, not only by ensuring that polluters pay, but by providing guarantees of non-recurrence. The power of this honorable court in naming the fossil elephant in the room should not be underestimated. Many UN human rights treaty bodies, as we've heard, national human rights institutions, and some domestic courts have done so. And indeed, the UN Secretary General, perhaps most emphatically, in calling fossil fuels the polluted heart of the climate crisis and making many other clear condemnations of fossil-fueled climate change. But this court can bring those truths into the inter-American jurisprudence by making explicit that there is a legal duty to phase out fossil fuels, including funding for fossil fuels, which, by financing climate destruction, violates the duty to respect as well as the duty to protect human rights. Thank you, Your Honors, for your kind attention.
Muchas gracias. ¿Ha concluido su intervención?
Have you concluded? Yes. Thank you. Next, we will hear from the representatives of the International Network on Climate Change, Energy, and Human Rights. Honorable Madam President, distinguished judges and judges of the court, on behalf of the International Network of Climate Change, Energy, and Human Rights that my colleague and I are representing here, we would like to thank you for opening your doors to the diversity of so many voices and the opportunity to be part of this pivotal moment in history. We have 4 observations that we would like to share with you from our written submission: the recognition of the right to a safe climate first, the energy transition, fossil transitions, and climate mobility. The climate emergency has been said by the Supreme Court of Colombia, is a hegemonic planetary position that led us to adopt an anthropocentric model and selfish model, and in this way we will not be able to guarantee the survival of future generations, whether human or non-human species. Having a right to a healthy environment is essential to face these essential dangers and damage caused by the climate crisis. The court has a unique opportunity to develop this content to face the current and always deeper climate injustice with binding and consistent standards. The court could establish the right to a safe climate to bear in mind the importance of atmospheric protection and create a holistic protection under the convention. This right is also meant to broach the complexity of the relationship between climate change and human rights, which leaves many issues open to interpretation, many of which have led to the failure of several climate-related litigation, as cases mentioned here, and also the Duarte Agostinho and Carem cases before the European Court. The right to a safe climate has the potential to broach complicated dogmatic issues in a holistic way, and also to recognize explicitly that in order to face climate change, there's a need to deeply change the law, including the law of human rights. David Boy, in 2019, at the time Special Rapporteur for the Environment and Human Rights, said that a safe climate is part of the substantive elements of the right to a healthy environment. In the case of Laura Aroja, the court itself has developed the components of the right to the environment, including climate. After recognizing the rights to clean air and water, the acknowledgement of the right to a safe climate would be consistent and a consequence of this jurisprudential line of action. This may be an umbrella right of sorts, adapting the protection to the of the convention to the specific circumstances of climate change and protecting several subjects at the same time. In the spirit of the doctrine of public trust and intergenerational justice, seeing atmosphere as a common good that belongs to all and must be protected for all generations and species, opens the door to the interests and rights of future and even non-human beings. This development towards a holistic protection requires a dynamic interpretation based on the pro homini, indubio pro natura, and indubio pro futura principles. These, together with the precautionary principle, allow for the prevention and of future damage that defies traditional human rights system that only act when damage has occurred. Once it has occurred, the right to safe climate should establish common but differentiated responsibilities for mitigation and adaptation that must be timely and effective based on the best science available, and there's a need to adapt dynamically to ongoing progress. The obligation of mitigation calls for the issue of fossil fuels to be broached, which grew up to $7 billion by 2022. And due to governmental assistance during the spike in prices due to the invasion of Ukraine and the pandemic. This situation has led to a vicious circle because, on the one hand, there is a fight to limit global warming caused to a large extent by burning fossil fuels, but on the other side, benefits, licenses, and financing are being considered and obtained. So there's a need for subsidies to be phased out for these fossil fuels. I will now like to give the floor to my esteemed colleague, Armel. Thank you. And good afternoon. I'd like to once again thank you for this opportunity to come before this court on behalf of our network. I would like to mention two issues. First, the energy transition in the framework of human rights, and then climate mobility. As to energy transition as a key strategy against climate change in light of the obligations of mitigation and adaptation, we believe that energy transition is a key strategy to stop global warming. However, it must happen in the framework of effective enjoyment of human rights and of the rights of nature. In this complex transition, it is necessary to guarantee the inclusion of all parties, bearing in mind the principles of equity, inclusive participation, protection of labor rights, promotion of social justice, and respect for the rights of nature. That is why it is fundamental for the energy transition to stay within the law, where human rights and the rights of nature are respected under an integral approach, since both are severely affected by climate change. I think I spoke a bit fast. I will try to slow down. I will now move on to the second topic, climate mobility. And at this point, you must have realized that the main point behind our presentation is the holistic nature of these issues, because when it comes to climate change, there are many issues, there are many impacts, there are many causes, and oftentimes people get lost. And if you get lost, when time comes to translate the requirements in legal terms, in terms of rights and duties, you end up setting aside some of leaving out certain aspects, especially people and communities, especially when they're the ones that are most vulnerable. So I think that this will actually I will end up out of time, but still, as for proposals, respectful proposals to the court, basically, our first concern is to reach out to all persons in a situation of climate mobility. What's the issue at hand? There are two scenarios that are getting more attention. On the one hand, the sea level rises, especially in SIDS, and also persons and communities that are affected by fast onset events and extreme meteorological weather events that become extreme when they impact more vulnerable societies. And the risk is to leave out and unprotected whole sectors of the population that are impacted by, for example, slow onset phenomena. and that's not me, I still have a couple of minutes, the loss of biodiversity. And this scenario is invisible within the invisibility of the whole issue of climate mobility. Another scenario that is not seen and is hidden by others has to do also with energy transition, is measures to fight climate change or protect the environment. And we know, and you know better than anyone else, because you've said it in your current jurisprudence, that those projects can also have force people into displacement and lead to land grabbing. And this scenario is usually unnoticed, goes unnoticed. And another one that goes unnoticed as part of the invisibility is that of socio-environmental conflicts as a consequence of the other scenarios. And that's where climate change has a major role to play. So once again, the point of all of these scenarios being referenced to is to make sure that when time comes to establish parameters, criteria, and duties and rights, that reference be made to all scenarios so as to not leave large swaths of the population uncovered. And I think I'm out of time. Please conclude. Another example of the need to have a holistic approach is bearing in mind vulnerability and root causes, because people do not react mechanically to the impact of climate change. They pre-existing vulnerabilities will come into play, such as sexual orientation, age, gender, discriminations, for ethnic reasons, for belonging to an ethnic group. And so we have to take into account those vulnerabilities. Corruption is another one, impunity, even environmental impunity, poverty, including energy-related poverty. So basically that's what we had to say. That was the point behind our presentation, to emphasize this and to respectfully propose to the court that it include that graduality in there. Thank you.
Thank you for your contributions. I will now recognize the representatives of the Bogota Energy Group. Please proceed. Thank you, and good afternoon, Madam President, and ladies and gentlemen of the Inter-American Court of Human Rights, colleagues here at the table, and everyone at this hearing. My name is Juan Sebastián Ortiz. I am manager of public law for the Energy Group of Bogota. For my colleague Pablo Torres and myself, it is a privilege to be in this hearing with you, representing a business group present in Colombia, Peru, Brazil, and Guatemala, whose primary stakeholder is the city of Bogota, and that has been working for 125 years. We decided to offer submissions to this process because we, as a responsible corporate citizen and under the guiding principles for businesses and human rights, we are convinced that that every member of society shares the responsibility of supporting the states in their duty to guarantee human rights. As central players in the energy sector in Latin America, we are particularly interested in submitting technical information, experience, and openness to dialogue in order to offer clear and reasonable regulations that would allow the states to create and facilitate institutional conditions necessary to take on the climate emergency in a coordinated fashion. We were the only private company to offer submissions at the request of Chile and Colombia. Our participation is based on a commitment to act in conformance with human rights and our constant concern for the need to create legal stability in finding solutions that will respond to the challenges of climate change. The opinion that this court will issue is an opportunity to set clear, specific regulatory standards that would guide the coordination of all players, the state, private companies, social organizations, and communities, for taking actions that will lead toward addressing climate change. Unquestionably, this will promote quality and transparency of legal frameworks within which infrastructure projects need to be developed for energy transition, and also will create confidence among investors. Our presentation will divide it into 3 parts, summarized, of course, but broadly developed in our written submission. First, we will offer a brief introduction of the overall picture and context of climate change in Latin America, according to our own experience in the territory. Number 2, based on this context, we will then call out to the court for 2 points that we hope you would consider when you develop your advisory opinion. Finally, we will propose 2 sets of regulatory standards that the court could consider to ensure energy transition and mitigation of the effects of climate change. With respect to the context, even though this is a worldwide phenomenon, the experience of climate change is not the same in the countries of the global north as it is for countries in the south. The causes and consequences are not the same. It is for this very reason that the readings and proposals of the crisis must adopt a common but differentiated approach. In this sense, unlike what has happened in other regions, there are 3 main challenges that Latin America and the Caribbean are facing with climate change. The greatest is deforestation caused by the expansion of agricultural frontiers, changes in land use, monocropping, illegal crops, and trafficking in natural resources. The second challenge is structural transformation in the transportation systems that mostly use gasoline, diesel, and ethanol. Our region is experiencing the most rapidly growing vehicle ownership levels in the world, and by 2050 there will be more than 200 million private vehicles with a terrible impact. The advisory opinion should encourage mass use of public transport, and as said by the representative of the United Nations rapporteurs, the use of cleaner energy such as natural gas that will provide true leverage for the transition in countries such as ours. The third challenge is known strictly as the energy transition, that is to say, replacing fossil fuels with renewable energies. On this subject, the court should ask what would be reasonable goals for decarbonization in the context of energy grids such as those of Latin America, which have high rates of renewable, conventional renewable energy and a growing demand for energy. How to guarantee replacement of energy sources that have a heavy impact on human health, such as fuel, wood, or diesel, without jeopardizing the vulnerable populations that use them? What is the environmental and social cost of a rapid transition? How can our countries make the best possible use of the limited financial resources they have available for achieving objectives that require large investments? We would encourage the court to refer to these factors in its opinion. That is, first of all, include standards on mitigation of deforestation. Also, as Judge Perez Goldberg said, specific guidelines on transportation, and weigh the rights associated with mitigating climate change with other rights. It is important to remember that the amount of financial resources needed for mitigation and adaptation to climate change is exorbitant. Our governments, our taxpayers, and our investments are the ones who need to take on the burden of transition in a context of extreme resource shortage and innumerable unmet human needs. High costs of credit, high interest rates and inflation rates, and a complex geopolitical energy setting limits the ability of states and markets to finance the transition. Faced with all this, the Bogotá Energy Group would like to call on the court for 2 things, and respectfully. First of all, it's necessary to adopt and set clear, reasonable rules that are sensitive to the specific capacities of the countries to fight climate change. The court must avoid ambiguity and guarantee regulatory consistency between the international mandates of human rights and commitments based on international climate change instruments. These rules should also respect the conditions necessary for investment. Number 2, it is urgently necessary to emphasize the role of energy as a right and as a necessary condition for expanding human rights and sustainable development. We would remind the court of the tension between those who defend this slower, more well-planned transition without denying the reality of climate change and those who call for a fast-moving energy transition. The Bogotá Energy Group believes that in any case, we must never lose sight of the fact that energy is a mandatory facilitator for the exercise of the fundamental rights of everyone: education, transportation, food, free movement, and so forth. We think this advisory opinion is an opportunity for the court to attach to energy its proper role and express its importance and that of the sector responsible for developing it. We would suggest two sets of regulations that should be considered in the opinion. We think it's necessary to guarantee that there is shared responsibility among everyone in addressing climate change and developing business activities from a human rights perspective. Number one, the court should demand that the states readjust their regulatory systems and adopt public policies to guarantee clarity, stability, and sustainability in regulatory systems. This would encourage the development of infrastructure projects that mitigate climate change and promote access to energy. Such changes would need to include, as a top priority, a environmental cost-benefit analysis that would entail not having the infrastructure for providing essential public services and a study of the material and differentiated impact of every project. Number two, with respect to the shift from fossil energies to renewable energies, understanding the interdisciplinary and multisectoral character of transition, the court must set standards that would facilitate a clear, orderly institutional framework for financial, environmental, and social planning of the transition process, bearing in mind the specific needs and impacts of every state, organization, and company that are here today. Respected members of the court, we here are offering the technical experience of the Bogota Energy Group. We have shown that the interdependence between the right to access to reliable, stable energy and human rights and the environment and sustainable development. Thank you for giving us this opportunity to share ideas, suggest questions, and emphasize circumstances so that the court's decision on the climate emergency would not jeopardize energy stability or social and economic stability in our countries. We trust that the court will take all necessary measures to translate human rights into practice and reality in Latin America. Thank you.
Thank you for your participation, Bogota Energy Group. And now I give the floor to the judges for questions. Judge Patricia Perez Goldberg, would you like to ask any questions? Yes. Thank you for all your presentations. I would like to ask those of you joining us here this afternoon if you could please share some thoughts regarding an aspect that has come up time and again during this advisory opinion, and you also have referred to, which is changing the way we move, the way we use transport to move around. We've heard that we should decisively move towards a phase out of fossil fuels. So if you look at the different recommendations and observations we've heard, you might understand there's three levels as to how transport is organized. One is to reduce the use of transport in itself. A second way would be to be sure that you would have to transport yourself or commute in shorter distances and finding a way to make it less polluting, and that leads to also the reduction of fossil fuels, as we've heard. And one line of work that has been explored by different organizations or is being explored in civil society is to think about remote work or telework not as a single measure, but as one way to address this need to reduce GHG emissions, especially considering that land transport is one of the most contaminating activities and that has a clear impact to global or influence on global warming. If you could please share some thoughts regarding this. Of course, it's not the single way, but a way to complement, along with others, to reduce that towards this goal. Thank you. Thank you, Madam Judge. We believe that the decarbonization of transport should go hand in hand with acknowledging dignified transport as a right in a city and in countries in the region overall. And this entails reducing transport, making it less contaminant, and making it more dignified. So a multimodal way of transport, prioritizing pedestrians in the famous triangle of urban transport, prioritizing pedestrians and non-motorized transport, and also mass transport of passengers, to displace the logic of introducing electric vehicles or electric transport as an alternative. We are actually looking to do it differently, to first prioritize dignified transport and non-motorized transport, to prioritize pedestrians. Thank you. Just to specify my question. As we've heard, we are in an emergency situation. We need immediate action. So the question is, while we change the matrices, while we can do this, how to implement urgent measures to, right now, reduce global emissions. So it's not one thing or the other, but how can we, along with other measures, move towards that? So that's part of what I'd like to hear about. Thank you for the question, Your Honor. Some elements we can contribute to understand how transport is the main user of fossil fuel. That happens in all energy matrices in the world. And if we look at the global energy matrix, we see there's a clear issue there. So you've mentioned specific points. We could go to the first one, which is understanding transport as a right that can be weakened because of privileging individual transport, whether fossil gas, gasoline, or electric vehicles. So in our submission, we refer to the limitations we have for carbon budgets, that we're basically at 1.45 degrees today in 2024. So how we are privileging energy that should be used in terms of energy justice to access energy in communities that don't have it. And we're actually privileging this to the SUVs, the larger trucks that receive so much gasoline, and then you can start asking yourself about freedom. So the first element is how public transport, dignified transport, should prevail, and non-motorized transport should be the type of transport to take in these urgent lines of action considering the emergency. And it's also interesting to see how different cities, if you go to surveys in commuting distances, most commutes in large cities in Latin America are by foot. So investment can be very smartly directed towards that, towards facilitating non-motorized transport instead of privileging individual transport. We should also say that individual electric vehicles is exactly the same because it goes to the same type of extractivism activities, whether it be lithium or others, still privileging individual transport. And an additional contribution could be how the fair energy transition would also entail cultural patterns and changing our cultural patterns. Today, part of that, the large use of fossil fuels that are expended in transport also are used to transport material, for freight transport, for our food. So there we see that if we start stimulating new local or locally grown food, and that our food model should be in the areas surrounding our cities, then we are also going to use less fossil fuels. So, for example, in Colombia, 90% of diesel is used to transport freight, and that freight many times is merchandise, and 90% of gasoline is for particular vehicles or individual vehicles, whether motorcycles or cars. Thank you. Thank you.
Yes. So on our public finance perspective, to address the transport issue, that for the region it's very important and relevant. We address specifically the point of using public finance as an alternative use of fossil fuels finance to divest in infrastructures that facilitate the energy transition. We can say that the public finance institutions should be mandated and have specific targets using their finance for public transit. And this means facilitating those ways of energy or, well, mobilizations that are low carbon emissions. Would you like to elaborate?
Thank you, if I may. I certainly agree that in light of the emergency and the nature of states' legal obligations, as we heard from our colleague earlier, that they must take all available measures, all appropriate measures within their means and power that are capable of rapidly reducing emissions and avoiding further human rights violations. And that certainly includes measures that would transform the transportation system in structural ways. But I think it's critical to look upstream, that the seeds of that change will not come from one individual alone choosing one individual mechanism for transport. But if we look at how the regulatory system and financial structures are skewed in favor of fossil fuels, that can help level the playing field and make it more possible for the available alternative forms of transport to rise. And that means that by shifting funding out of fossil fuel subsidies, direct and indirect, that liberates a lot of financing for renewable energy and other infrastructure enabling environments that would allow such alternative forms of transport to flourish. I also think it's important to keep in mind the broader picture of the relative percentage of emissions that come from transport as opposed to energy use in industry. It is, of course, very significant, but we know that the lion's share of the emissions are coming from energy and industrial uses, and that is critical to keep focused on, and that is fossil fuels used for those purposes. And finally, just because I think it's illustrative of just how significant reliance on fossil fuels is in terms of overall impacts, even in the across the transport sector. I believe it is something on the order of 40% of all cargo on ships in the world is fossil fuels. And just to grasp what that means is that we are moving fossil fuels around the world on ships that are themselves creating emissions, so that by reducing production and use of those fuels, we will be directly and indirectly reducing the emissions generated both through their transport as commodities and cargo and through reliance through individual forms of transport and infrastructure and the like. But that obligation to shift financing will liberate available means for other alternatives. Thank you.
Would anyone else add anything? Just briefly, we fully agree with colleagues. And as you've said, a combination of measures is needed at once, because these structures that are truly needed take time to be established. So first, we would have to change our culture and move towards using bicycles, for example. But it's not just changing that culture. It's to ensure there's a safe structure for people to use this. And at the same time, since cars are not the best way, because not everyone can use an electric vehicle, because we might not even have the natural resources to do it. And in Germany, for example, we might say, okay, let's all switch to electric vehicles, but then we are going along the same extractivist colonial ways that we should leave behind. So there are ways to do it, car sharing and others. There's measures that have to be taken at the same time. Thank you. Thank you. Thank you, Madam President, for your question. An urgent and immediate measure would be to switch to gas, switch transport systems to gas. The emissions of gas compared to other fossil fuels are lower, and this would have a very positive impact in particulate matter, because it does not create the same level of pollution, environmental pollution in the air, as other fossil fuels. That is an intermediate alternative considering the limitations of electric energy to move the types of transport systems we have today, not just in terms of increased demand of energy by electrifying all transport, and the limitations of technology for existing batteries. And in our countries in the Andean region, just going up a mountain, you need a certain power, and we just are not there in terms of the technology of electric vehicles. We cannot say that all transport can be easily made electric. And emphasizing pedestrians could have a distinctive impact on people with reduced mobility or with disabilities, so we should focus on mass transport. But if you are asking for a quick measure and urgent, that could be a possibility, a good alternative. Thank you. Thank you very much. Briefly, please, if I may. It's very important to say that gas is also a fossil fuel. It's another one of the fossil fuels we should leave behind. So just remember the science and how methane emissions, the main component of fossil gas, is 86 times more potent in terms of climate change than carbon dioxide. So there, of course, obviously, if you burn gas, it's 30% less CO2 emissions only than gasoline and the rest of fossil derivatives. But the big issue is with fugitive emissions. So in the U.S., for example, in the Permian Basin where they're doing fracking, about 10% of gas that is exploited is in the atmosphere without burning. So gas is not a solution, and it has to be understood as one of the main ways to reduce GHG emissions is precisely leaving gas behind. And in the region, we have potential for renewable energies and other types of discussions. Gas, just as other fossil fuels, should absolutely be left aside and advance in other manners.
Thank you, Judge Perez Goldberg. Judge Veronica Gomez, please go ahead. Thank you, Madam President. First of all,
Nanka Kudma. You were very emphatic. You were talking about illegal conduct. You were talking about illegal conduct. You were very emphatic about that. What were you referring to when you were talking about illegal conduct?
Thank you, Your Honour. I was referring to the conduct that has occurred since the very beginnings of industrialisation and relevantly since the earliest understandings of climate risks in scientific and policy circles. That conduct, be it acts and omissions with respect to the governing
Get closer to your mic, please. We can barely hear you.
Apologies. Would you like me to start again?
Yeah.
I was referring to the conduct that's been ongoing since industrialisation and relevantly continued since the earliest understandings of climate risks in scientific and policy circles in respective states. That is conduct in terms of acts and omissions which states have engaged in with respect to that chain of conduct that we referred to in our submissions, beginning with fossil fuel production. That, over time, as a composite act, is one that has already caused significant harm to the environment and the climate system and ergo impaired rights. And as a result of that, the law of state responsibility would have it that there are legal consequences, and the consequences comprise of cessation of that act to stop it, and that must involve
Okay,
phase
thank
out.
you. Thank you. I just wanted to understand. Then either to you or to Mrs. Gomez Orozco, I'll do it in Spanish. Just in
the model of the Non-Proliferation Treaty is a model that has been very important in Latin America. We have the Tlatelolco Treaty on the nuclear non-proliferation, for example, and this continent, at least this part, doesn't have any nuclear weapons thanks to that commitment, and it's an international treaty. But how can you use this model? And I'm very interested in the name. I'm struck by the name of your organization. How do we use this for this other issue? Why this model? Do you believe it's feasible? Because when it comes to nuclear energy, nuclear weapons actually, this technology is still in the hands of very few states, so it's easier to sign a non-proliferation agreement. So do you think this is a feasible model?
Your Honour, I'll start in broad strokes and then Mr Gomez will continue. The model is feasible and necessary because there is no instrument that is regulating fossil fuels as yet. And although our position is that existing law does regulate fossil fuels, it would be, in order to take the action that is required, that the kind of framework in terms of the structure and architecture that the Nuclear Non-Proliferation Treaty has embraced is extremely helpful. And indeed, as this court would appreciate, treaties are not only to create new law, they also codify existing law. And a very important contribution of this court in its advisory opinion in explaining how human rights law governs fossil fuels will be of great assistance to states as they attempt to codify what law does govern fossil fuels in a treaty instrument going forward. Mr Gomez might like to expand.
Y añadiría a la explicación.
And I'd like to add to that explanation, Madam Judge, how other protocols, the Montreal Protocol and the treaty on anti-personnel mines and the Convention on Chemical Weapons have also been useful along the way. And the initiative of the Treaty for the Non-Proliferation of Fossil Fuels is an initiative that indicates that the main threat to life is fossil fuels, and that's at the center of all of our lives, and it needs to be treated as such. It's a collective construct where equity and transition pathways and the economic opportunities created in the countries that are more dependent, more fuel fossil dependent, should be taken into account. So there would be this interstate, state-to-state cooperation, and that's why we place it in that basic area of treaties and along this path, which we feel should be faced in that way in terms of human rights protection. All right, let us move on now to common but differentiated responsibilities. In English or in Spanish? In Spanish? In English?
It's directed to you. So, how do we calculate fair share? Okay, how do we calculate fair share of differentiated responsibilities, in particular?
Yes.
Population, high historical emissions, low historical emissions, current levels of emission, which are the parameters? The court is very concerned about that because everybody speaks in general, but no one is specific about this so far. So,
yes,
help us.
I fear I won't give you the specificity you desire, but I'll do my best. So, this issue about concretizing CBDR is a live one, or differentiation generally is a live one. At the outset, I think it's important to observe that in the context of climate change and the regime, differentiation turns on two factors. It turns on historical contributions and it turns on capacities and capabilities. Yeah? Historical contributions to climate change, those are ascertainable. Relevant capacities and capabilities of states, those are ascertainable. Drawing from both in order to come up with a fair share is something that reasonable minds might differ about in terms of methodologies. But there is extensive scholarship emerging and submissions being put in courts below and adjacent to this one that draw on that. And so I think the key point for present purposes is that determination of a fair share is possible. A court can form a view based on much research and development of argument in the course of litigation about what might be appropriate, because what is fundamental is that being able to have a fair share, knowing that one can do that, that is gold, because once you have the fair share, that operationalizes, or that allows CBDRC, Combat Differentiated Responsibilities and respective capabilities, to be operationalized, and it can run with a whole bunch of existing tools that is recognizable to courts. So, for example, in deciding what the zone of reasonableness is, or what constitutes all available measures that a particular state may have, that can be considered by a court by reference to what the fair share is. Similarly so from practice, the one example that comes to mind is that scientists from the Stockholm Environment Institute and from the Institute of Governance and Sustainable Development have used one methodology of a fair share to be able to calculate what phase-out timelines might be. And so the fair share is crucial and is the key to operationalizing CBDR.
Okay, I understand. Just don't scare me by saying that it needs to be done by litigation. That's really bad for everybody involved. Okay. Anything to say?
Si me permite agregar, señora juez.
If I may add, in concrete terms, what might be said in response to your question is that there are per capita capabilities in certain countries that allow for specific differentiation. Countries such as Norway, for example, where their GDP is not highly dependent on oil income. So their fair share would be different, and they would phase out these fuels much faster than a country such as Angola, which is highly reliant on hydrocarbon income. So that's, of course, a collective construct, and that's the idea behind this treaty initiative, that this be done as sophisticatedly in a sophisticated manner as possible, to be able to find a way to do it in an equitable way. And we have a few ideas through GDP, for example. Thank you.
Perhaps we could move along briefly to the International Network for Climate Change. You talked about comprehensiveness or integrated measures. How can we take those concepts and work them up together? Fair share, highest possible emission, all of that. How can we fit it together? International Network on Climate Change. International Network on Climate Change?
Yes.
Could you repeat the question? You said that the common thread in the presentation was in integratedness or comprehensiveness. You said it very clearly. Believe me, you're all witnesses. How can we fit together these concepts, fair share, highest possible emission, and do so on a comprehensive basis? Thank you, Your Honor. I think that here the question is basically has to do with the questions that were asked over the past 3 days. That is, what are the specificities of the court as a human rights forum for addressing climate change? And, for example, to cover this whole issue of mitigation, but not just mitigation. I think that here the focus, I don't want to detract from the issues that you mentioned. For example, that is the responsibility of the states, but I do think that here we could go back to the specificities of this court. That is to say, an approach that begins with the need to protect people and communities. I think that it is something that could perhaps be developed somewhat. I think that here there are a number of issues that obviously will be covered by the International Court, but I think there are points here that are truly specific to human rights, especially in the context of the Americas. For example, let's think about transportation. What is the specificity of a comprehensive approach to transportation? To begin with, mitigation, obviously, to prevent, but prevention is not just a call to a theoretical call or wishful thinking. Instead, here there are very clear obligations. Here we have the scenarios. We need to avoid reaching those scenarios, and the court has already developed a whole body of rules. My point here is that the comprehensive approach means to mobilize what we already have. Positive law, get it moving. That involves prevention and also rights of access, guarantee and non-impunity, guarantee the fight against corruption, whether you can see that in the scenarios. Then we have needs for protection as well, once transportation becomes available. So my point, without wanting to, I don't want to monopolize the floor, but I think the climate emergency is not just a question of deciding which state is responsible, how to run an international fund. I'm not saying that these things are not important, but what I am saying is that in our reality, in our day and time, there are people and communities all over the Americas that are suffering already from the impact of climate change. I think, therefore, that we should perhaps focus a bit more on practical matters. Also, with respect to climate transportation or mobility, there's a great deal of focus on the island states, and that is as it should be. But I can also say that today, in Mexico, in many of the states along the coast, in the state of Tabasco, there are entire communities that need to be relocated. They can no longer live on their land. Their lives are in danger. These are very specific situations where I believe a comprehensive approach can be adopted because we can talk about mitigation, adaptation, and loss and damage. Not a fragmented view, mitigation over here, adaptation over there, and loss and damage somewhere else. Rather, we need a holistic approach that would consider all these things and translate them into legal terms. Otherwise, in the day-to-day work of the court, with your cause and effect approach, I think this is what will be proposed, and I think the parameters can be an answer, a response to that. I promise I will be brief, but what are the specificities of a court such as your own in terms of climate transportation? It needs to be a focus on protection, not on flows, traffic flows, not on how to manage suffering or how to monetize suffering, but rather a focus on protection, and there the court already has tools, mechanisms, and corpus juris. Thank you. Finally, Mr. Ortiz, thank you for appearing in this hearing. It's very important to have your viewpoint. I was expecting more opinions of this kind, offering solutions, because that is important. It needs to be part of the dialogue. With this concept of stable, reliable, and sufficient energy, and the clarity and sustainability that you talk about, it would not appear that we are. Don't you think that we are still trapped in the same business model? What you said seems to leave us, this talk of energy foreseeability. Yeah, I know that you have to provide use day after day. You have to provide transportation. You have to provide everything. Services such as water also depend on this. But to supply the population, I understand that. But at the same time, it sounds like we are still validating the same old, the same business model. that we started to develop at the beginning of the 20th century, and it became stronger when we stopped using the train and started using highways, because it was someone's business model, not because it was better to use the train, simply because someone wanted to make more money. So it would appear that it would appear to be counter to the historical process where cycles run their course and we move along to another model that's more efficient and more beneficial for society. All this talk of stability, sustainability, clarity, and legal sustainability that you are calling for, doesn't this leave us stuck in the same business model that we had in the 20th century? Thank you, Your Honor. I think that a 21st century company such as Bogota Energy, which has gone through this model and used it today in 2024, has a different approach. And human rights have evolved, other things have evolved, and they have placed our company in a situation where we cannot merely respond to the business model of a private citizen, but instead guarantee a fundamental rights, which is the right to access to energy. I'm not talking about business models for private citizens. There isn't I'm not talking about the energy grid. I'm talking about business models for electric companies, power companies, oil companies, that business model. Yes, ma'am, unquestionably. We do need to distinguish the extractive companies from companies such as the ones that distribute energy and transport gas, because they guarantee different rights and they have a different body of regulations from those of the typically companies that extract fossil fuels. But in that sense, I think the human rights approach today means that this business model is radically different from what we had 100 years ago. And the guarantee of rights, the protection of those rights, necessarily means that there are regulatory frameworks that are stable and clear, so that private enterprise and state investment can have stability in terms of remuneration, definition of investment plans, definition of planning, financial planning, environmental and social planning of transportation. So no more change? So we don't change anything. We just stay where we are. Nothing will change. If I may, could I add something to that? I think that what we want with all of this is to draw attention to the importance of having clarity. We're not saying that the legal system has not evolved, or that nothing can change, or that measures cannot be taken at a certain specific moment, but we think that right now there is no certainty as to what energy transition model is being adopted by our countries, and we do not have clarity about how this access to energy can happen. It's necessary. It can offer benefits to human rights, and it requires enormous investment. If you need to invest $10 billion, for example, in a plant, how will you do that? How can you do that investment? And I think in that sense, saying that we need an idea as to where we're headed, what are the priorities, I don't think that's the same as demanding that legal frameworks should not evolve. In that sense, I think it is a different approach. The type of legal certainty that we are crying out for right now is not exactly the same. It's not that it doesn't change. It isn't that contracts can't change. It's that if contracts do change, we need to understand why, what we're trying to accomplish, what direction we're going. And this way, we can know what to do with our resource investments. Thank you. Thank you.
If I may, Madam President, only if Judge Gomez needs it. It's the only opportunity we've had to hear from a company. So I believe it is fine for them to state their position. It would have been good to hear from other companies as well. It's the only one we do have. And we appreciate the fact that they have come here to state what they have to say. I've heard the answer already. We've heard about gas already. It was quite valid as well. So if we may, let's leave it at that. Thank you. Thank you, Judge Gomez. Judge Perez Manrique, do you have questions? Yes, Madam President. This debate and in this panel has focused on fossil fuels. However, the International Network on Climate Change, Energy and Human Rights states that livestock farming and agriculture also play a role, an important role, regarding consequences such as drought, loss of species, loss of habitat, deforestation, and the water footprint. So I have 3 questions as to that. I will pose them all together. First, what mitigation measures could be taken, especially immediate measures, but also over a longer term, and what parameters can be used to determine whether an agricultural or livestock practice is sustainable or not aggressive towards the environment, and if you have assessed in the affirmations you make how this could affect the food chain and how it could affect vulnerable groups and people with less resources. Thank you very much, Your Honor. Unfortunately, though, this is collective work from our network, and we do not feel fully capable of answering for the person that covered this topic, because this is all their work. So if it pleases the court, we can certainly send a written answer to this by the person that was in charge of this part of the amicus. We appreciate it. Thank you. The court will later determine that. But it is very important, because this might seem we're just talking about whether or not to use oil, yes and no, and there's a series of additional factors in contamination. So I'm concerned that from everything we've heard today, these will have social consequences, and no one has referred to these, because if I reduce the use of oil, and then someone would need fuel or energy to prepare their food every day, to just use water, it multiplies its price because there's less production, and that's the market play regarding oil. So I have not heard about social consequences of these measures. But of course, I am not trying to give any type of evaluation on the measures as such, but how are we measuring consequences? Along those lines as well, Oil Change International and Ban Climate Advocacy states that when talking about emitters, that Brazil, Mexico, Argentina, and Venezuela are at the top of are the top producers of oil and gas, and Colombia is the main provider of coal in the region. So we're not talking about first world countries here. What is the relationship between producing countries? In many of these countries, production is by transnational companies. Not in all cases, but I think for most it is the case. So these are foreign companies that are exploiting oil. So we're attacking the producer side. And again, I'm worried how to reconcile this, because behind the state in these countries, we have people and human beings. So I'm concerned about how in the transition will the most vulnerable sectors or how can you compensate sustainable development with the change of an energy matrix in this case, and who will pay for the party?
Sí. Sí,
I apologize. I asked the question to Oil Change International and Bank Climate, so it's you, right? I don't have the names. I'm sorry. I apologize. Then that's why I've named the organization. Please go ahead.
I will answer in English because I have the information in my head in English, if that's okay. Yeah, indeed, we mentioned this and we highlight this data about our region. Although these countries are contributors of fossil fuel finance, they're also recipients of international public finance. And this is also a question that we'd like to highlight here in the court. Yes, we aim for transition, but instead of allocating public funds to fossil fuels, countries should instead have ambitious policies to transfer these funds to cleaner ways of energy. We say that countries should say no to fossil fuels, and in this way also strengthen their public policies that in some cases are full of loopholes, facilitating the expansion of gas as a fossil fuel through the ways of subsidies, taxes, or concessions of finance. We would also say that the ambitious towards the cleaner ways of energy would also instead meet energy needs and energy demands. I believe my colleague wants to also complement this question, if you're not allowed.
Señor juez, si me permiten.
If I may, we are talking about equality in how there are historical responsibilities in certain countries that are more dependent on fossil fuels, and also that we're talking about the economic terms this can entail. In the case of Colombia, our country depends 50% on oil exports, oil and gas that it does not have, knowing that proven reserves in Colombia are just 0.1% of oil and 0.05 of gas. So we are at a crossroads, and this is similar in the whole region. We are not producers of fossil fuels, but we are greatly dependent upon them. And there is where we have to ensure we build equality that I would suggest, which is based on contributions, in the historical responsible parties that today we can locate them as large power oil extracting companies that have great capacities. In the simplest terms, we can think of in terms of GDP that are much less dependent than our countries. So there is something you can elaborate looking at equality. And I insist, we insist, it has to go deeper than this, but there are ways of doing it. I can bring this to your consideration. The Civil Society Equity has prepared a document. It's still a work in progress, looking at these types of factors to ensure a just use of fossil fuels, or just phase out, of fossil fuels. Along the same lines, how can we solve the dilemma? We can determine that, yes, we have to eliminate fossil fuels or have the goal of anything that has been approved in international agreements that look at it as not necessarily a short-term goal, but something that requires time and resources. So how do we solve this? And specifically here again, we return to a principle that we've heard several times throughout the hearing, which is common but differentiated responsibilities. How will this work, and who will make it work, if I may? I want to bring forward a study that has not been cited of the Inter-American Development Bank, and in the midst of the pandemic in 2020, that was called Employment in the Future of Net Zero Emissions in Latin America. I'd like to read 2 paragraphs because I think they answer a series of questions we've been discussing in these days and hours. They expressly state that decarbonization in Latin America does not need to be done to the detriment of growth or employment. By 2030, structural changes in patterns of consumption and production can give way to 15 million net jobs in Latin America and the Caribbean, compared to a scenario of business as usual. And then also they say that in the transition towards a zero net emission economy, 7.5 million jobs will be destroyed in Latin America in electricity from fossil fuels, the extraction of fossil fuels, and the production of animal origin food. By 2030, however, new job opportunities will certainly compensate for these losses by creating 22.5 million jobs in agriculture, production of vegetable source foods, renewable energies, forestry, and manufacturing. To ensure a fair transition, we have to make sure that initiatives towards decarbonization also go hand in hand with policies that help us relocate workers, to look for decent work in rural areas, and new business models to support displaced workers. With all this, I mean that there are data. We have data telling us that this transition can be accelerated without the need to continue business as usual. But accelerating it, we can build up sectors that are more ecologically friendly in our continent and ensure that this transition inserts us in a world that's more adapted to climate change, and even make us provide lessons to the world. We know that Latin America can supply several times the whole planet over with renewable energies, just looking at the potential in the region. And the possibility of using it ecologically and sustainably is something we have to mention. So in that sense, common but differentiated responsibilities have to also consider these differences between the North and South, but they can be no excuse for many of our governments to relegate action or postpone accelerated action to phase out fossil fuels and have a more ecological economy. In the previous panel, or the previous block, we heard about the difficulties our countries have because they're over-indebted, and how difficult it is to finance these types of projects for them. If we think that they mentioned, you heard Colombia, 50% that are so dependent on or that finance their state through foreign trade linked to oil. How can you finance this? It has a high cost. And I do know the studies that say that in the longer term, these investments are profitable, and you end up wasting less or spending less, and it's justified. But and it's not our place to come into these details, but we have to be concerned about how we can have equality and protect the most vulnerable sectors that depend on the state for healthcare, food, education, etc., and how to preserve them when the state will renounce to a very important source of funding. I'm bringing the problem up because it's something that we have to see. We'll measure the scope of what the court will say in its advisory opinion, and if we don't discuss this, and I think that's a great contribution they have brought as well, and I will ask some questions of you, but that's the issue. How can we ensure we discuss this so that we find solutions that are practical and truly help us in a fair, rapid, and safe transition?
Your Honor, going back to, that would take us back to the main issue which is at hand, which is equity. And there is a fundamentally important point about those pillars that we mentioned as fundamental to the treaty, to a treaty of non-proliferation of fossil fuels, which is first equity. And within that equity of the phasing out of fossil fuels, there's also international cooperation, which goes to your question specifically, and that international cooperation also bears talking about distinct or different financial flows. And we just heard from that person from Argentina in the previous panel talk about what the service of the debt is a very large amount, and it's a country that depends on the reserves of Vaca Muerta, for example, so with all the problems that this brings about. So going back to your first question, there's a need for this to be addressed from various fronts that will allow us to negotiate in a different way so that we can have debt cancellation. And the Colombian government has spoken about that very clearly and has talked about an ecological debt, and which is incurred into by countries such as Colombia is not equivalent to the debt that we have, and how we countries in the region have to face this. And all of this will depend on the enactment, on the approval of a treaty. Well, it would depend on international will to take this on as based on the size that it has, the proportions it has, and as part of an international or multilateral treaty. Usually, these collective solutions are obtained through multilateral means. Thank you for your answer. Finally, I'd like to mention and repeat how important it is for the court to hear all of your positions and opinions. It's a principle, an essential principle for the workings of the judicial function. We have to listen to everyone. In your initial presentation and then in your answers, you have mentioned the measures that could be taken, if I didn't misunderstand, to organize the process, this transition process, make it more orderly. So my question, and based on the answers that I just received to my questions, my next question is the following. That organization of the transition process that you are suggesting, you recognize that the point of arrival should be, the goal should be the elimination of fossil fuels, or do you also believe that fossil fuels can still be exploited but under a specific order with a reduction of emissions? I mean, what's your specific position in that regard? Thank you for your question and for thanking us for being here. What we are looking for is consistency. We do believe that climate change is real, that its impacts are devastating, and that we clearly, as a society and as humankind, what we need to move towards is decarbonization. That's the basic agreement that we have. But what's our concern? What you just said. How is this going to happen in practice without disproportionately hurting those who live off of access to energy, to power? Countries such as our own that sometimes don't have other types of revenue or income, they are highly reliant on fuel sales, and that not hurt those populations in a disproportionate way. That's our main concern. Our group works with building renewable infrastructure with an emphasis on electricity. But our concern is that currently we don't have the possibility to build that infrastructure because there's a tension there and there's pushback against those projects being built. So we would like to make a call for consistency. If we need renewable sources of energy, we need the infrastructure to have them. If we're going to make changes to the transport system, for as long as we wait for the batteries for EVs, then what's the best way, the least complex way to be there? Are we going to just stop using transportation? Of course not. But I do think that decisions can be made to mitigate the impact of fuels that are more polluting. I know they're all fossil fuels, that's true. But which one is a reasonable choice while we reach that decarbonization process? Because energy transition processes have usually taken years, and there are certain uses that are very worrisome, such as the use of firewood. Over 1.5 million households in Colombia use firewood in their kitchens, and that creates emphysema, etc. So that's where gas has a role to play for those households that are vulnerable and have no other way to cook their food. So our call is one of being realistic. There's a need for decarbonization, but we do not want for human rights to be breached. And access to energy, access to power is one that is an enabling right in the case of women. Of course, it frees up their time and it frees them. Thank you. I have no further questions, Madam President.
Judge Eduardo Ferrer. Mention was made of that all new projects for energy, for fossil energy, presumably violate human rights. I think it was the Fossil Fuel Non-Proliferation Treaty Initiative. I think. I'm not sure, but could you clarify that? And the second, would this also apply to other sources that make more emissions, such as agribusiness?
Thank you, Your Honour. It is not just us who. It is not just us who have observed that, or taken the view that no new fossil fuel projects can continue compatibly with human rights. The UN human rights treaty bodies have said as much, and it's a reflection of the fact that these very activities, this very conduct, has already breached rights, and so any continuation of it is still in perpetuity, at least of limiting rights. And so when it comes then to new projects, especially in circumstances where the International Energy Agency, the IPCC, and other best available science and sources have indicated that no new fossil projects are necessary to ensure energy security, and that energy and renewable energy can be scaled up so as to meet energy demand, it seems that any proportionality analysis that was to be applied to whether or not a new fossil fuel project could be pursued and supported and invested in would fall short of the standard required. It would be disproportionate in the circumstances, and we submit that that's the better view.
Se basan en la ciencia.
Science-based? Science-based? This is science-based, this information? Science-based?
The scale-up of renewable energy can meet the energy demand, I believe is in an International Energy Agency report, which is science-based.
Y si me permite agregar, señor juez.
And if I could add something, Judge Ferrer-McGregor. It's very important to understand how the extractive process of fossil fuels has led us to hydrocarbons that are much more intensive in terms of carbon emissions, and they leave us much less available energy to society. A critical example for our region is what's happening in Vaca Muerta, Argentina, and how through the drilling of many oil wells to extract not oil wells, but wells to extract natural gas under conditions. It was one of the deposits that with the best technical facilities could be extracted differently. So here we have a relationship that is detrimental to human rights because we continue to depend on the same way of extracting fossil fuels, but it's more and more intensive. They're carbon intensive, energy intensive when they are exploited. So this provides a new frame of analysis in which energy diversity, even beyond renewable energy, can become an alternative toward a transition that has a heavy cultural component. And what about agro-industrial emissions, agribusiness emissions? Does that also apply? We could, Your Honor, we could go into more detail on that subject in terms of the trend we see today in the agribusiness model, which is more heavily based on fossil fuels. In terms of for fertilizer, for example, and NCA is one of the types of fertilizers based on the same model of extraction. The extraction of nitrogen is done with fossil gas. The obtention of potassium, phosphorus depend on mining that uses fossil energy. So here we're saying that it builds dependency, and there are alternatives involving cropping practices that are traditional to many of our people, of our indigenous peoples. Thank you. I think this is enough. I want to change the subject. I want to talk to Oil Change International and Bank Climate Advocate. You talked about the concept of fair measure, of fair share, as part of mitigation, adaptation, and reparation. How do you relate this concept to the maximum possible ambition? That is to say, if this implies differences in terms of commitment by a state, which one should prevail in order to guarantee human rights, not just for the population, but humanity as a whole? Yes, thank you. We talked about fair share from the perspective of the energy transition in order to put a stop to dependency on fossil fuel and our dependency on what we call the carbon locked-in development. That is development that is based on carbon fuels. On this point of fair share, we could say that we need to consider technical, financial capacities and the resource capacities of the countries in order to bring about the transition, as other panelists have said, especially SIDS, which have very few capability to do the transition, and also then the need to transfer these resources that continue moving into fossil fuel industries, instead of the transition that the countries need. So instead of continuing to invest and continuing to grant subsidies and financing to development models that depend on the carbon industry, instead we should think about infrastructures that would allow the countries, especially those that are moving into development, to be able to invest in their own infrastructure that would allow them to bring about low-emission development. Also, I would like to take this opportunity to raise the point about common but differential responsibility. And in Oil Change, we have a database that tracks financial operations of the G20 countries, multilateral organizations, development banks, because these are the ones that continue contributing to dependency on fossil industries. So in this whole area of fair share and common differentiated responsibilities, we are emphasizing the fact that this also has to include ambition and policy development that would make it possible to step away from dependency on the fossil industry and eliminate clauses that make it possible for these subsidies to continue. So regulation that is allowing investments in this sense.
Briefly, Your Honors, I wanted to reiterate and endorse the criteria that were offered by our colleagues from the Fossil Fuel Non-Proliferation Treaty recently about the considerations to inform the differentiation between states, both looking at cumulative emissions through acts and omissions over time, as well as economic capacities and the level of dependence on fossil fuel revenues or jobs in the country. I think that those factors come together and that there's a rich history and under the economic, social, and cultural rights jurisprudence looking at the ways in which the respective capabilities and means available to a country at a given time inform the actions it should take while respecting its human rights obligations altogether. I think that it's critical in this moment to understand that just as with other economic, social, and cultural rights, although there is a recognition that they will be progressively implemented in accordance with differential capabilities, that some are of an immediate effect. And when we know that fossil fuel climate change is posing a grave threat to the right to life, among other rights, there are some immediate consequences of that threat, including when it comes to fossil fuels, not extending and entrenching or expanding dependence on fossil fuels as one would do if one were to extend new infrastructure for gas or other fossil products now, which would lock in a dependence that is inevitably leading to and contributing to climate harm. I think a key distinction between new fossil fuel projects and other forms of emitting activities is that fossil fuels are intrinsically and inevitably lead to emissions that drive climate change. As the Secretary General of the United Nations has said quite clearly, the problem is not fossil fuel emissions, it is fossil fuels themselves. And I think there, in contrast, agriculture, of course, industrial agriculture, as our colleague said, dependent on fossil fuels, is destructive of land, it leads to land conversion and destructive of natural carbon sinks as well as other emissions in the input processes. And those techniques need to change. But growing food, of course, needs to continue through small-scale and localized mechanisms. And finally, if I may, just to come back to the point on, with due respect, companies don't guarantee human rights, states guarantee human rights. And I believe that with this court's elucidation of the fact that there has been and is an ongoing breach of international obligations that gives rise to a duty to repair the resultant harm, that is also part of the reparation obligation in the face of that breach is to finance the transition and to pay for the cost of both mitigation measures and adaptation so that there is a demand based in rights and in law, not simply based on voluntary cooperation or actions by given actors. Thank you.
Muy bien, muchas gracias. Y bueno, también
Thank you. I would like to express agreement with what my colleagues have said about the importance of having the Bogota Energy Group here with us today. There's something I would like to know about. What is the reason why other companies did not come? You're the only one. We can't speak for the others. Clearly, though, I think that the companies don't trust that there will be a more open dialogue. There's a lack of trust, or that's our perception anyway. We think that very often to raise arguments about stability or the idea of how to plan projects, infrastructure projects, is interpreted as anti-rights, and in that sense, we think this is a forum that the companies do not always identify as relevant to themselves. There may be others. The Inter-American Court, it's a court. It applies to everyone. But you did not take that perspective, and that's why you're here. We think that you need to talk. You need to have an open dialogue. We have arguments, and we need to share them with everyone else. And I think this is a constructive dialogue, which is what will lead to specific solutions. Yes, Your Honor, thank you for that question. We confess that we went to a number of companies and encouraged them to join us and to take part in this hearing, but unfortunately, I think the forum itself and the issues under discussion, the companies still see this as a risk and not as an opportunity. We, however, are here for that very reason, to show that there are opportunities in dialogue, as my colleague said. And we can build through the productive sector, private companies, we can build the solutions that we need, and it will be much more harmonious and much more respectful of everyone's ideas. Thank you. I commend you. I commend you for being open to this dialogue and for coming here today. That's all, Madam President.
Thank you. I echo that those words of congratulation. It has been very important for the court to hear from you, as Judge Perez Manriquez stated. I am a career judge, and it is essential for judges to ensure balance from different points of view, not just certain points of view. And along those same lines, I wanted to give you the opportunity to clarify or help enlighten the court on an issue you have briefly mentioned. And I say briefly because the time does not allow it. And in your oral submission, as well as your written submission to the court, you're asking the court to set standards that are reasonable for the transition, for the energy transition. And we've already heard there's a question of how to build this, especially considering critical issues and tipping points that are scientifically based with evidence saying that we cannot wait. So it seems to be contradictory opinions, that reasonability goes against the urgency in time or lack of time in certain matters. So could you help us understand how to build standards of reasonability based on what scientific evidence could we work towards that transition? And additionally, what direct alternatives in transboundary cooperation could you offer? Thank you, Madam President, for the question. In our submission, what we point out has also been stated in these days. The contribution of Latin America to GHG emissions, given their energy system, cannot be compared to the rest of the world. And in that sense, for us, addressing climate change in Latin America, and that's why we started saying that it starts with tackling deforestation. Our true capacity is absorption. So the second point we have also stated as fundamental is transport. The impact on the environment there is clear, but also for health and lives of people in the air we breathe. And thirdly, the energy transition. And that's why, for that, we refer to reasonability. And for example, with gas, we've heard this on several occasions. Gas is also fossil fuel. We have to eliminate it. But then the concern rises: what to do with people and populations that depend on gas to fulfill their fundamental rights. We're also worried that there's not an adequate balance as to energy needs and the idea of not using energy sources. How will we supply energy needs? Just look at how much light and electricity we're using today. How are we connecting? Where are we storing information? It's all digital. Energy is in many more areas, or is needed in many more areas than we imagine. So our call is that if this is going to accelerate and to guarantee the right of people to energy. We believe this is something, this aspiration is shared. We also want to accelerate mitigation of the consequences of climate change. We are worried. We see the clear effects it has on people and countries. We do not deny it. But we have to coordinate the legal framework that will guide us all, businesses, communities, and states, towards that transition. Deciding to transform the energy system is a very fundamental decision, and it requires the most number of agreements and consistency between goals set and actions taken to achieve it. Thank you. I also wanted to add 2 issues for reasonability. This venue is actually a tool and an important opportunity to build reasonable rules. It's an opportunity for all the parties, communities, civil society, states, businesses, to submit our arguments and the evidence we have from our experience and in our territories. That is very valuable for the court and to be able to convene more parties. Thank you. Besides everything you've said that is valuable, we have scientific evidence that's very clear and has been presented in these 3 days of the hearing, in the file and the dossier and in other fora. Where are scientific evidence-based proposals that can help us build transition indicators beyond the themes? How do we bring this to reality? How to achieve that reasonable transition? To specify this, well, first, there's an urgency. We don't deny it. We are concerned that scientific evidence shows that electrification, just as is the talk, for switching for fossil fuels does not seem viable. There are no batteries for this. The weight of a battery needed for a truck to travel through the Andes, if you've ever been there, is not. It's just not available, and it would be prohibitive. It's just too expensive for our countries to pay for this change. So there's scientific evidence that shows that today we cannot transition. It requires time. And while time goes by, we think it's important to have clarity. What will be demanded of us as businesses? What is expected of us? What investments should be made? And what are the rules to make those investments? Because the climate emergency forces us all to have standards to guide us and give clarity. And the court is the one to decide the sense of those standards, and the state to decide, provided given all the information provided and arguments. So we just want there to be clarity, coordination, public policies that are consistent, and if we will build renewable infrastructure to give the licenses, the environmental licenses to build it. When you asked whether there will continue being fossil fuels, we don't really know the impacts of lithium, and we don't know if we will be able to mine these rare lands that are needed to provide electricity. So the idea that we will all go electric by 2030, but we don't have access to those minerals, and we don't even know whether it will be better for the planet to have those minerals or gas emissions. So that's our vision. And just to add, if it please the court, in our written submission we have evidence, figures, data, and we can gladly provide more literature and the reports for the court to have that necessary scientific evidence to build the rules. Yes, I would appreciate it. I think you were asking for the floor. Briefly, because we have to break. Thank you. So on the one hand, it's important to talk about the preservation of life as a fundamental human right should be above economic reasoning, because many times we focus on that in other discussions. And also, in terms of energy as a fundamental right, understanding that fossil gas, if we analyze the consumption matrix, is mostly done for the extractive processes of fossil fuel industry. This is important because we're always saying that we need access to energy that communities don't have. But if you look at Colombia, and these are figures from the same Association of Natural Gas, 24% of total gas consumption is by the oil extractive industry, and just 16% is residential demand. Thank you very much. Thank you all for your participation and for the interest of appearing before this process. Thank you, and we reconvene at 6 p.m.
Por favor, todos de pie, la Corte se retira.
This hearing.
Se reabre esta audiencia pública de acuerdo a nuestro.
This public hearing is hereby resumed. According to our schedule, we will now recognize the organization Earth Justice. Please proceed.
Honorable judges, my name is May Manupipapong, and I, along with my colleague Jacob Kopis, are here on behalf of Earth Justice, a non-governmental environmental law organization in the United States. Earth Justice has over 50 years of experience litigating for environmental protections, the right to a healthy environment, and climate justice. We work with partners all over the world, including in the Americas, Africa, Southeast Asia, and Oceania. In our presentation today, we will underline how important it is that this court provides states with specific, actionable obligations for complying with their duty of prevention with regards to the climate emergency. Clear requirements in this court's advisory opinion will help guide environmental regulators, ministries, and courts in reducing greenhouse gas emissions and avoiding the worst human rights consequences of climate change. It will also strengthen the voices of communities and civil society across the hemisphere and allow them to hold states accountable. We will identify two sets of concrete duties. I will focus on mitigation measures, and my colleague will address the requirements of climate assessments. As many have highlighted in their presentations, the American Convention requires states to use all the means at their disposal to avoid activities under their jurisdiction causing significant harm to the environment. In the context of the climate emergency, this duty of prevention requires all states to transition to clean energy. Every new fossil fuel project and every existing power plant, oil and gas field, or coal mine that is allowed to continue emitting greenhouse gases will make it harder to reduce warming and ensure human rights. This is why replacing fossil fuel infrastructure with clean and carbon-free sources of energy, many of which are readily available and technically and economically feasible for most states, is one of the most important mitigation measures states can take. The remaining question, then, is not whether states must end their reliance on fossil fuel sources and replace them with clean energy, but how and when. Based on historical responsibility and respective capabilities, the timeline each state executes these measures will vary. More developed states must take urgent steps immediately, and reach net zero emissions faster than developing states. However, all states must take some action now. While our written submissions identify a more comprehensive and detailed list of potential actions that will help guide states in fulfilling their human rights obligations, we focus today on the three main requirements of a clean energy transition: phasing out fossil fuel extraction, removing fossil fuel subsidies, and replacing fossil fuel sources with clean energy. First, states must take immediate steps to phase out fossil fuel extraction. While many have noted that states must stop burning fossil fuels, it is equally vital to halt the extraction of fossil fuels, which itself produces substantial greenhouse gas emissions and drags on the lifespan of the fossil industry. More developed states must immediately stop approving fossil fuel extraction and production and begin shutting down existing oil and gas fields. Developing states must also take the same steps, as consistent with their historical responsibility and respective capabilities. A swift and early phase-out of fossil fuel extraction can also support economic development in these states. As the global economy decarbonizes, demand for and prices of fossil fuels will drop. States that are dependent on fossil fuel revenues that fail to prepare for this reality will face profound financial losses, which a recent UNDP report warns could roll back current levels of development by decades. Second, states need to stop subsidizing oil, gas, and coal production and consumption. In 2022, countries in Latin America and the Caribbean spent around $2 trillion, or nearly a third of regional GDP, on fossil fuel subsidies. These subsidies prolong and expand climate harm by enabling fossil fuel projects that would otherwise be economically unviable and diverting limited public funds away from cheaper clean energy alternatives. Although necessary, removing such subsidies should be done carefully and in conjunction with policies that protect vulnerable populations from energy price increases. Third, states must replace most fossil fuel-generated electricity with clean energy. More developed states must stop approving any new fossil fuel burning plants now and begin retiring existing plants on an expedited timeline. Less developed states should immediately begin planning the retirement of existing infrastructure and only approve new fossil fuel projects that are consistent with their remaining carbon budgets. Finally, states must remove barriers to and promote clean energy. There are many reforms states can implement now that are not economically burdensome and can level the playing field for clean energy, all of which have been adopted by at least some states in Latin America and the Caribbean. These reforms include setting minimum targets for clean energy, updating policies around how states determine how electricity will be generated, and incentivizing off-grid and distributed small-scale clean energy projects like rooftop solar. Thank you. My colleague will now take the floor.
Honorable Judges of the Inter-American Court, my name is Jacob Kopis, Senior Attorney with Earthjustice. I will discuss today the need for conducting climate assessments before approving development, infrastructure, or resource extraction activities. Properly conducted climate assessments are the best way to provide crucial information for limiting future sources of emissions. They give an accurate understanding of how any new activity contributes to global climate change, thereby allowing authorities and civil society to identify which activities must be stopped, which must be phased out, and which must be prioritized. In these hearings and in written submissions, many groups have called for climate assessments to be considered part of states' obligations to prevent significant environmental harm and to ensure human rights under the American Convention, a position that is fully supported by international law and this court's jurisprudence. We echo this call, but respectfully ask this court to go further by setting specific minimum standards that states must adhere to when conducting climate assessments. These requirements are already well established in international standards and best practices. Unfortunately, however, very few states have yet to incorporate them into their regulations or practice. This creates a problematic loophole in which fossil fuel companies can hide their true climate impact of their extractive activities and avoid fully informing the public and authorities. This court has followed a similar framework for environmental impact assessments in its prior advisory opinion OC-23 on human rights and the environment. There, this court clearly laid out 5 minimum requirements that all environmental impact assessments must comply with under international law. Those requirements should apply equally here. In addition, the court should outline further requirements specific to climate assessments. While we describe several such requirements in our written submission, here we will highlight 3 that are fundamental to our proper climate assessment. The first is regarding the proper scope of an assessment. Climate assessments must evaluate the cumulative climate footprint of the entire project. This must include all indirect emissions, sometimes referred to as Scope 3 emissions. This should cover the entire life cycle of the project and all associated activities, from the extraction of raw materials to our product's final disposal. For an example, an assessment of an oil well should include all direct emissions, such as those from machinery used to drill, fugitive emissions from leaks, and accidental releases of methane gas, which frequently occur with drilling activities. The assessment should also include indirect Scope 3 emissions. These could include transportation of oil in pipelines, shipping of oil to other countries, and the eventual burning of that oil, and among other related activities. A proper assessment of these indirect emissions is fundamental for fulfilling the primary purpose of an impact assessment. That is, to evaluate the additional impact to the climate of a new project and identify potential alternatives and mitigation measures. Second, authorities must determine whether the project's total life cycle emissions are compatible with the state's climate and human rights obligations. At a minimum, the project must be compatible with the country's remaining carbon budget and a low-carbon future pathway. Evidence that a project's life cycle emissions would exceed a state's NDC, for example, would be conclusive evidence that a project is not consistent with the state's international obligations and should be rejected. Third, authorities must examine all feasible carbon-free alternatives. They must then reject any fossil fuel proposal where an alternative clean energy project could bring similar benefits while avoiding greenhouse gas emissions. The assessment of alternatives, including no project alternatives, is a key international best practice for any environmental impact assessment. If no feasible low-carbon or renewable alternatives exist, states should only approve a project after imposing binding conditions that require fossil fuel companies to avoid or mitigate greenhouse gas emissions. These requirements will help guide authorities in ensuring climate assessments can identify and properly mitigate new sources of climate emissions. And we greatly appreciate the opportunity to participate in these historic proceedings. We'd be glad to further discuss these requirements and others we highlighted in our submission during the question period. Thank you very much.
Muchas gracias a Earth Justice por su participación en
Thank you, Earth Justice, for participating in the process. And now I'll give the floor to International Trade Union Confederation and Trade Union Confederation of the Americas.
Thank you, Madam President, distinguished judges and members of the court. My name is Tony Moore, and I'm the General Secretary of the Barbados Workers Union. Together with my colleague, Susanna Muscat, I'm pleased to submit observations on behalf of the International Trade Union Confederation and the Trade Union Confederation of the Americas, which represent 191 million workers in 169 countries and territories worldwide, including in the Inter-American region. I'll be focusing my remarks on workers' rights to decent work in the transition towards a carbon-neutral world, or put another way, workers' rights to a just transition, and on the implications of climate change mitigation and adaptation measures for fundamental labor rights. In international law, labor law, fundamental labor rights are those contained in the core conventions adopted by the International Labor Organization. These are the right to freedom of association and collective bargaining, the right to freedom from forced labor and from child labor, the right to non-discrimination in employment and occupation, and the right to a healthy and safe work environment. All of these rights, as well as other human rights in the world of work, such as the right to work or to just and favorable conditions of work, are also regulated in international human rights law and protected under the American Declaration of the Rights and Duties of Man, the American Convention of Human Rights, and the Protocol of San Salvador. In the later presentation by the International Lawyers Assisting Workers Network, you will hear from my colleague more about the right of workers to a healthy environment and just transition as an intersection between climate emergency and human rights. The climate crisis is already presenting pervasive and harmful threats to ecosystems, poverty reduction, sustainable development, decent work, and social justice. An increasing number of fundamental labor rights violations and adverse impacts on employment can be traced to climate change. Climate-induced disaster, environmental degradation, and growing scarcity of resources are affecting many communities, driving millions of people into poverty. In many cases, victims of the climate emergency will be left more vulnerable to forms of modern-day slavery, including forced labor, labor trafficking, and child trafficking. Such forms of severe labor exploitation are pervasive in industries which are particularly vulnerable to environmental degradation and high climate change impacts. But there's increasing evidence that renewable industries, which are deemed vital to an urgent transition to clean energy, are also reliant on forced labor for mining, processing, and manufacturing of critical minerals and inputs. These implications of climate change mitigation and adaptation strategies on fundamental labor rights are far less mentioned in the intensifying debate over how to protect the world's most vulnerable people from the impacts of the climate crisis, while accelerating the global transition to clean energy. It has been acknowledged in the jurisprudence of this court that states have an obligation to mitigate greenhouse gas emissions from sources under their jurisdiction to prevent harm and protect fundamental human rights. States also have an obligation to undertake adaptation measures to minimize and mitigate the negative effects of the climate crisis and protect groups that are at risk of being affected. Accordingly, states must prepare for and respond to the effects of climate change, particularly those that pose a foreseeable threat to human rights. In this context, it is important to invoke obligations of states under the Constitution of the International Labour Organization, in addition to those stemming from the ratified core conventions containing fundamental labor rights. These obligations of states are highly relevant to the considerations of this court because all the state parties to the Inter-American Convention of Human Rights are also members of the ILO. Based on the very membership in the ILO, all ILO member states are obligated to respect, promote, and realize the principles concerning the fundamental labor rights contained in these ILO core conventions. This obligation extends even to states that have not ratified the conventions in question, as the violation of these fundamental principles and rights at work cannot be invoked or otherwise used to access legitimate comparative advantage. Further, in fulfilling the ILO's constitutional mandate to improve conditions of labor worldwide and to pursue balance between economic and social objectives, states must pursue policies based on 4 strategic objectives: employment promotion, social security and labor protection, fundamental principles and rights at work, as well as social dialogue. These 4 objectives form the pillars of the ILO's decent work agenda. Here we underscore decent work as a rights-based concept, whose goal is not merely the creation of jobs, but the creation of jobs of acceptable quality and grounded on rights. Accordingly, climate change responses should contribute to the goals of decent work for all, social inclusion, and eradication of poverty. This enters the definition of just transition developed in international labor law. Just transition has grown into an increasingly recognized concept, also in climate law and policy. During the recent decade, just transition has been included in both international and national climate law frameworks, including in the preamble of the Paris Agreement in 2015. Preambular Recital 10 of the Paris Agreement refers to the need to take into account the imperatives of a just transition of the workforce and the creation of decent work and quality jobs. Following the Paris Agreement, just transition has evolved into an increasingly important concept in how climate law principles and commitments are implemented. Accordingly, it is evident that the concept of just transition and the workers' right to decent work in the transition towards a carbon-neutral world is highly relevant to the assessment of the links between the climate emergency and human rights and the relevant obligations of states. Regarding adaptation and mitigation measures, these should be developed and implemented within a rights-based context, not only as it relates to fundamental principles and rights at work, but also giving priority to the right to work and the right to just and favorable conditions of work. This would require states to adopt a coordinated approach to economic and social policies that ensure access to employment opportunities and active labor market policies, as well as systems of protection against unemployment and other social protection measures, support transition away from those industries that contribute to the climate crisis, and minimize the impact of job losses and improve job opportunities. The goal of just transition, like that of the Decent Work Agenda, is not merely concerned with the creation of jobs, but with the creation of jobs of acceptable quality that are linked to access the fundamental principles and rights at work, social dialogue, social security, and labor protection. I would therefore like to highlight the importance of workers' participation in the decision-making aimed at tackling the climate crisis. Procedural rights contained in the relevant environmental instruments, including the Escazú Agreement, apply to workers and trade unions, but states are also required under ILO conventions to ensure that all workers, including those most affected by climate change and who are most often excluded from labor protections, have the right to form trade unions and to negotiate over mitigation and adaptation measures. Lastly, I want to highlight that just transition is strongly related to the principle of common but differentiated responsibilities and implies an obligation to consider the adverse impact of response measures on most affected economies and to address issues relating to climate finance. Financing should be directed towards supporting states that are most vulnerable to the climate crisis, but least responsible for climate change and that are least capable of adapting. It should include provisions for financing a just transition of workers, including creation of rights-based green jobs for the future and addressing current work deficits, decent work deficits. In conclusion, the ITUC reiterates firmly that any consideration of human rights within the context of sustainable development towards a carbon-neutral economy and society, and any consideration of related state obligations must include just transition measures. Madam President, thank you very much for your attention. I'm obliged.
Thank you for your participation. And next, I will give the floor to International Lawyers Assisting Lawyers Network. You have the floor.
Madam President, honorable judges of the Inter-American Court, my name is Zuzanna Muscat-Gorska. I work for the International Trade Union Confederation. I will be answering questions related to the preceding presentations together with my colleague Tony. Now I'm presenting on behalf of the International Lawyers Assisting Workers Network. I will be focusing my remarks specifically on the workers and their right to a healthy environment in the world of work, and more broadly, a right to a just transition as an intersection between climate emergency and human rights. Climate change has already led to job losses, decreased productivity, increased deaths, occupational accidents, and occupational diseases throughout the Americas. Heat stress is of growing concern in this region, directly affecting workers in agriculture, construction, mining, fishing, and workers in the informal economy, such as street vendors and waste pickers. It is estimated that by 2030, 45 million people will be affected by heat stress throughout this region. As climate change continues, this will spread to other sectors throughout the region. Climate change will also lead to massive internal and international labor migration, with the World Bank estimated 16 million people will have to move because of the effects of climate change in the Americas. Climate labor migration will exacerbate the harms, exploitations, and violations felt by migrant workers already, many of whom face massive backlash, racism, and lack of fundamental rights, including the inability to join and to form unions in the country of destination that they are working in. The right to just, equitable, and satisfactory working conditions is recognized in Article 7 of the Protocol of the San Salvador and is protected under Article 26 of the American Convention on Human Rights, as well as under international labor laws. Part of the right to just, equitable, and satisfactory working conditions is the right to safety, health, and hygiene at work. Most member states have national laws protecting the right through occupational health and safety regulations. This court's own jurisprudence has created 6 essential components of the right to safety, health, and hygiene at work, including the right to work in conditions that prevent occupational accidents and diseases, interrupt her work in the case of imminent danger to her life, health, and safety, access information about risks to life, health, and safety, participate, training, and access justice and redress for occupational accidents and diseases. Similarly, the right to a healthy environment, protected through various legal instruments globally and within inter-American human rights system, has led this court to identify specific obligations of states to regulate, supervise, and oversee, require and approve environmental impact studies, establish a contingency plan, and mitigate. Member states have a legal obligation to both respect and guarantee the right to safety, health, and hygiene in the world of work, and the right to a healthy environment. This obligation extends to a private sphere and includes the obligation to prevent third parties, such as employers, from violating these legal rights. This legal responsibility of employers goes beyond the workplace and includes all persons in the world of work that they control. These obligations require member states to develop normative framework and address climate change and its impact on the world of work. This framework must ensure that productive activity does not endanger people in the world of work. For example, the regulation must prohibit outdoor work to be performed when the temperatures exceed a certain standard, or the employer must provide environmental safety and personal protection equipment. The regulatory framework must include the right of people to interrupt their work in the event of imminent danger to their health and safety due to heat stress or other extreme weather event. This right should be extended to all types of workers, whether salaried or self-employed, regardless of their nationality or migratory status. It must enshrine the right of people at work to access information on existing risks due to heat stress that may affect life, health, or safety. Here, member states should be guided by Escazú Agreement, which clearly provides the right to access any environmental information, including environmental risks and associated adverse impacts that affect the environment and health. In surveying trade unions around the world, a major obstacle to their participation is the failure of governments to provide information on opportunities for social dialogue on legislation, policies, and plans related to the climate crisis and just transition. In some countries, trade unions have been systematically excluded from climate policy discussions. The duty to supervise and oversee by state falls on all activities that occur within its jurisdiction, including those carried by the private persons, and may produce significant damage to the environment. This duty requires a labor inspection mechanism to monitor the application of this regulatory framework and a sanctioning system in the event of non-compliance. It is the lack of state oversight that is one of the most recurrent breaches in the violation of rights. Workers and trade unions are holders of the right to a healthy environment in the world of work. The negative impact of climate change directly affects working people, making their participation in decision-making essential to the success in the fight against this emergency. Protection of trade unionists as human rights defenders is essential to ensuring the right to a just transition. A just transition means moving away from unsustainable industries that harm the climate while marshalling public resources to invest in clean energy industries that are based on decent work principles, as discussed in the ITUC intervention. It also recognizes that carbon-dependent communities cannot be forced to bear the economic and social costs of change and must be supported throughout the transition. Climate-related impacts disproportionately affect women and other marginalized groups, and their specific concerns and proposed solutions must feature prominently in any mitigation and adaptation policy that is put in place. Indeed, a just transition must be a concept with climate and labor justice at its core. A significant barrier to labor rights defenders is the restrictions on their right to freedom of association, particularly the exclusion of workers who are often most affected but lack legal recognition and the ability to form and join trade unions. This often includes agricultural workers, migrant workers, workers in the informal economy, and those in fissured employment relationships. A further barrier is the inability of unions to be able to bargain collectively with relevant actors on climate-related issues, since in many countries an employer is not obligated to bargain with the unions on climate-related issues. The final barrier is the inability of workers to strike on issues related to climate change and just transition in most countries. Thus, states must ensure that labor human rights defenders are able to carry out their activities free from threats of any type of physical, psychological, or moral harassment. In conclusion, this discussion cannot exist without centering climate and labor rights as twin co-pillars. Workers and their organizations are essential in addressing climate change, in mitigation and adaptation, and in oversight and enforcement of laws, decisions, and regulations. Member states have a clear duty to ensure a safe, healthy, and hygienic world of work that is not adversely impacted by climate change effects such as heat stress or other extreme weather events. This obligation extends beyond member states to employers who have the most control over the world of work. Without workers and their organizations' ability to fully exercise their right to freedom of association, collective bargaining, and the right to strike on issues of climate change and just transition, the right to a healthy environment, just, equitable, and satisfactory working conditions, or a just transition cannot be realized, respected, or enforced. Thank you very much for your attention.
Muchas gracias a la representación de
Thank you to the representative of the International Lawyers Assisting Workers Network. I will now recognize Eduardo González Chávez to take the floor. I understand you are speaking on your own behalf. Is that correct? Please proceed. Distinguished Madam President and members of the court, representatives of the illustrious estates that brought this request before the court, registrars, I would like to draw your attention as I discuss this matter on two particular points which I think could contribute something useful. The title I would identify as the chapter of this line of reasoning is very simple. Without a healthy environment, there can be no human being. The adverse effects of climate change have been outlined by the previous speakers and by many scientists. However, I would humbly suggest that I can contribute to this decision, and at this time will attempt to define the obligations of the states in the following terms. Considering that the advisory opinion by its procedural nature, does not find any particular state responsible for a violation, but rather considers certain factors in light of the convention, I think that we can consider the following. We need to spread the word about environmental defenders, and I think we could use the following wording that have been used in legal considerations in other courts around the region, so that through this strategic wording we can meet the specific needs for addressing the effects we're discussing as quickly as possible. We need to expand procedural standing for all grievances. I think the advisory opinion by its very nature can do that. I may be mistaken. We should recall here that the sword of justice is sharpened in every time a case is settled. It may grow rusty in some verdicts, but it is important for all decisions to be carried out quickly in international relations and human rights. Nevertheless, many states do not do so, and that is why we are here today. The climate emergency tells us that sometimes it's the most remote judge, most remote from anyone in the region who has the power, who in fact whose verdicts must be obeyed in order to create, change, or invalidate a public policy, a government act or omission, or a business practice, or anything that is aggressive against nature. Otherwise, chemistry and physics are giving us very dramatic forecasts for the future, and these scientific scenarios will certainly be borne out under these conditions. In the specific expression of available remedies in Article 26 of the American Convention on Human Rights, I think that this is the main support that I would request outside of the analysis, alongside other specific articles contained in the treaties, that is, the Universal and Regional Conventions on corruption. The topic covered by Article 26 of the American Convention on Human Rights, having to do with the International Covenant on International Social and Cultural Rights 2.1. In examining it, we have found that in practice, the duty of the states to channel as all the available research they can is not being obeyed. The proposal would be that we set a judicial standard as to how to show or demonstrate that the states are in fact channeling available resources to meet this type of international obligation. In the judicial precedents that I studied, I found a few things. The most recent was paragraph 10 of the General Observation. This is not a judicial decision, but it is a precedent. It's the General Observation number 3 of the High Commissioner of the United Nations High Commissioner, who said in paragraph 10 that there is a duty for the states to demonstrate. And I think that this is where I can contribute something. The expression available resources should be, or remedies, should be interpreted, in my view, in the sense that it is the state that has the burden of proof through financial accounting decisions and government practices that to demonstrate that they have in fact used all their resources. In practice, the states say that that they don't have budgetary sufficiency for a specific action, but in real life there is a great deal of superfluous expenditure taking place all through the region. So I propose, or what I would be bold enough to suggest, if this seems appropriate, would be that we could analyze in any case file, administrative or penal, whether the states in fact have channeled these available resources in real life. So I would suggest, for example, the idea of an allegedly superfluous expenditure as an expenditure that does not go substantively toward the protection of human rights, that is, expenditures on the environment and their adverse impacts. And why am I saying this? I certainly know firsthand that the governments allocate enormous amounts of money, of their budgets, to matters that have no that provide no public benefit. For example, the billions of pesos or dollars that are used for advertising purposes. That's just one example. After that situation, in order to, I know that I don't have a great deal of time, I would ask that we think a little bit in order to respond to the situation. Think about specific obligations for monitoring on this subject. In the last advisory opinion on the environment by this court, the court made reference to a decision on environmental impact. I would say if we think that the real factors of power, without saying specifically a constitution, economic factors, legal factors, political factors, the real factors of power, which are agents that are contaminating nature, if at some point they are in a position to corrupt the external agents that do these evaluations, if I would say they do. I think that can happen. So based on international treaties on corruption, we could say that the states are under obligation to ensure institutional means of internal control for attitudes of oversight or supervision associated with actions that are dangerous or not favorable to the environment. The way I read it, I think the international text would indeed be able to cover this. If I may, I will give a more detailed explanation, but that would be only if you are interested. But this is the statement I would make. To close, at a time of international tension, political tension such as today, all we can do is suggest that belligerent states, in any case, have a prohibition by international jurisdictions to avoid using weapons or strategies that do not upset the environmental balance or worsen the climate crisis. Otherwise, they would incur international responsibility, even if they argue a legitimate cause. And finally, with respect to the common but differentiated responsibilities, I think it's interesting to think that this goes back to the first thing I said. In the order number 3/20 of the Inter-American Commission on the Obligations of States, which was discussed in the last few days, I found that in paragraph 4, 15, and 37, the Commission talks about available resources for carrying out actions. And I think that's not happening. That's what we're not achieving. So I think that there is a possibility for us to authorize the different members of a strategic litigation. When I say strategic litigation, we're talking about human rights as established in the convention. There could be a scientist. This is not a matter of jurisprudence. It's a matter of expert analysis. An issue of the judicial authority that is responsible for the non-compliance. Clearly, we are not getting down to the commitments established in the Paris Agreement. We're not there. We're not achieving those goals. And this has been explained very clearly by previous speakers. So I think this possibility to establish a standard would lead to actions, and the first actions would be enough it would not solve our problems overnight. I would be interested in hearing your questions, ladies and gentlemen of the court. The question is, what can we do tomorrow to solve this problem? I certainly don't have the answer, but I do think when we talk about the common but differentiated obligations, we can understand that every entity that has standing in the region can say to the state what it can do with its budget, and to tell the state what obligations would be carried out as a function of that. My time is up. Thank you.
Thank you, Mr. Eduardo Gonzalez Chavez, for your participation. We now have the time for judges to ask questions. Judge Patricia Perez Goldberg, will you be asking questions? Yes, Madam President, thank you. Thank you all for your submissions. I have two very specific questions. First, to representative of the International Trade Union Confederation. You have referred to one aspect that has not been covered in the hearing before this, and it's very interesting, by the way, which is the connection between the need to reinforce social security and protection of workers in the context of the transition, of the energy transition, and in the context of climate change. In previous hearings linked to the OC, the advisory opinion, on the right to care, we heard many submissions regarding social security, the importance of reinforcing this essential pillar. And I really believe it would be interesting for you to elaborate on how to reinforce social security in this context. Thank you.
Thank you for your question. Social security is fundamental to the achievement of the decent work agenda, social security and social protection. What is often found is that when natural disasters or climate disasters hit, if states do not have strong and certain social security systems, it undermines workers' access. Therefore, we take, for instance, situations of hurricane, earthquakes, heat hazards that affect many workers in many countries, where they automatically are unable to work. Workers in tourism, workers in fishing, and so on. The opportunity to work does not exist in the face of natural disasters or climate disasters. And if there are not strong social protection and social security systems in place, then workers don't have any access to income that will tie them over until they're able to work again. So in the trade union movement, we are very concerned to ensure that at the company level, that the company puts in place certain protections for workers, alternative opportunities if they can be considered. Because, for instance, when in Barbados during COVID, although it was not climate related, but I'm just trying to draw an example of how Social Security works. Tourism was not possible, but we looked for other forms of work for tourism workers during that time, so that we would not place too much of a heavy demand on the Social Security system first and foremost, but at least we had a Social Security system in place that workers can access, for instance, unemployment insurance and so on. So what we recognize is that where there are those circumstances that will force workers into a position where they can't earn to feed their families and so on, there must be some system that can be jointly discussed and arranged between governments, between the private sector, and between workers' representatives to ensure that at least there's some minimal protection until they're able to access employment again. In the ITUC, my colleague Susanna, she works very much in that area, and I'm sure she may want to add at this point in time. Thank you.
I'll just reiterate that indeed in the times of crisis, also related to climate change, the workers are often still left without any support. This is the reality. I can bring the example not from the region, but quite illustrative from Pakistan and from floods in 2022, and especially workers in the railway. It was at least 70,000 workers who were left for months without any support, and unpaid wages, pensions, which were not stopped. In the Inter-American Commission's resolution on the climate emergency and scope of the Inter-American obligations, the social protection adapted to climate change is specifically mentioned. I think this would be a good occasion to build on that in terms of substantive content. The ILO standards are a very good point of reference, and we also see the link through the concept of the just transition, which is linked to decent work agenda, and the decent work agenda includes social protection. So the argument is that yes, obligations in climate emergency, including mitigation and adaptation, should include specific social protection measures.
Muchas gracias. Y
Thank you very much. A second question to the representative of the International Lawyers Assisting Workers. Since you are here, and the view your association has, or a worldwide membership you have regarding workers' associations, how do you see the challenge of truly having freedom of association and trade unions in connection with climate change in this transition that you have referred to? Because if you could please elaborate, what particular risks additional to those already they already face for freedom of association and trade unions in the specific context of climate change. Additionally.
Thank you very much for this question. As we presented, indeed, the problem which we see is that the barriers to freedom of association and collective bargaining, they present themselves in the context of climate change as barriers to human rights defenders. We would very much like the progressive understanding that freedom of association and collective bargaining violations impede workers to play their role as labor, environmental, human rights defenders. And the barriers include non-recognition of climate strikes, non-recognition of trade unions as agents in the collective bargaining on climate issues, but it also includes retaliation that links retaliation against trade unionists, also in their role as when they try to bargain over environmental issues. I would give two examples. One is Colombia, where we have problems of violence against activists, including trade union leaders. We have lists of trade union leaders killed, and also in Colombia, the trade unions are not given any space to legally negotiate over environmental emergencies. Another example, it's linked with Brazil and the very famous collapse of the Fundão Dam, which was called the worst environmental disaster in Brazil. It was the collapse of a dam linked to ore mining that resulted in the spillover of I have numbers somewhere, but like 40,000 cubic meters of toxic waste, which killed the whole villages, killed 18 people, affected businesses, affected municipalities, and so on. The thing was that in this particular, this dam was operated by the multinational and by the subsidiary. The unions were not recognized for years. They were not recognized because the workers were subcontracted or they were not employees. So there were many precarious forms of employment, and the employer's argument was that these workers cannot be represented by the unions. Had there was social dialogue in this company, this disaster, in our view, was really preventable. But there was no discussion, no opportunity to represent workers, to talk about their exposure. They were victims of killings in this disaster, as well as almost 100, like 87 of workers were present during the dam, and they are still not compensated. They are still not, while being affected in their health, they are still not compensated. I think this gives one example where the problems and non-recognition of trade unions to represent the workforce affects the action against environmental degradation, and the same is in the climate change.
Muchísimas gracias. No tengo más preguntas.
Thank you very much. No more questions.
Thank you. Judge Veronica Gomez, do you have any questions? Yes, Madam President.
Jacob Coppes, you were talking about the assessments, and we've been talking a lot about that, about assessments, information, etc., etc. And you gave Earth Justice gave a roadmap, in writing, about with lots of standards, which are very useful indeed. But which are the good practices that we've seen? Because one thing is to talk about the standards in the abstract. Could you provide some examples of good practices in application of these standards so that we can see them working in practice? And how many are they? Do we have examples of good practices in these climate assessments?
Thank you very much, Your Honor, for this question. There are good examples of best practices out there, and we point to several standards, as noted in our brief, in our submission. And these are really based upon some of the relevant national standards that are emerging on how to do proper climate assessments. I think some of the best ones have come out of the European Commission has standards on how to do life cycle emission assessments. And the U.S. Environmental Protection Agency also has some good examples of guidelines on how to do proper life cycle assessments. And I think these are like the best practice that is available out there, really doing an assessment of not just what is the specific impact of the activity itself, but what is the cradle to the grave analysis of what are you actually contributing to climate change pollution, which includes upstream, downstream.
Yes, that was clear. You were very clear and it's very clear in the report as well, in the written report. You mentioned agencies in Europe and the United States. The type of assessments they do, are they transnational in nature? They take into account all of the transboundary impacts? They recommend as best practices to incorporate those. For example, the U.S. Department of Energy is recently redoing one of its prior analysis on the export of LNG, liquid natural gas, and the climate impacts of that industry. And so it's currently in the process of actually reanalyzing, and it's looked at the prior analysis did not properly account for the amount of leak emissions within production upstream before the gas gets from the gas fields to the LNG facility, and also the transportation of the LNG abroad and the eventual burning of the LNG. And so they're re-evaluating this, and this is hopefully will be a good best practice to do a better analysis that includes the latest science, the best available science on what is the actual leakage rates from this whole process. Because as prior panels, they noted the big impact of using methane fossil gas is not necessarily directly burning it, but actually the leakage all across the process. And they found that this leakage rate, and more studies are coming out to saying the leakage rate is higher, and hopefully as a result of this process, it will come up maybe later this year, earlier next year. There'll be another study looking at the entire life cycle chain and providing figures that other companies can then use to estimate their impact. Who does the assessment? I mean, you mentioned state agency. Who should do, ideally, the assessment?
Ideally, the assessment should be done by an independent authority. Many countries, such as countries in Latin America, have the assessment is done in two parts, usually done by an independent consultant that a company hires on. And then there's another assessment where the government agency, the environmental regulators, have to double check everything and do their own proper assessment, looking upon what the numbers and evidence provided. So the independence, both from either external consultants, but most reliably from a state agency, is really the key here.
Mm-hmm. Do they tend to be people that are from the industry?
Unfortunately, the independent consultants are from the industry, and this is probably one of the problems with the independent consultant model. And so that's the real need is for, and I mentioned just the state regulator to be taking seriously its job of undergoing this analysis, but also to reiterate in part of the court's jurisprudence the importance of public participation in these processes. Making sure that there is notice to the public that these new projects are going forward, access to the actual impact assessment studies, and hopefully summaries that provide that information in a form of language that is intelligible to the general public and not too technical, and making sure there's an adequate comment period and that those comments are then incorporated by the environmental authority into their assessment.
You realize that there are usually lots of questions of transparency and how the independent, person doing the assessment is selected? There's a whole line of questioning on that. The last one on this topic, how much does it cost?
So the costs of these, they're not free, obviously.
Obviously.
They have costs, but they're all within, they're within the reach of most governments in the world that have already set up these institutions. This is not, we're not asking for a new climate assessment institution from the government. The existing regulatory agencies, the existing environmental authorities already have processes in place, already have teams of technicians that review these types of impacts. And it's just a matter of adding additional guidance and amplifying the look to not just focus on localized environmental impacts, but also the climate impact assessment.
Mm-hmm.
And there's tools produced by says US EPA and European Union authorities that provide a lot of guidance and a summary of the best available science that many countries can rely upon.
Thank you very much. Estas eran muchas de las propuestas.
This is one of the concerns of Mr. Gonzalez Chavez also in his presentation.
Ms. Toni Moore, and I don't know whether you're Susana or Monica. She's Susana? Susana, yeah. Sorry, it was confusing because it was two different organizations. This is a really important presentation. So the first question is, what is the role of the ILO in all of this? I mean, we know that the ILO has been really good internally working all of the new themes, the new topics, automatization, artificial intelligence, and climate change on its own. But is it connected with the international dialogue, the dialogue of the international community in general, COP meetings, anything, on these issues?
If I have to make a very honest assessment, I would say not sufficiently. But what I would say is that the ILO has done tremendous work, for instance, on just transition. In fact, very instrumental in developing, seeing the development of the Just Transition Principles and Guidelines of 2015. And just last year at its 111th International Labour Conference, there was actually a technical committee that focused specifically on just transition. And I was pleased to be able to lead that committee on behalf of the workers group of the ILO. And coming out of the recommendations that were offered by the committee is a greater role, a greater voice externally, because you recognize that internally we are doing good stuff, but externally to have its voice being heard in those discussions that will take place, as you said, at COP immediately after the ILO last year, International Labour Conference. There was a big meeting in Paris to look at the issue of financing again. And we were challenging the International Labour Organization, the workers group at least, was challenging the International Labour Organization that it has to be able to comment on issues of finance as well. It has to be able to speak to the need for reparations. It has to be able to speak up on the fact that occupational safety and health is a major threat and recently accepted within the ILO as a fundamental right, but compromised sufficiently by the climate emergency that its voice must be heard. It has to be able to speak on industrial policy and issues of insurance and weather insurance versus other forms. So especially as it relates to social protection. So short answer?
Yes.
The ILO, the ILO is doing good base work, but so that questions like this will not have to come. The evidence of its work in external discussions, feeding into external discussions, must be seen.
Thank you very much for the answer. The other question is, both of you referred to heat. What about the impact of weather events? You know, big weather, apart from heat, because heat is one side of the story. But then we have sea level rising, weather events, extreme weather events, and I imagine those have also an impact on workers.
Extreme weather events.
Extreme weather events.
In this 166 square miles that I live in, we are experiencing extreme weather events. For the past few weeks, for instance, one would go outside and think that rain was threatening, but it is not the clouds that form that shadow on the outside. It's actually the Saharan dust.
Yes, we saw it yesterday.
And yeah, you saw it. Some people have been saying that they can smell it. Some say they can even taste it. So it's having significant effects on sinuses and related issues for workers, which impacts attendance at work, which impacts productivity at work, which impacts a whole number of things. Extreme weather patterns mean that to countries like ours, as a child growing up, we used to have an expectation that hurricane season would be concentrated really between August and October. But now we can experience hurricane seasons as early as May, and it can extend as far as January, where we had hurricane activity being experienced and so on. So while we mentioned heat, it is just because the limitations of a 10-minute presentation will force you to just make an example, but we recognize that hurricane patterns, weather patterns have changed, and it's cold as well. Extreme cold is also an impact in a number of countries. Of course, it wouldn't be our concern as much in most countries of the Americas, but it still is a concern in some countries of the Americas as well. And that has implications for collective bargaining. For instance, how do you dress? Not only the environmental concerns, but uniform agreements and so on. In our climate, you still see a lot of workers dressing in suits and so on, because we still have remnants of the colonial past in terms of how we must dress, when better uniforming might require us to wear shorts, dry fit materials, and so on. And then it has implications, these severe weather patterns and changes for ACs and AC air conditioning units and how you service equipment and so on. So the conditions are widespread, I'm sure.
Yes. I'm going to ask you now, and you could respond about that as well, about the situation of first responders, the working conditions for first responders, with more fires, with more extreme weather. The people that still have to go to work, and those are the first responders, and what's their situation? Because we keep on hearing about stress and people not wanting to, or quitting their jobs, those who are in the first lines of response. Do you have comments about that?
Yes, thank you very much. On the preceding questions, I would just have a couple of comments that will build on what Tony said, maybe more from the legal side as well. So on the one hand, we have the right to just, equitable and satisfactory working conditions. On the other, we have a right to healthy environment. Both these rights have a specific elements included in the jurisprudence of this court. What we see is that OSH laws at the national level, they are not ready yet to deal. They don't include climate change related risks. And an example that we gave was heat, because it presents well the problem. For instance, in the legislations, we have provisions in many jurisdictions for construction workers to leave workplaces in the case of rain, but not heat. So what we are, and the same is in agriculture. So there is a need to regulate, to regulate with these specific risks in hand. So update the legislation, and then there is also the element of right to safety, health and hygiene at work, built up by this code, which includes the right to interrupt work in case of imminent danger to life, health and safety. This comes directly from the Convention 1555, and it was in a very coherent way received by this court in the inter-American system. So this right has to be also translated into other risks that you mentioned and all the risks that are related to climate change. And the other thing is also the obligation to supervise, which is included in the right to a healthy environment. So we need labor protection to control workplaces and be updated on the powers and knowledge on these new risks. And just to mention two cases from the Inter-American system. So both Oroya case and fireworks. There was a case, the fireworks Brazil fireworks factory case from Brazil, where child laborers died in the accident in the factory, which was felt that the state really violated its obligation to supervise, because there was no the risks could have been known and the laws were not implemented through supervision. On the first respondents, I will just mention the also quite recent recommendation from the ILO. It's a recommendation from 2017, recommendation number 205, which talks about decent work and employment for peace and resilience. And there is a specific provision on the first responders. We can send it to the court for the specific reference. But this whole instrument is quite interesting, because it talks about the potential of employment creation and decent work to improve not only prevention and addressing crises that originate from conflicts and disasters, so climate change is fully included, and also to build resilience for the future crisis. So this is an, I think, quite important source of legal reference for the code, and we can send the specific reference and citation.
Thank you very much. Gracias, señora Presidenta.
Muchas gracias, Jueza Gómez. Juez.
Thank you, Judge Gomez. Judge Ferrer McGregor? Yes, Madam President, I will try to be concrete in view of the hour, the lateness of the hour. First of all, there's a matter here that I find alarming or worrisome. It has to do with the two interventions, one by a workers' organization and the other by the attorneys who represent workers, who work with workers. Mainly having to do with the reality here in our part of the world, and a reality in the world of work in general, where informal employment is so much more common than formal employment. So what types of protections can workers have in the face of climate change when they are informal workers? They are not registered, and for this reason they have no union representation to protect them or defend them. Anyone who wants to answer that question is welcome to do so.
I can advocating for workers in the informal sector being able to have the right to freedom of association and collective bargaining. It's not as straightforward as it is for workers in the formal economy, but even where they do not have direct access to trade unions. What we have been saying, and it relates to the question for a region, for instance, that is exposed to extreme weather patterns and so on, you don't need for workers to be specifically unionized to be able to speak to them if most representative trade unions can get to the table. And that's where the importance of social dialogue at the tripartite level comes into play, where government hears from business and it hears from workers' representatives as to those ideas that can be generated to protect workers. There are 3 Ps that trade unions are concerned with. Planning, that is to the best extent possible where we can anticipate where problems will occur and address recommendations to remedy them. Participation, where we will be allowed at the table to be able to speak to issues as we anticipate them to protect workers. And poverty alleviation, where our focus is on ensuring that we leave no one behind, and that includes workers in the informal economy, so that we are not seen or should not be perceived only as a voice for those people who are union members, although ideally we want to get them there, so that incidents like what Susanna mentioned that took place in the factory, where we could have identified the risks, the specific risks that workers in those situations face, we could deal with them. But at the national level, there is a space for trade unions at the regional level, like what TUCA provides for workers, and at the international workers, we have voice to impact meaningful change for workers.
Anything you would like to add? Anything you would like to add? Please go ahead.
Thank you very much. I'll add a couple of points. So, indeed, informal workers, they are invisible to the system. They are deprived of any labor protection, social protection, or collective representation. A short answer would be to allow workers to recognize trade unions for the purpose of representation of informal workers who are informal. They might not be legally recognized as members, but the trade unions should, or other organizations should be recognized as partners. We have examples, for instance, it's not on informal sector, but on irregular migrant workers. In the UK, the unions can represent them. They can talk to the employers or to the governments, even though these are irregular migrants. They are not regularly, legally in the territory, but the system allows trade unions to bring their points to the table. Social protection, which the informal workers are deprived, it builds resilience for the crisis, and including climate change. Safe jobs that they also don't have access to, support livelihoods. And again, migrant workers are overrepresented. Migrant workers are overrepresented among informal in the informal sector, where the migration is often a survival strategy in the context of climate change. So in our view, the solution is collective representation. And I would just flag that we have another growing problem, and this is lack of recognition of trade unions to represent non-standard workers, specifically self-employed workers, where, for instance, platform economy is often seen as a part of response to climate change, including in the renewable energy sector. But workers who are self-employed in the majority of jurisdictions, they cannot accede trade unions, and they cannot be represented by them. And this is also the problem when we're talking about the exclusion from representation and the massive exclusion from all labor rights. Thank you.
Thank you very much for your answers. I think that we need to note that in the entire region, if you look from the perspective of the North, or the examples of UK, for example, with the migrants. That's very enlightening. But when you talk about really harsh informal labor situations in Latin America, there are other causes. It's a response to other factors. And the first thing that's being questioned right now is whether or not they have a decent remunerated work. I find that there we have serious difficulty with incorporating this group of people, and the pandemic made it worse. There was more informal work during the pandemic, and we saw how vulnerable people are when they work informally. The pandemic shed clear light on it. It's just a comment that I was interested in hearing. I think your answer is absolutely reasonable, which is from the standpoint of the labor unions and the representation you give. Ideally, everyone could be a member of a union and would be able to defend their rights. We gave an advisory opinion on trade union freedoms and the collective bargaining and representation of women, and the idea was to strengthen unions. But I find that perhaps in determining vulnerability to climate change or the climate emergency, the informal workers are a new form of vulnerability. This is what I wanted to say. Thank you so much. I have no more questions.
Thank you, Judge Perez Manrique. Judge Ferrer McGregor, will you ask questions? Yes. Thank you. To the International Trade Union Confederation. And continuing on with the dialogue of a just transition, you've mentioned forms of modern slavery. Could you please elaborate how they are related with these impacts, considering the climate emergency?
Thank you very much for this question. We wanted to cover in our submission the impact of climate change and climate response on fundamental principles and rights at work. We don't see that. We see it's a bit of a point in the debate over climate change obligations that it's not covered. Our point is that climate change disasters already push millions of people into poverty, and these victims of climate emergency, as we see them, are more vulnerable to forms of severe labor exploitation. Modern slavery is not a legal. It's not a legal concept. It's more academic concept. But basically, it refers, among others, to forced or compulsory labor, trafficking for labor exploitation, child trafficking. We see these severe forms of labor exploitation in the current economy, including in the environmentally degrading industries. So those industries that are very much responsible for climate change, they are riddled with severe labor exploitation, including modern slavery. But what we also see as a worrying evidence from the ground is that and Tony covered that in her presentation, that the industries that are necessary for our transition, including renewable energy industry, they have identified cases of modern slavery, forced labor in their supply chains, at least in their supply chains. So in the mining, processing, manufacturing of critical minerals, for instance, in cobalt mines in Congo, we find child labor. We find people in situations where they don't have, in the situations that meet the threshold of the definition of forced labor, and other situations of severe labor exploitation. So climate change and violations and modern slavery, climate change and modern slavery are in some kind of a vicious circle when one reinforces the other. And I think maybe over, like the cutting concept would be that we will not have jobs on a dead planet. This is what trade union movement is saying. There will be no jobs on the dead planet. That's why we need to be part of the solution. But modern slavery in green economy is also not it's not something that anybody on the progressive side wants to see. So I think I hope I answered your question, but I can also elaborate if it's needed. Thank you very much.
Sí, muchas.
Thank you. In the context of a just transition also, do you know any success cases of labor reconversion, anything to show or contribute to the climate emergency? So what steps have been taken? Do you know of any positive examples or good practices of labor reconversion, of the transformation that is necessary for the just transition to occur? Or is it something that is just being thought of, or is it happening because we are dealing with an emergency? So immediate steps should be taken. So the question is, are there any success cases, good practices, examples?
So that I'll start and maybe, yeah. The question which comes, the answer that comes to my head is the example from Australia, when Australian trade unions are very much supporting the government's plans of mitigation and adaptation and transition. They are in dialogue. They made a report in which they tried to evaluate the quality of jobs in the renewable sectors, and they did find that where trade unions were on board, the result was safe and safe jobs in renewable energy sector connected with retraining, with the rights. This was really a good example of transition from the jobs in the non-clean energy, which often are still jobs of good quality. This is the trade-off for the workers, that they have to part of the jobs in the fossil fuels sector, for instance, are jobs with rights. So the good example in our view is where the job creation in the green economy, green energy sector, these are jobs with rights, and we have many examples of such transition, and the participation of the unions in the mitigation and adaptation decision making and plans is in our view the crucial element. So I would point to that. Tony, I think you might add to what I said.
Not to point to a direct case example, but to answer on the component of your question that related to best practice or the practices. And what we have advocated significantly on would be for retraining and retooling and reskilling opportunities, because as we look to transition to a low carbon economy and as jobs change, what is very often likely to be the impact is displacement of workers, and as a first response. And what the trade union movement advocates for is the retraining and the reskilling and the retooling of workers, especially preparing them for the opportunities that are available out there as it relates to green jobs. So that's what a lot of our focus in the transition has been on.
Thank you very much.
Gracias, juez Ferrer. Me indique la jueza Pérez Goldberg.
Thank you, Judge Ferrer. Judge Perez Goldberg would like to ask another question. Actually, it's not a question. I just wanted to take this opportunity to thank for the silent work that is being done always, but especially in these advisory opinions where we receive so many expert opinions, to the personnel of the Secretariat, and the registrar and then deputy registrar, but especially Natalia Castro and Natalia Oviedo, who have worked so hard, relentlessly to attain what we have attained. Thank you, and I'd like to echo your words of thanks and congratulations on behalf of this court. We have no further questions, and we have concluded the list of speakers planned for this public hearing. As established in the order of February 22, 2024, this advisory proceedings will continue in Brazil, with a second hearing in the city of Brasilia on May 24th, and another in the city of Manaus between May 27 and 29. About 116 delegations will participate in these hearings, so we still have a great deal of work ahead of us. Before adjourning, I would like, on behalf of the court, to once again thank the authorities of Barbados for their invitation to hold our 166th regular session of the court in their country. We also reiterate our appreciation to the University of the West Indies for providing us with its facilities to host our session and the seminar on the impact and challenges of international human rights law. I would also like to thank the participating states, especially the states of Chile and Colombia, the Inter-American Commission, and the numerous non-governmental organizations, academic institutions, and individuals and civil society organizations for their valuable contributions and participation in this public hearing. Without a doubt, the richness and the wealth and diversity of the arguments presented have contributed significantly to our work in this very significant advisory opinion, and demonstrate the great importance and complexity of the subject matter at hand submitted to the court by the petitioning states. As you know, the court has a specific mandate regarding advisory opinions regulated in Article 64 of the American Convention and Article 70 through 75 of the court's rules of procedures. This mandate imposes a great deal of responsibility on us, but at the same time it sets a framework for action that we must respect and not exceed. We will approach our responsibilities within that framework with all seriousness. Thank you. This session is adjourned. Enjoy the rest of your evening. All rise. The court shall exit.